Right. Roll the record now in Gillett versus Philip Michael, is it ERAVI? ERAVI. Case number 24DN17. Counsel state their appearances, please.
May it please the court, Joe Gillett, plaintiff, appears in person.
Your Honor, Lisa Becker appearing on behalf of the respondent, Mr. ERAVI, who appears in person.
Permission to remain seated, Your Honor, to remain on the record so the microphones may pick us up.
I'll give that to both counsel. Oftentimes, it's preferable with questioning and so forth from the podium. Clearly, the defendant has counsel. Ms. Gillett, you're aware that you have the right to counsel, correct?
Yes, I'm aware I'm a right to outside counsel.
And you're waiving that right?
Yes, sir.
All right, we are here today for trial on the petition. Record is being made. Is anybody trying to make a record or recording? That is not allowed unless there's been prior authorization through the chief judge. Okay, nobody indicating that's happening. Are there any preliminary matters before we begin with trial?
None from the plaintiff, Your Honor.
Judge, there's a couple of issues. I think Ms. Gillett plans on testifying from the table. I think she should testify from the witness box and without, if she's going to bring electronical things up, like a witness, if a witness brings things up that she's testifying to, I'm allowed to see those things. So I think she should testify from the witness box without her computer and the electronic things. Anything she brings up with her is free game, I think, for counsel to look at. Just like any witness comes up and brings notes or things going to refer to it, I'm entitled to see those things. So that part, I also have I've asked for the witness exclusion rule, which you have 3 deputy sheriffs were subpoenaed to testify. I think they should be excluded. Dr. Justin Spies is a witness. He should be excluded. That's all I have to.
Are all witnesses present now? No, not a show of hands. I'm asking the parties if all the witnesses are present. So if I give the warning, then any objection by the plaintiff to the sequestration order?
No, Your Honor.
All right. If you have been identified as a witness in this case, once we get started, you're going to be excluded from the courtroom. You'll need to not discuss your testimony with anyone other than the attorneys for the parties. Once you have given your testimony, you'll be released by the court. If for some reason you're not released, I'll advise you of that as well. So we'll do that here in a moment. All right. Ms. Gillett, in regards to testifying, did you have a response?
Oh, well, Judge, when I go to testify, I'll be up there, but all the videos will come in through witnesses.
All right. Well, if there's a witness that has reports, written reports and so forth, they may take those up there. I don't want people just reading from them. But if it refresh their recollection as to dates and so forth, then witnesses can do that. In the event that, I don't know, this doesn't happen very often, if somebody has some sort of electronic device that they're looking at their notes from that becomes a little bit more difficult. So if it can be avoided, I would ask that the witnesses avoid that. But all testimony I'll take from the stand unless there's some other compelling reason not to.
For the record, Your Honor, I think that defense is just making assumptions of how I'm going to testify.
Well, we'll All right. Now, I have Mr. Baker's entry of appearance to the petition. I did not see an answer. Is that correct, Mr. Baker?
That is true, Judge. We, at the close, we plan on filing a motion to dismiss, but that's correct.
All right. Are there any items that can be stipulated to or at this time in regards to exhibits for either party?
Are you stipulating to the emails coming in?
Yes, I can stipulate to those.
We'll deal with them as they come up then. I just wanted to, if there's things that we can streamline, I would ask that we do that without being prejudicial to the case, of course.
Do you want me to lay those on the evidence table, Your Honor?
I have them. I mean, I've got, it's not necessary.
All right. In regards to exhibits, I want them marked as, and if it's a document, a printed version of it, and it can be referred to. If there's copies for counsel of the court, that'd be fine at the time of the exhibit being offered. In inquiry earlier with counsel, it's my understanding there hasn't been an exchange of some of the exhibits. However, both parties are wanting to proceed today. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Very well. I'll hear, first of all, I'd ask that the witnesses, subpoenaed witnesses, exit the courtroom till you're called in. Please stay close by. Don't want to have to go outside to find witnesses. Thank you.
Sheriff Walker will be my first, Your Honor.
All right. First of all witnesses other than the parties out of the room now. Mr. Baker, your witness is out?
Yes.
Okay, good. All right, I'll hear opening statements at this time, beginning with the plaintiff.
Judge, do you want the stipulated exhibits on the table or handed to you?
When they're actually offered as exhibits, then it'll be presented to the court. I have reviewed the petition, and there were some of these documents I believe were submitted as a part of the petition. So I may have a copy of those, but I do want to be sure that the record's clear as what's admitted. All right, so opening statement, please.
Your Honor, I want to keep my opening statements brief. I filed a petition for protection from stalking against Mr. ERAVI. Mr. ERAVI has come down to Elk County numerous times. When I'm on the docket with the commission especially, he's come down. He has followed me to my vehicle. He has recorded me live stream on YouTube. I do not access their YouTube stream. I have no care, desire, or want to access their live stream. Under the cases that involve the Phelps, there were several U.S. Supreme Court decision findings that were made in Snyder v. Phelps. One of those is they can put what they want on their media stream, on their own web pages, on what they do. I don't care to go look at it, so that doesn't matter to me. In Snyder v. Phelps, there were lots of hateful things put on social media and websites that affected the father of the fallen soldier. This is not the case. I have filed this based on physical interaction with me, which is one of the events. I have filed this based on him prying into my personal life that is outside my jurisdiction as a prosecutor. There are different levels of scrutiny for elected officials. County attorneys in small local counties are a lot different than, say, President Trump or President Biden. And there's a different level in what is elected officials. And though I am an elected official in 2 small rural counties, I am not a national media person. I am not the president. I'm not the governor. I'm not the attorney general of the state of Kansas. And I have some rights to privacy in my own personal life. It's obvious that he's been trying to pry into my personal life because he's asking me about a duck that went missing in Fredonia, Kansas. So he had obviously gone and tried to obtain information that was about me personally from someone over in Fredonia, because that's not something that would be publicly known. That's not something that's been in the media, and that's not something that anyone would have access to unless they went snooping into my private life. And I have talked about that in my my petition. I, as you know, raise ducks, and I'm a well-known person to care for ducks. In fact, my Parks and Wildlife officers know that if they have a rescue that is a rare or endangered species, I would be able to rehab it. That's not something that's publicly known. But it is something that occurs because of my skills and abilities. As we move into this case, I think it will show that he has continued to message me personally. He has made statements in his emails that hint that he knows that he is passing the line, trying to justify himself, saying, I'm emailing you as an elected official. I get to email you because you're an elected official. I don't have any business with him. There's no reason for him to be following me. There's no reason I should have to wear up to my back every time I leave and come into the courthouse where I'm here to do my job. There's no reason that my family should have to fear. His followers have started making tons of threats against me. Those are his followers and not his actual actions. But his actions have ramped up to the point that he caused physical contact with me. I had prepared the petition after the physical contact, but waited to see if he calmed down, dissipated, had any reason to leave. But the behavior has not. And after every single hearing, he emails me. Anytime he gets a whim, he starts emailing me. And this was filed after the last email, which was October 30th of 2024. It is the continuing desire to have contact with me. As a county attorney, and previously as a guardian ad litem and a defense attorney, I'm trained to keep my composure in a courtroom or wherever I may be to try to stay calm. Although I may appear calm on the outside, that does not always mean that I don't have a fear on the inside. I don't show it the same as other individuals because I'm trained. Attorneys are trained to do that. It doesn't mean that I don't have a fear that they could come over to my town, or they could follow me outside of the courthouse further, cause problems for my personal life, and there's no reason for this to continue to occur. There's no reason for him to be emailing me. None of it has to do with business. It's just literal rants and craziness. There's no necessary reason for it. The calmer I stay, the more he amps up. They like drama on their YouTube channel and try to make it where it's not. There have been untrue statements about me posted, both by the defendant in the criminal case that he's following, and by him by repeating things that that individual has said. So there's no reason for them to be prying into my personal life, following me to my car, causing physical contact with me through the door. And frankly, I don't want him within 30 feet of me, 50 feet of me. I've had to hire private security because I've had numerous followers threaten me. He's now caused physical contact with me, and that's an extra expense that has cost me. And at the jury trial, he ran towards me after I had filed this case and ran up behind me. I don't know if he was hoping my security would tackle him or something more would happen, but he literally approached me during the jury trial after he had noticed this case was pending and ran up behind me. My security is here to testify about that. And so then he didn't move. I moved on to my office, and he had to be removed and nudged out of the way by security because he was standing outside the judge's chambers out here in the hallway. So there's no reason for all of this and for him to be contacting me personally.
Thank you. Mr. Baker?
Thank you, Judge. Judge, the analysis that you have is constrained by KSA 6031A02. And you didn't hear in the opening statement anything about contacting commissioners and this county prosecutor not being a legitimate purpose and not constitutionally protected. That is one of the elements. And in fact, when you see these emails, they're all sent to the commissioners about county business. They're sent to the prosecutor at her official email address, talking about, in fact, she says that he can't even make Cora requests. That somehow that's not a legitimate purpose or constitutionally protected. She says she'll admit she's a public figure. And Kansas, there's a case, Cindy Baker v. John A. Regan. It's not published in 2018. The district court was reversed in that case of granting a protective order against a parent of a child. And the court said that the parent had a legitimate reason, even though the other parent didn't like it. Now, Kansas doesn't have any case law on public figures. It's a public figure trying to get a protective order. And there's a reason for that, because you just can't get it. I will cite to you in our motion to dismiss, I'll file after the presentation, they did deal with a public figure. They have an identical statute. And in that case, it was a state senator who filed a protective order against a person. Same allegations, I don't like it. And the Florida court said because Petitioner is a public figure and not a private citizen seeking quiet contentment while going about her day-to-day life, the calculus about what constitutes harassment, credible threats, or even defamation against her is different. So that they say, look, the injunction process is not intended for use in punishing mere offensive incivility, which is what she's saying. I don't like the words he uses, or statements that in isolation may appear far more menacing than when considered in their true context. Say it's not to silence political opponents. And they go on. Though the words may be based, insulting at times, it's pure political and protected speech deserving of the broadest possible First Amendment protections. The court there reversed the district court. You're not going to see anything, and this is a citizen journalist, you'll not hear any evidence that what he did was not for a legitimate purpose. These buildings are open to the public. There is no law against videotaping public people in public places. There is no law that says that media cannot be in the hallway or in a courtroom. There is no law that says that just because she doesn't like the media asking her questions, and even if she says no comment, that doesn't mean the media has to stop asking her questions. They don't get a free pass on that. And so you'll not hear any evidence today that says that anything he did was not for a legitimate purpose or for was not constitutionally protected speech. She'll not bring you any evidence today that said he ever physically said the words I threatened to her. Nothing. And she'll conjure up all these things about what others have said. She speculates. She can't get it on hand. She says, well, you gave me bad publicity and others have threatened me. Well, where are they? Why hasn't she sued them? Instead, you'll hear evidence and she just makes it up. And the duck thing you hear, the duck was about a duck that got stolen from a neighbor. She's a public figure. So it is in the public interest to know if the police showed up at your house, or the police said, hey, you gotta give that gun back to the neighbor. That's something of public interest. That's what the public should know about that. And she can be asked questions about that. She's not immune. So you'll hear all this evidence. You'll not hear anything that meets the elements of this statute today. Thank you, Judge.
Thank you. Ms. Gillett, your first witness.
We'll be calling Sheriff John Walker.
Have Sheriff Walker in, please. You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Do.
Thank you. You're under oath. Please have a seat. Counsel, when he's settled in, you may begin.
May I approach the remote, Your Honor?
Remote? Yes.
Could you please state your name for the record?
John Walker,
And how are you employed?
Sheriff of Elk County.
And how long have you been so employed?
4 years as sheriff and 12 years total in Elk County.
And how long have you been in law enforcement?
Going on 18 years.
And have you had the opportunity to be investigating some of the issues regarding Mr. ERAVI?
Yes.
And over that time period, have there been investigations that have to do with contact with officials, contact with staff in the courthouse?
Objection, Your Honor, is irrelevant. It has nothing to do with this plaintiff. What he may have done with others has nothing to do with any contact or course of conduct with this plaintiff. So it's not relevant.
Ms. Gillett?
It's relevant as to how he obtains the videos or has been long-term conducting the investigations to obtain evidence in these cases.
Still irrelevant. There's not, he wants to bring up some sort of thing that he may be a bad actor, he's done these things in the past. Irrelevant. He has to prove her case.
It's laying foundation for the evidence, Your Honor.
I'm going to give you a limited amount, but it does, we need to tie it in pretty quick to this petition.
I think that defense keeps making assumptions that things are going in a
I'm
different
not asking you
direction.
to comment on his objection. I want you to ask the question.
Have you been conducting investigations that involve Mr. ERAVI?
Yes.
And do some of those include investigations that require you to download or keep a hold of videos?
Yes.
And are you the video custodian for your office?
Yes.
And do you control the courthouse security cameras?
Yes.
Do you control the body camera system?
Yes.
Okay. So if there are videos that are saved in the system, then you would have access to those?
Yes.
And if investigations needed to be done into a specific issue, then do you go online and research video as well?
Yes.
All right. And did you download and investigate video from July 29th, 2024?
Yes.
And can you tell us briefly what occurred that day back in July?
I believe that was the incident where we was in the commissioners meeting and they followed you up to the top of the stairs and then later out to your vehicle.
Object, Lord, object. He has no personal knowledge of that. He did not personally observe that. So
That can be discussed on cross-examination. Objection overruled.
Now, during that incident, did you send a deputy to walk with me?
Yes.
And which deputy did you send to walk with me?
Deputy Love.
And did we have an executive session that day with the commission?
Yes.
And you and I were invited to that.
Correct.
And that was for courthouse security purposes.
Correct.
All right. And at the conclusion of the executive session, was it suggested that I leave the courthouse?
Object is hearsay and leading.
Sustained.
Was there any suggestions made to me at the conclusion of the executive session?
Still leading.
Overruled.
Yes.
And what was the suggestion made to me?
Hearsay. Objection is hearsay.
Sheriff Walker is one of them who made the suggestion to me.
Hold on. Is this the witness that was he making the suggestion or somebody else that he observed? What's the question?
He was in the room with the commissioners and I and himself when he recommended that I leave the courthouse for my own security.
Recommended?
Yes. And the commissioners concurred with him.
Overruled. Now,
Okay.
he can answer as to what he stated.
And Sheriff, did you make a suggestion to me at the end of the meeting?
Yes, that you probably should be watched really close and try to have somebody with you at all times.
And did you suggest I leave the courthouse?
Yes.
And was that for my own safety?
Yes.
And do you have fear that something could happen to me?
Do what now?
Do you have fear that something could happen to me?
Yes.
Object is irrelevant as whether he has.
Well, he answered the question, so please proceed.
And do you often make sure I have security with me?
Yes.
And any time that I have to be in a public corridor with the defendant present, do I have security provided by you?
As often as we can, yes.
How many deputies do you have?
Right now, I have 2 deputies, my undersheriff and myself.
And
2
some,
part-times.
and are there times where you need extra resources?
Yes.
And is putting a single deputy on me for court difficult?
Yes, at times.
Judge, it's irrelevant.
Sustained.
So, am I able to get personal security for events?
Yes,
Right. And does that help free up your deputies?
it does.
Now, do you continue to have a fear that something could happen to me?
It's irrelevant.
It is relevant.
Now, hold on. Why is it relevant that he has fears for you? Isn't the test if you have fears as plaintiff?
Correct. And if my sheriff has a concern about my safety, then that would up my concern even more. And when I testify, that's going to be one of the things I testify about.
Judge,
I'm going to sustain the objection.
Now, Sheriff, on the July 29th, 2024, was that video, were there videos captured that day?
Yes,
And was that through Deputy Love?
yes,
And so he would be the person to talk to about the video of his body camera.
yeah, of his body cam, yes.
Now, did you download the live stream of Mr. ERAVI from that day?
Yes, we ran it off.
And is it a true and correct depiction of how you recorded it?
Yes,
Have there been any changes or corrections made to it?
not to my knowledge.
Your Honor, we're going to move to admit the video of Mr. ERAVI's live stream.
What is the exhibit number?
It is exhibit number 9.
Mr. Baker?
It's not Mr. Walker's body cam, it's someone else's body cam.
No, this is the download or the videoing of Mr. ERAVI's live stream on the on his YouTube channel. It's going to be our interactions after the executive session.
He can't authenticate that. Judge, he didn't make it. It would be hearsay to him. He's not the one that took the video. He has no knowledge about the authenticity of that. So I object.
Okay, Ms. Gillett, did this witness view what occurred that's purported to be on the video?
Yes, Your Honor.
Is he going to be able to verify that this was a true and accurate depiction of what occurred at what he was to see?
It would be a true and accurate depiction of what they have screened from Mr. ERAVI's live stream.
Well, there'd have to be other foundation in that regard. Now, if a witness sees something happen and the video is presented, and the witness can identify, yes, this is what occurred, it's not altered or so forth, that's one thing. If it's something that's on the internet, there's going to need to be, where the witness can't identify that would need to be, have foundation laid, additional foundation.
All right, we'll skip over that one, Your Honor, and we will, we'll move on. All right. Now, okay. Now, was there video captured on body cam of Mr. Spies and Mr. ERAVI during the trial the other day?
Yes.
All right. And did they end up moving down towards the judge's chambers?
Yes.
And was I located down there?
In the judge's chambers, I believe.
And did they end up moving towards me?
I know I can testify that they were down by the judge's chamber door.
Can we have a date that we're talking about, the trial the other day?
Okay. Now, which trial was this set for?
That was set for Mr. Walker. I believe, without looking at my phone, I believe that was on the 6th of November.
And were you running security that day?
I was.
Okay. And was many of the other deputies there running security?
Yes.
And whose body cam is this one?
Deputy Signer's.
Okay. And can you verify it's a true and accurate depiction of the day?
Yes.
And you maintain the logs of the body cameras?
Yes.
Has there been any modifications, corrections, or changes to that body camera?
Not to my knowledge.
All right. It's correct as far as your system is concerned?
Yes.
All right. Your Honor, we'd like to play that body camera.
What is the exhibit number?
That will be exhibit number 11.
Object, Judge. She does not list anything as a November 6th event in her petition. The latest date she cites is October 30th. So that, I'll go ahead and finish. So that the events that she claims, she's claimed 9 events, none of which involve a November 6th, something that happened. It would be completely irrelevant.
Your Honor, this is a continued pattern of behavior that would be another incident that's happened since the petition was filed.
Well, that's going to be admitted because, yes, if there's continued violations or abuses even after the petition, that's subject to, may be admitted. So I'm going to allow that. So Exhibit 11, I'll view it. And then make, if the witness can identify that as what's occurred and so forth, then. And
Is this
we'll look-
the video, Sheriff?
Yes.
And is that you in the video?
Yes.
And you're having interactions with Mr. Spies?
Yes.
And was Mr. ERAVI also present?
Yes.
All right. Your Honor, we'd like to watched the body camera of the,
All right, I'd ask that you identify who is who.
Sheriff, which one are you?
One in the black vest,
And who is it you're speaking with?
the defendant's partner that's outside.
Okay. Is that Mr. Spees?
Yes, I believe.
All right, and then we'll see Mr. ERAVI approach here in just a moment.
He's down at so when I came in, I came up the north staircase, and he was standing by the judge's chamber, stating that a Greenwood officer had put his hands on him to try to move him away from the door at the judge's chamber, so that's how I know he was there.
Okay. So this would show where he was in relation to when he came down and approached me?
Yes, I don't know if all of that got caught, but it's, just the clip that we had from that day from her body cam.
Okay. All right. We're going to hit play now, Your Honor.
Well, you said you'd play the whole thing. You were starting in the middle.
Right, we're starting where they actually had Sheriff Walker came up.
Well,
Can that be identified? Is there a counter or something on the video?
There is up in the top corner, Your Honor. The counter says 9/12/21.
Does it give a time? 9:12 is the time,
Yes, that's the time.
not the date? Okay,
And the date is 11/6/24 in the top right-hand corner.
I'll permit it.
can we have the whole thing play? I don't know what's on it, so I don't know what
Well,
led up to this.
She can, okay, if the exhibit is admitted, then if you wish to play the whole video, then you can. But she may proceed.
Let the record reflect, I can't hear anything. There's no audio.
There was no audio.
But I don't have any audio either, Your Honor.
You need to
See the light.
you need to come over and
And while we're watching this, who is that Mr. Spees is talking to? Sheriff, who is that Mr. Spees is talking to down at the end of the hallway?
Objectives
it was a
leading.
Greenwood County deputy.
Objectives leading.
There's nothing leading in who's he talking.
Overruled.
Talking? Can you tell if he's talking?
All right. And so that's the location and area that he had gone to from the main hallway.
Objectives leading.
That's where he was.
No, I'm going to sustain. I'm not sure it's leading so much as, I don't know who you're referring to. You say he. Please identify
I'll withdraw the
who these
question.
people are.
I'll withdraw the question. Had Mr. ERAVI been in the main hallway?
Yes.
And then did he rush down towards the judge's chambers?
Objectives leading.
Sustained. The video shall speak for itself, so I don't need characterization as evidence.
This was Mr. Spees walking down the hallway. Did Mr. ERAVI go earlier?
Yes.
Okay. And did he remain down there in front of the judge's chambers?
Remain there as long as I'd left there, so,
And that was just the time period you were upstairs?
yes.
All right. Now, Are there any other videos that you have captured or were involving the courthouse cameras?
Yes, I believe there's a couple of more there.
Okay. And what is on the courthouse cameras?
One is, without going through them all, one of them is leaving the commissioners meeting, and headed upstairs, and then one of them was from, your office where you go down and go out to get in your vehicle.
And is there video on our courthouse cameras? Or is there audio?
No, no audio,
It's just video.
just video.
Okay. And are there numerous channels all going on at the same time?
Yes.
Okay. Now, which channel is the one that you designate as the staircase?
I could not tell you that. We just downloaded it.
Okay. So, how many channels are there?
Should be 4 channels.
Okay.
Judge, just as a point of order, she's got all these videos. How is she going to enter that into the record so that I can see what exhibit she's just going through this and showing?
Well, this is what I asked about before we started with the evidence. There wasn't an exchange of evidence in regards to these videos, as well as I understand you have the same situation, partially in regards to that concern. But if an exhibit is admitted and they choose to only play a portion of it, the other side is entitled to play the other on any exhibit or the entire exhibit.
Yeah, and my problem is she's just showing some videos. They're not marked. I don't, and then in the end of this, she'll say, okay, here they are.
Well,
This is,
hold on, counsel. Let's do this and get to the meat of this thing. Now, if there's videos that need to be viewed by both parties, then I'm going to take a recess and let them do it. But this piecemealing like this is going to take us forever. So we'll take a break. I want counsel to meet with each other, give them the other one access to view your exhibits so that we know what we've got. And then, it'll be a lot easier to make rulings based on the evidence if parties know what that evidence is. How much time do you anticipate this will take?
I'd say about 15 minutes.
yeah, I was going to say 15 to 30 minutes, Your Honor.
Okay, well, I'm going to call a recess. It's 11:08. We'll call a recess until 11:30. If it's still going on, take your time, do what you need to do. But I would like to get back in by 11:30 if we can. As a scheduling matter, I'd set this for 2 hours, but I don't have other hearings this afternoon. Are both parties able to proceed until we're done today?
I have sync cases starting at 1:30.
I've traveled, so yes.
All right, well, we'll try to work around what we can. Is that scheduled for the whole afternoon?
Not the whole afternoon. I have one at 1:30 and one at 2. I don't remember if I have one at 2:30.
Well, we'll deal with those as we come up with it, but I would like to get this done today. So we are in recess at this time, and that's 11:30. Check back in. All right, we're back on the record. We have the same appearances as before. Apparently the same witnesses that have been sequestered are not in the courtroom at this time. Sheriff Walker is on the stand. Counsel, where are we at with the viewing of the exhibits?
Judge, I think I only have 2 more videos, and then they have a slew of them, 2 of which I think are irrelevant.
All right. Well, if both attorneys had an opportunity to view the others' exhibits, and then they can make their objections at the time that they're brought up. So Let's proceed. I believe we're still on direct examination.
We are, Your Honor. I believe that the courthouse video is the next one that I was going to play while Sheriff Walker is still on the stand.
Please, the exhibit number.
The exhibit number is Plaintiff's 12. I'm so used to saying state. Plaintiff's 12.
All right. Any objection?
Well, it depends. There was body cam, which we don't object to, but then part of it went into the viewing of the live stream, which we would object. But I think we'll see.
Okay. We'll go ahead and then I'll hear objections as it becomes necessary.
And Sheriff, we talked before the recess about the fact that you're the maintenance, the custodian of the court security cameras.
Yes.
And is this video true and accurate depiction of what occurred on November 6th of 2024?
Yes.
All right. And you've downloaded about an hour-long section outside the courtroom that morning. Does the relevant part come up about 9:30?
I believe so.
All right. Your Honor, I'm going to skip ahead to 9:30 so we don't have to watch everyone walking in and out of the courtroom for 30 minutes.
All right. It's offered and admitted, and defense has knows that the entire video, so if they wish to play any or part of that, they may.
Yeah, I don't have it, but I've viewed it.
Viewed it. Right.
And again, Sheriff, there's no sound on these videos, is there?
There is no sound.
All right. I'm going to pause for a second. Are these still jurors going in and out, Sheriff?
I believe so. I believe they are in the courtroom at this time. Not 100% sure on that.
Okay, pause it. Counsel, I've watched 4 minutes of this. What is it that you're
At
looking?
9:35, they're gonna walk onto the screen, and then they'll be talking at the counter, and then Mr. ARAVI will be walking towards where I'm standing.
All right.
And Sharon, who are the two individuals that just walked on?
Mike and, I really don't know the other gentleman's name, really.
Okay. So, and Mike, you're referring to,
Gentleman sitting here.
and the other individual, is that the witness he brought?
Yes.
And Judge, we're stopping at 9:35:54, and we started at 9:30:54.
Very well.
All right. And I will pass this witness to the defense.
Mr. Baker?
Thanks, Judge. Sheriff Walker, is this the Walker trial that you said jurors were walking in and out of, or?
Yes, that was during the Walker trial.
And that Walker trial was open to the public?
Correct. Well,
Not the jury selection?
the jury was, but the people that wanted to watch it had to watch it down in the commissioner's room.
Okay.
On like live streaming.
All right. And there were you saw various individuals walking in. That's a public hallway, right?
Correct.
And then you saw Dr. Spies and Mr. Irvie. Was that at the clerk's window?
When I personally came
On the
upstairs.
video.
Oh, yes, video, yes.
That's all I'm asking.
Okay.
And did you ask the clerk, or did your father ask her, don't tell me what she said, but did you ask, hey, what are those two fellas doing up there at the clerk's office?
No, I did not.
Okay. And lots of people go to the clerk's office for various reasons, if you know.
Correct.
And then Ms. Gillett talked about you having some knowledge about Mr. Irvie following her, but you never saw Mr. Irvie follow Ms. Gillett, did you, personally?
No, not this instance.
Well, or even in person, did you?
I seen him follow her out of the commissioner's room, I believe one time for sure.
Okay. And that meeting that you saw was an open meeting, public
Correct.
meeting? Okay. And I didn't see Ms. Gillette on this video, did you?
I did not,
Okay. No further?
but I didn't watch the whole thing. I just copied until all the jurors were done that day.
Well, actually, you saw this whole
That's
video.
true.
Right?
Yeah.
And you never saw Ms. Gillette in any of that? did
No.
you? Okay. No further questions?
Any redirect?
No, Your Honor.
Thank you. May this witness be released?
Yes.
Yes.
All right. Sheriff, you are released from your subpoena. If he need, as he is in charge of security, if he needs to be in the courtroom, I'll permit that. Next witness, please.
Sheriff, would you send in Love?
Yeah.
Deputy, if you stop and raise your right hand, please. You swear to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. You're under oath. Counsel, when he settles, you may begin.
Would you please state your name for the record?
Joe Love.
And how are you employed?
I'm a deputy at the Elk County Sheriff's Department.
And Deputy, how long have you been a deputy?
I am starting my 7th year.
Now, you had a break in there, in between there.
Yes, ma'am.
All right, but you've been in law enforcement 7 years.
Total.
You were previously a deputy here in Elk County.
Yes, ma'am.
All right. And now that you're back here in Elk County, have you had to do investigations regarding Mr. ERAVI, the defendant in this matter?
Yes, ma'am.
Object is irrelevant. Investigations.
Well, the way that the question is somewhat vague. Is this going to relate to the petition as to something he investigated concerning the petition?
He investigated or escorted me in almost all of the
Well,
situations.
in regards to the petition, yes, that will be admissible, but saying investigation, that could take in a lot of things, so please be specific.
Now, are you able to identify him as the defendant in this matter?
Yes, ma'am.
Okay. And have you been sent by the sheriff to escort me around the courthouse?
Yes.
All right. And have you escorted me off the property on occasion?
Once.
Okay. And sometimes are you assigned to come provide security for me?
It's going to be irrelevant, but
Please proceed.
Now, are there times that I fear for my safety, that I've expressed that to you?
cause for speculation.
No, I've told him, if I've told him I'm afraid, and he's been there.
I'm going to sustain because the witness, it's not the best evidence. The witness or the person who feels that would be the best evidence. So you telling somebody else, I'm not going to allow that in.
Are there times that you fear for my safety?
Once.
And, Deputy, on September 9th, were you requested to be at the county commission meeting for the sheriff?
Yes, ma'am, as per the sheriff.
Okay. And did I appear at the county commission meeting?
Yes, ma'am.
When I left to go upstairs, did you hear a loud bang that got your attention?
Yes.
Now, I thought you came upstairs right away, but did you delay coming upstairs?
Leading.
Sustained.
When did you finally come upstairs?
Directly after I heard the loud banging noise.
Okay. And then after you heard the loud bang, what did you do?
I exited the commissioner's room, walked up the stairs, and I seen you standing at the door with Mike and the other gentleman. I can't think of his name.
All right. Now, did you speak with Mr. ERAVI and his associate?
At that particular time, I just asked him what was going on.
Okay. And where had I gone?
You were actually at the door at that time, but you were trying to get to your office.
Okay. Now, when you were, did you do an investigation into that incident?
Yes. The defendant asked me to do a report. He wanted to file a complaint, and you asked me to do a report because you wanted to file a complaint. So I spoke with both of you after the fact.
Okay. And did they end up taking you upstairs and showing you the door and everything?
Yes,
And you spoke to me then later in my office?
yes.
All right. Now, when you were dealing with the commission meeting and everything going on, were you watching the live stream?
I don't,
Were you watching Mr. ERAVI and Mr. Spee's live stream on YouTube?
no, I don't watch that. I've never watched any of their YouTubes.
All right. Did you go back and review that video later?
I had asked for it. What I reviewed was what they sent me.
Okay. And does it show me going through the door then into my office?
Yes, it shows them following you, walking with you to your door. I didn't see you go to the door of your office. I seen you go to the entry door into the foyer here.
Okay. And do you, and have you escorted me down to the commission meeting in July?
Yes, ma'am.
And after the commission meeting in July, did I leave the courthouse?
You came back to your office, ma'am, via the elevator.
And then after going up to my office, did I leave the premises?
Yes,
Did you walk me to my car?
yes, ma'am.
And did they follow me to my vehicle?
They followed you out of the courthouse. How far they came, I don't know, because I had my back to them.
And were they yelling at me and following me to my car?
They were questioning you, yes.
Okay. And then I got in my car and left.
Yes, ma'am.
Now, have you had concerns when it comes to me of me being hurt?
Objectives irrelevant.
In the manner in which it's asked, I'm going to sustain the objection.
In dealing with this defendant, have you had concerns about me being hurt?
Same objection.
Sustained.
Now, have there been any other instances besides July 29th and September 9th that you've had to escort me or walk me around the courthouse?
I can't recall a specific time, but
All right. And, Your Honor, I will pass this witness to the defense.
Mr. Baker?
Sure. Deputy Love, so the September 9th, we've actually got video of when Mr. Irving and Dr. Spees came down to talk to you,
yes, sir.
right? So the chronology was, you seem to indicate that you heard a bang and you went up, but that's not true. You never went up at all until they contacted you. They came down and said, hey, and told you about the incident, right?
No, sir. When I heard the bang, I exited the commission room, walked up the stairs to see what was going on.
All right. And that's on September 9th, okay? And the bang was what?
The door hitting the wall.
Okay, and who was around when that happened?
Mike, Dr. Spees, and the county commissioner are all
All right.
there near
Okay, you said Mike, I'm not,
this gentleman here, sir. I don't know his
Michael, or I know who he's talking about, Irving. It's,
the defendant?
yes.
Okay.
All right, and so the bang. Did you ask what happened?
Yes, sir. I asked what happened.
And what did Mr. Irving say?
He said that she was trying to prevent him from going through the door, and he was pulling on it, and it slipped out of their hands and hit the wall.
All right. Now, I think we've got a video of that. Do you remember if Mr. Irving was videotaping and Dr. Spees had his phone out, videotaping like they normally do?
Yes, they were videotaping, and I'm not sure. I mean, this was after the fact. I don't know. I did not see the incident take place.
It's okay. And I'd like to, if I can play you what we have recorded, and you tell me, kind of describe what's happening, if you would.
And what would the exhibit number be?
There'd be Exhibit B.
Defendant B?
Yes. And let's see if I can find it.
Any objection, Ms. Gillett?
I do not, Your Honor. Are you talking about Joe Love's video or the prior one?
Well, I'm not sure. There's the door incident. Let's see which one this is.
It's going to be open with, and you have to do player legacy to get the following.
Okay, so what can we do? The issue is we need to do something because now there is.
Let's go back. Let's take the other video back. Let's go to the one before that. Or I think it's you.
This video?
And let's let's go.
Change the sound. It's not letting me use the TV video sound.
Well, you're there.
Yeah, it's fine.
Counsel, I have bouts of
It's playing the
vertigo.
sound from down.
It'll get better.
Thank you.
He's got it sideways, but go ahead. All right. So do you recognize that as that public meeting, September 9th, as we go through there, or do you know?
Yes, sir, that was Commissioner room on
All
that.
right. So I'm going to speed this up somehow.
One of the other things that I needed to address today is, back in March, the sheriff and I started researching
That way,
surveillance.
advance.
Are you wanting to move forward in
Yeah,
the video?
I do.
This is the
Where do you want to move forward?
Well, let's see where we're at. Go on. Let's get to past.
counties
Keep going.
that are establishing issues.
Let's go to where Mr. ERAVI speaks to the commissioners.
We generally use that fund to help with stuff.
It's going to come up here pretty quick.
No, I'm not asking Jill to shake her head. This is public comment. Get out of the way, Jill. Get out of the way. This is public comment.
Excuse me, this is our meeting and I am allowed to speak.
No,
I think you're going to just before that.
no, let me, I can kind of run this myself. Thanks.
This is public comment.
Excuse me, this is our meeting and I am allowed to speak.
Further discussion, okay.
Do you guys actually know what the diversion fund is used for? No, I'm not asking Jill to shake her head. This is public comment. Get out of the way, Jill. Get out of the way. This is public comment.
Excuse me, this is our meeting and I am allowed
I
to
don't
speak.
give you
No,
any respect.
you're acting disrespectful.
Be quiet. Be quiet. Nobody wants to hear from you. Now, what I want to know is, do you guys actually know
This is not a
what?
public comment, it's discussion.
You don't run the meeting, Jill. You have no authority here. Be
You don't
quiet.
understand Robert's rules.
Quiet.
You guys have to be.
$3,550 you're just gonna spend without any public comment? He's gonna move ahead.
He
You
opened
guys
it for,
actually understand. He opened
he opened it for further discussion.
Shut it down?
I have something I want to say as well. You
You're
opened,
just gonna shut it down. You're just gonna let her spend money and let her do what she wants. And you're gonna open it, shut it down.
you opened
Because
it,
Jill doesn't wanna hear it.
you opened it for comment. I had something I wanted to say as well. They'd already voted. They'd already voted.
Comment out here.
They voted.
Do you guys have any other questions for?
I'd like to know what that does.
Thank you.
Jill, is this stalking? Is this stalking? Did you know that the stalking statute says that it doesn't apply when you're conducting official business, especially within the public, which is what we're doing? Because you were trying to charge us with some bullshit charges, we were just asking you about it, and you said, well, I'm going to charge you with stalking now.
Now, let me stop.
Judge, for the record, we...
No.
Oh, it's just what, it's him commenting on this. What?
So, this, you saw the door bang, and now...
I'm going to object. He's testifying. Either he can ask questions or he can play the video.
This is cross-examination. While it is their exhibit here, this is a witness that is the plaintiff's witness, so he may cross-examine. Objections overruled.
So you heard the door bang.
Yes, sir, I heard the door hit the wall.
All right, and so far we don't see you coming up the stairs yet, do we?
No, sir, you don't.
All right. Now, you said you came up spontaneously after you heard that bang.
After I heard the bang, I came up to the head of the stairs there.
All right, so let's see if you do that.
We were following Gillett asking her question. She tried to force it before and prevent any access. Okay, what are we doing? Why do they keep doing it?
Now, is that the stairway up?
Yes, sir.
I don't see, there you are, is that you?
Yes, sir.
Secret would be,
Yeah, Jill Gillett. Two reporters following her up there, trying to talk to her.
Now, you hadn't gone up yet, have you?
No, sir, not at that point. At the point,
Well,
you don't see it.
let me,
Hold on, wait, one person at a time.
all right.
Listen, wait for him to finish the question, then answer.
So, all through this video, after that bang, you've seen the video footage, and then they come to you. You had not gone up prior to that, had you?
Can I elaborate on that question?
Well, just answer yes or no, and then we'll go from there. But you hadn't gone up
I
there.
had not gone up the stairs. I had come to right there where that gentleman's standing at that, prior to them coming down the stairs.
Okay, but you never went up.
No, sir.
Okay. And then, so you say you went to the bottom of the stairs, and then you went back to your office.
I was not in my office. I was in the Register of Deeds office.
Either way, you didn't go upstairs.
No, sir.
All right.
She goes in and pulls the door closed, prevents her access. I don't want a complaint form. What's a complaint form going to do against an attorney who's above the law?
Now, that's a public area, that walkway where we've just seen all the video.
Yes, sir.
And you didn't, and them talking to you about what happened, that's something that people do to you all the time.
Yes,
Hey,
sir.
something happened.
Yes, sir. He was wanting to make a complaint over
Okay.
the events that had transpired.
yeah, what's the process? This is the open public hallway. Sure. I'm gonna stand first, quote unquote.
All right. So, we also saw some other video with you. See if I can get to it. Get me to the next video, would you?
And the exhibit number,
It's still Exhibit B.
We need to do something because now there is something up, there's a mark on the wall. We're saying that Jill initiated this. Cannot go unreported because of what you guys will try to spin this
You guys
as.
are trying to say that I caused the whole thing. Jill initiated this. So you're agreeing that Jill initiated this?
I'm agreeing that you were pulling the door and she got a hold of it. She got out of both your hands. What I said, that's what I said.
Now, let me stop right there. What were you saying? You said you saw some video?
They showed me the video of what had transpired up at the top.
Oh, up there. Okay, so they said, here's what happened, here's the video, and what were you saying back to Mr. Irving?
Mr. Irving was wanting to know what, he was accusing me of going to spin it off as some kind of a crime, and I told him I'd seen the video, I'd seen what happened.
So, and you saw in the video where they went through the double doors when Jill went into her office, closed the door, and they stopped. You saw that?
Yes, sir.
Okay. And you also saw in the video, there was no words in there that said, "I'm going to hurt you, Jill," or, anything like that, was there?
Not to my knowledge, no, sir.
All right. In fact, nothing you saw in that video caused you to write up some sort of criminal activity on the part of Mr. Irving or Dr. Spies, correct?
I did write up a report because I had been asked to do one by him and the county attorney as well.
All right. And that report, did you make any conclusions that there was some sort of criminal activity?
No, sir.
Okay. And was there anything in the report that you concluded that Mr. Irving couldn't be in the courthouse or in that public building or even talk to the county prosecutor?
No, sir.
Okay. She asked you something about when you went outside. It said you went outside with her to her car, but you didn't go all the way to her car, did you?
Sir, I really don't remember.
Fair enough. And you said they were out there outside the courthouse.
Yes, sir.
And that's a public area, correct?
Yes, sir.
All right. And she said, did you hear them yelling? You said, "I heard them questioning." You recall that?
Yes, sir.
Right. And do you remember what they were questioning her about?
Yes, sir. We were talking about an abducted duck.
A duck. And was there some deal about a duck, being a neighbor's duck being stolen, and it somehow ended up at Jill Gillett's house?
That's hearsay. I am not familiar with that case at all.
Okay, but you heard about it.
I heard comments about a duck, yes, sir.
All right, this duck.
I am hard of hearing, so I couldn't pick up everything it said.
I got it. If a county prosecutor had stolen a duck or, something like that, that might be investigated, right?
I assume so, yes, sir.
I got it. Okay. That's all I have.
Any redirect?
Just briefly. So the first time they were here and you walked me to my car, were they questioning me about something different other than the duck?
A judge asked and answered. He said he didn't. He just said the duck.
Well,
Sustained.
she had specified.
I suspect
Let me
the objection.
rephrase it. Do you remember any of the questions from the first time you took me to my car?
I don't remember specific questions, but the first time did not involve a duck.
And the second time then involved them asking me questions about a duck?
Yes, ma'am.
Okay. No further questions, Your Honor.
Just to follow. What did you say first time? What date you talking about?
Sir, I can't remember the exact date. It would have been a previous commissioner meeting a month
Okay.
prior.
And so, in the questions you think that Mr. Irving and Dr. Spies were asking, did it occur in the courthouse?
No, sir, it occurred as she was exiting the courthouse out to her vehicle.
Outside the courthouse?
Yes, sir.
Okay, just asking her questions. Did you hear them make any threats, or "I'm going to hurt you," or anything like that?
No, sir.
Okay, no further questions.
Well, you may step down. May this witness be released?
I believe so, Your Honor.
Yes, Judge.
All right. Deputy, you are released from your subpoena. If you're assigned for security, you can be in or out.
Yes, sir.
Next witness.
Clinton Hansen, Your Honor. And we've watched those videos now, Judge, but I don't think that the defense has actually asked for them to be admitted. But I am asking for the two videos we have watched, 11 and 12, to be admitted into evidence.
I have no objection. I'll ask that it be admitted also as well.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank Thank you. You may have a seat. You're under oath. Counsel, when he settles, you may begin.
Would you please state your name for the record?
Clinton Hansen.
And how are you employed?
I'm a deputy sheriff with the Greenwood County Sheriff's Office.
And from time to time, have you done special cases here?
Yes.
And were you a former county deputy?
Yes.
How long have you been in law enforcement?
A grand total of 14 years.
And were you assigned to be special security for me for the jury trial?
Yes, ma'am.
What date was that trial?
I believe it was November 3rd through the 5th.
Okay. And did it get delayed due to the election day?
I don't know about the election day per se.
Was Wednesday the 6th the day that you were here to give security for me?
Yes, ma'am.
And when you came on November 6th, were you assigned to follow me everywhere I went?
Yes, ma'am.
And were you on the lookout for individuals that could cause me harm?
Yes, ma'am.
Now, after I had been in the judge's chambers, where did I exit to?
You came right out of the judge's chambers into the foyer area, I guess, for lack of a better phrase.
Okay. Is that at the top of the stairs?
Yes, ma'am.
And after I had been standing there with you for a few seconds, did anyone approach us?
Yes, ma'am.
Who approached us?
There was a couple people. We had another deputy, Jeremiah Andrews, that I work with, also came by. I'm sorry, sir, I really don't know your name other than Michael. Came and stood by the judge's chambers at the top of the stairs as well. Some other people were walking by too.
All right. And did he stand right behind me?
Pretty close.
Is it within feet of me?
Yes, ma'am.
And did something occur after he got behind me?
He dropped his phone, or it somehow landed on the floor. I don't know if he dropped it or just fumbled with it.
Okay. And did he draw your attention?
The sound of the phone hitting the floor did.
Okay. And did you continue to watch him to make sure I was protected?
Not only just him, but the entire area.
And did I express any concern to you that day of fear?
Object is irrelevant.
Judges can,
Sustained, not the best evidence.
well, Judge, it's relevant as to I expressed the fear that I had felt for the jury trial.
Same objection, Judge.
The objection sustained.
And have you been scheduled to continue to provide security to me in these kind of situations?
Yes, ma'am.
All right. And I will pass this witness, Your Honor.
Mr. Baker?
Yeah. Deputy Hansen, were you in uniform that day?
No, sir, I was not.
Okay. Did you have a firearm on you?
Yes, I did.
And was it open?
Yes.
Okay. Anybody could see it?
Yes,
Did you have a badge?
I did.
Okay. So you look like law enforcement, right?
I would presume so.
All right. And so you're there, and then Mr. ERAVI's in the same area. Did Mr. ERAVI say anything to you or them? Say, I'm going to hurt you, Jill, or I'm going to do anything like that?
Can I ask a clarifying question, sir?
Well, let me see if I can ask it again.
Okay.
Did Mr. ERAVI, when he was there, say, this man right here?
Okay. I was unaware of his
All right.
last name.
Did you hear him say anything to her that said, I'm going to hurt you or threaten you or anything like that?
No, sir.
Okay. And did he make any threatening gestures, body language, proxemics, anything like that that said, this guy is going to go off on her?
No, sir.
You didn't perceive him then as an immediate threat to her, did you?
Not at that time.
Not at that time. And then, you say he dropped his phone and picked it up, and that was the end of that, right? She went on her business, right?
As far as Mrs. Gillett?
Yeah, and that.
There was some conversation between the deputy that's sitting over there. I'm sorry, I don't remember your name. She was advising me that he could not be recording. I am unaware if he was recording or not, and then me and Mr. Gillett went to her office.
So how many law enforcement were there around Jill Gillett when this happened?
To myself and Deputy Andrews.
All right.
She was further down the hall here.
All right. She have a firearm?
I presume so.
Does she have a badge and uniform?
Yeah.
Okay. No further questions.
Can you redirect?
No, Your Honor.
All right. May this witness be released?
Yes, Your Honor.
Yes.
Please stand.
Thank you. You are released from your subpoena.
Thank you, Your Honor.
Next witness.
I'm going to testify, Your Honor.
Right. Counsel, we're at 12:53. Where are we? Was scheduled such that, and I think Mr. Baker indicated he's here for the day. Ms. Gillett, what appearances do you have?
Judge, I have child in need of care hearings this afternoon. I have a few of them. I have one at 1:30, one at 2, and then I have the last one is at 3 o'clock. And it's a truancy case. It shouldn't take very long. It was a brand new setting that just came up last week.
So what do you want to do?
So they were summoned in, I think, a couple weeks ago.
So that, I mean, when would be the end time when she'd be available, you think?
I would need to be away from 1:30 to maybe 3:30.
If we start back up at 3:30 or soon thereafter, that 3 o'clock hearing is over. Counsel, if we'd had this scheduled for the whole day, I'd feel differently about it, but
I don't think it's your fault, Judge. And so, if, I don't think we can get done, and I don't want to, I didn't know about her schedule, I didn't know all that. I had my concerns, you know, all that. So I'm going to suggest this, because I don't think we get done 3:30 to, and you've got a life and so do we. Maybe we can, and I'm going to say this, reschedule, or at least continue this to another setting. Now, but I'm open to staying tonight if you want, but I just don't think, and it may be, Judge, can I offer you this for my sake? It may be that I can do some of this by Zoom.
let's start one in person, vice versa. I really like to stay with the same way.
Fair enough. Just was looking for an easy way out for me.
I appreciate it, but I'd like to keep it the same if possible.
Judge, I don't have my calendar. I apologize. Can I, if I can talk to your clerk, if we just adjourn today and set it out, I think you're in compliance with the statute, and then we can find a time that I can drive back up here.
Do you know what schedule looks like on, today's the 18th. On the 20th, that would be Wednesday, because we had a full morning bench trial that's off now.
Mm-hmm.
On the November 20th.
2 days from now.
Yeah, I don't have it, and I'm trying to work from memory.
Actually, the afternoon, I've got just a couple of first appearances. I could probably be ready to go at 2 or soon thereafter.
That afternoon, November 20th?
Yes.
Is that going to be doable? We have to. Okay. Judge, I'll commit to that. I've got a federal, I know I have a pretrial federal, but that's by telephone. So I think.
That's by what?
Telephone federal pretrial, I'm sorry. So if you want to set it November 20th for that afternoon, and.
Well, what time is your call?
I think it's.
Counsel, you don't have your calendar?
I'm sorry, I just don't. It's all electronic for me, so I'm a solo practitioner. I apologize.
Okay, do you have a staff or somebody that
I
can
don't.
look and?
It would be my wife, and she's not there, so I'm sorry. I'm almost 70 and low overhead, so, if you want to do it, that day, I'll do my best when I get back. If I've messed up the schedule, I've got a conflict.
Well, I don't want to interfere with your federal case, that, you know, do you have a general feeling? I don't do federal case, never did, so that would
Well,
that would
my
break
general
well with me.
feeling is I've got, the pretrial, I think, is that morning. But, man, if this is a spelling test, I may not pass it, so, but that's my feeling. Set it for that afternoon, and you'll say 2 o'clock?
Or soon thereafter.
Okay. And if you will just give me enough grace that if I go back and said Baker messed up, he's conflicted that afternoon. If you'll, because I wanted to get this done today, but couldn't. I didn't know.
Well, I don't want to cut anybody short on their case. Ms. Gillett, would you be available on the 20th?
Yes, Judge, I only have those first appearances with you since our trial went off.
All right, well, looks like I've got a probate, but it's a final settlement. That's probably just paperwork. So I think there's a real good chance we'd be ready to go at 2.
Okay.
But I've got the morning as well, so if you find out.
Oh, okay.
If you find out that you,
Can you do it earlier?
that are available in the morning, you can, and your witnesses and everything can be there.
Okay.
I would prefer that, simply so we have more
Well,
wiggle room.
it's a 2-hour for me to get here, so 10 o'clock probably is good. But I will let, and I don't have do you have a staff or someone I can email? Or
Clerk's office.
clerk here? Okay, so I'll do that when I get.
Darren Matter is the county, is the district clerk.
Okay, so when I get back, I'll tell you.
So right now, we'll set it for 2 o'clock. However, if we can do it at 10, you know, we'll try to move it up to that. Will that council be able to work with that, both counties?
It will for me, Judge.
Mhm.
Okay.
All I have that day is those first appearances, Your Honor.
Time frame, just, if I have an estimate, Ms. Gillette, how much longer you think your case in chief will take?
Hour or less.
Okay? And Mr., you said something about motions after the state.
Yeah, so I'm going to file a motion, I'll argue that, and then, so I'm saying maybe 3. I've got 2 witnesses after I cross-examine Ms. Gillette, so I always try to.
You think 3 hours?
Well, I know I know, but with the hour of testimony there and then cross-examine a county prosecutor, you can imagine. So I think, I don't know, I've got some more videos to play, and they take a little bit of time, not a whole lot, but
All right.
maybe 2 hours. I think I could get it done in that amount of time.
Your case that you already have set takes precedent as far as I'm concerned. That's, you've got that. If you find out, and I don't know if that's a docket or how they do that.
It's said it, and they do now mostly by telephone, but you gotta be there.
What I would suggest, and if we could start at 10, and if necessary, and if your hearing is set for like 10:30, we'd take a recess to allow you to do your hearing, and that's no matter when it is.
Got it.
I just would like to be able to get all of the evidence in and hopefully a decision that day, so that
Right.
we don't have to have other people coming back
Got you.
on a different date.
I got you. That sounds fair to me.
So we'll set it at 10, however, that's subject to modification to, in consideration of Mr. Baker's federal case.
Thank you, Judge.
But it breaks, and we would probably go, if we can start at 10, we would probably go to noon or real close to noon, finish a witness or whatever, and then we would probably be starting at 2 or soon thereafter as I'm concluded with my first appearance docket, which right now I think I've got 2 cases, so it shouldn't take long.
Fair enough.
Okay. All right, so we'll see everybody at 10 a.m. on November 20th, which is Wednesday.
Thank you.
Judge, do you want to hang on to the exhibits, or do you want us to hang on to our own exhibits?
Right now, I'd like council to keep their own exhibits. Please have them available for me. In regards to videos, in the event that I want to watch some or part of these videos during deliberations, I would prefer to have counsel do that here in the courtroom, so that, frankly, so I don't foul it up in some fashion.
Got it.
All right, thank you. Anything further?
Not from this,
No,
not from the plaintiff.
not from the respondent.
Right. We are adjourned. Thank you.
You want the south one or east one?
The south one, please.
You're kind of competing with that diesel generator out there.
Welcome to Elk County.
Yeah, there you go.
All right, this is case number 24, DM 17, Gillett versus Philip. ERAVI? Irving. This is, have counsel state their appearances, please.
May it please the court, the plaintiff appears in person. Permission to stay seated to remain on the record clearly.
Let's have Becker appearing in person for the respondent, Mr. Irving, who also appears.
We're continuing a case from, I believe the 18th, 2 days ago. The plaintiff had presented part of her case in chief, and that's where we were interrupted. Before we get started with testimony, Mr. Baker, you had indicated the other day you had a commitment to a federal court. Scheduling wise, what do we need?
Yes, Your Honor, I've got an 11 o'clock telephone, and I've told your clerk if you can just cut it at 5, give me 5 minutes prior to. I don't think it'll take more than 15 or 20 minutes.
Okay, if you need additional time than that, let me know. I sometimes get caught up with what I'm doing, so please watch the clock if it's getting to that point. If there's a natural breaking point, we'll try to accommodate that, but we'll take that break. In regards to my calendar, it looks like I should have only one thing, first appearance at 1:30, so we should be able to get going by 2 o'clock, depending, and we may go some through the traditional noon hour we'll give everybody enough.
Judge, I do have a meeting at noon. I'm part of the Access to Justice for Rural Area Representatives that helps the underprivileged get access to courts.
What time is
attorneys.
your meeting scheduled?
It's from 12 to 12:30, 12:45, somewhere around there.
Okay, thank you. All right. Any other preliminary matters, counsel? All right, there was a sequestration order earlier, that will still remain in effect. So if there's any witnesses that were present before for either side that haven't been released from their subpoena, they need to step out, please. And counsel, I'd ask that you take a peek and make sure to everybody that you anticipate calling. Everybody good? Okay. Ms. Gillett, you may continue. You're calling yourself as a witness? All right, if you'd raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You're under oath.
Judge, if I may, as a preliminary matter, the witness is bringing up documents to the witness stand. I don't have copies. I don't think she's going to be reading from them.
Judge, it's a copy of the petition.
Hold on. How I do this, we do this with officers all the time. They take up, if witnesses take up documents, if they're referring to documents, then yes, the counsel will have an opportunity to look at those documents. I don't let witnesses just read from the documents. If it's a document that needs to be admitted as an exhibit, then and it's properly offered. If it's admitted, It certainly doesn't need to be read into the record because I can read it myself.
Well, just as a clarify, she's got notes. It's not a document. She's got little pasty notes over there that she's going to refer to. So it wouldn't even be a document. It's something she's going to use as an outline, and
All right.
I think that's proper.
Okay, Ms. Gillett, what are the sticky notes?
The sticky notes are my notes as to referring to the exhibits, which he does have a copy of the emails that were attached to the petition, a copy of the petition so I can follow through and remind myself of dates if I need them. And these are my sticky notes as to what I wanted to specifically refer to in these notes, in the exhibits. And these are my personal notes on their exhibits for when we get to their portion. So they're just here so I don't lose them.
Still personal notes. I mean, it's
Mr. Baker, we have a situation where the person's representing themselves. As an attorney asking questions, if you're asking questions, you may be the rare exception, but most attorneys have notes and so forth. So I see that as work product.
her own notes as a pro se.
Well, yes. If we're talking about in regards to what items that she wants to question herself about, and things to that effect, yes.
But pro se has work product, Judge? I mean, all I'm saying is I can't see the notes that she's taking up and reading from because you're ruling it's work product from a pro se.
I'm saying that she has a right to have notes in regards to what areas she needs to cover.
Can I see them?
No, that's going to be work product. All right. So the witness is under oath. You may make your testimony.
Your Honor, I brought this case to ask, it's hard to not ask yourself questions, so I'm going to go through a few of the things that occurred that are not protected. And so, on July 29th of 24, Mr. ERAVI followed me from my office down to the elevator. We went down the elevator and then into the commission room. He continued to try to question me during that time, was close to my person, which makes me have a concern for my own personal safety. It was clear that there was other concern for me because I ended up having a deputy escort, which was Deputy Joe Love. They are constantly on live stream. I do not access their live streams, Facebook pages, anything of the such. I've been sent numerous links, still shots. I don't care to look at those because I know, pursuant to the law through the Phelps case, that what's on their pages is their pages. But when it crosses the line to come...
Right. This is not an opening or closing argument. This is testimony. So
Right.
Testimony in regards to factual basis or facts is what
Correct.
this portion is for.
And the fact is, I don't look at any of the social media or news, what they consider themselves as, they consider themselves a news outlet. They're not KPA, but I don't consider them news. But I don't look at their social media. None of this is based on any of their social media or their presentation, as they call it publicly. It's specifically interactions between them and I. So on July 29th, he followed me down to the commission meeting. I had an executive session about security for a trial in the courthouse when they're here and present, as well as other things that go on that's related to security of the court and the courthouse. After the meeting, he followed me to my car. He questioned me the entire way to my car, yelled at me. Deputy Love accompanied me. I noted that when we went through their exhibits, that video is not included. I believe it's not included because it is conduct.
It's argument. It's not fact.
What? Okay.
It's conduct that is not speech. walking out to my car, following me, putting my car on live stream, having photograph video of my car designates what my tag is, what my car
Okay,
is.
hold on. This is argument, and that's fine in the appropriate context. The facts that you're talking about was someone followed you to your car. That's a fact. That's fine on testimony. Your interpretation of case law or those things aren't, no, that's going to be appropriate for argument. So I'd ask that you limit your testimony to facts as though this was being, attorney questioning you.
It's a fact that he now has my tag number. It's a fact that he now has the make and model of my car. It's a fact that he now knows that I have a foster kid whose name would be on the back of my car and what my foster kid's name is. Those are all personal information. It is a fact that he stood at the back corner of my car, and after I got in my car, I had to wait for him to stop yelling and move on before I could back out and leave the courthouse, which caused delay in my departure from the courthouse. It gave me concern that he walked all the way out to where my car was and didn't stop at the courthouse doors or back where it would be clear that he was not invading personal space. He walked clear up to the back driver's side corner of my car, of my SUV, and I was in my white SUV that day. That is conduct. It's physical. It's not speech.
Object is argumentative.
It is. Please refrain to the testimony of.
On September 9th of '24, there was a commission meeting, and we saw that video. Partly, the beginning part we did not see, but I came down to speak to the commission. Again, we had another executive session about court security, courthouse security with the sheriff, myself, the commission, and County Councilor Dean. Prior to going into that session, he kept talking to the commissioners. We ended up having our executive session. I came out to deal with a surveillance camera. After I left the meeting, I went up to go upstairs. He continued to yell questions at me about the duck. The duck is a issue that happened in Fredonia, Kansas. I lived outside the city limits of Fredonia, Kansas at the time. And I, as you know, lived out in the county. I am the owner of multiple ducks. I now own chickens. I own 4 dogs. And I basically have a small hobby farm of waterfowl and poultry. I have given lots of advice to many people, and I run a rescue. I have multiple rescue ducks over the years. I've been doing, we had ducks years and years ago, and then we stopped having ducks for a while, and then I got ducks again starting in 2020 during COVID. I was off work, and it gave me something to do. And as someone who cares for waterfowl, I carry medications, all kinds of things. I have a vet on call that works with me with waterfowl. I have a pet duck that lives with me. And so I was called about a duck that a little boy had with him and brought to a friend's daughter-in-law's house. They didn't know what to do with it, so they gave it to me to care for until whether it was located as a wild duck or whether a family was recovered. I know the breed of duck because I can identify them, that it was a mallard, and mallards can be wild or domesticated. So an investigation was conducted later when the individuals who owned the duck got home significantly after work. And the family for that duck was located A police officer came to the door, and as you know, my ex-husband had dementia, and he had been screaming and yelling all day and all evening. And particularly extremely bad that night. And he had interaction with the officer downstairs, came up screaming and yelling at me. And then later on, I went down and got the little duckling and took it to the officer to return to the family. And that is what happened with the duck. How the duck came to be in the little boy's possession, I don't know. But because I am well known for being able to care for animals, I had it. There was a report made by the local officer. I don't know what was in his report, but the little boy who had the duck had taken it over to an individual's home, and like I said, that's how I ended up with it, because they knew I could care for it and have it feel set up at all given times. So the duckling was cared for until the family was found. Mr. ERAVI clearly has been poking around with the Fredonia PD to try to find any kind of incriminating information.
A cause for speculation.
That may be argument. Again, please refrain from argument, and facts to support that argument is basically what this is, to give out facts. So please refrain.
So all the way up the staircase in the lobby, he's yelling at me about a kidnapped duck. And I don't believe you can kidnap a duck because it's an animal, but he yelled at me all the way up the staircase. At the top of the stairs, we watched the video 2 days ago, and you can see that I started to close the door behind me. I was in the motion of shutting the door when he yanked it out of my hand. I did not turn around or say anything to him when he did so. I walked into my office, and I had my key card with me in my other hand, and I wear a wristband, so I had my key card with me. And I buzzed myself into my office and then went in to calm down from them yelling at me all the way up the stairs and whipping the door out of my hand.
Which door are you referring to?
The door at the top of the stairs. We watched the video 2 days ago where he yanks that door open.
Double doors that separate the landing from the hallway?
Yes.
So we're not talking about the door to your personal office?
No. So when that door was yanked out of my hand, it did cause me pain and harm. For 3 days, my hand was swollen. They don't know, but I will tell you, I've had carpal tunnel surgery in that hand. I have permanent nerve damage in that hand. I have de Quervain syndrome in that hand. And I have tendinitis on the far side for overcompensation from the de Quervain syndrome. I am under the care of doctors. I do take medication for the permanent nerve damage, and my hand was swollen for 3 days. I live with excruciating nerve pain down my right arm daily for my entire life since I was 20 years old in a terrible car accident. After that occurred, I debated on whether or not to file a protection case, since they have now physically followed me twice, once causing damage.
All right, you've used that term "they." Now, Mr. ERAVI is the one you're referring to as he?
Yes, Mr. ERAVI followed me on the day of my car and on September 9th, which was July 29th. And September 9th, he followed me both times. So I debated whether or not to do something then. I did make a report for battery with Deputy Love. I have spoken with 2 different prosecutors, and one is very interested in
Objective,
cases.
speculation, and hearsay.
Sustained.
So those cases have to be referred out now, everything that it deals with them, since I'm a victim. There's no evidence in the video of me holding the door shut. He literally ripped it out of my hand as I was in the motion.
It's, no evidence, it's argument.
Sustained. Please refrain, from your perception of how things in regards to interpreting videos and things that are admitted as evidence, that's argument. So please, continue.
In the video, you saw the door was flung so hard it smacked the wall, and it made a loud bang.
Let the record reflect she's just reading from,
No, I'm not. That's not exactly in my notes. This is just to refresh me.
Overruled. Please continue.
Now, after I had those instances, I have continued to receive emails from him. I don't respond to them. He asserts that all of the emails are communications with an elected official. The protection for communications is it must be revolving around.
This is argument. Please. I don't want to have to keep going this. Tell the test, give the factual things that you want the court to know for evidence.
Petitioner's Exhibit 1 is attached to the petition. It is an email dated September 26th. It's from Mr. ERAVI to myself. And it says the catalyst is you is the title. And it is mostly just attacks to me personally.
All right. Are you moving for the admission of plaintiff's A?
I have it marked as 1. They have theirs as letters.
Okay. What was in your petition as plaintiff's A?
The actual exhibit's marked as 1.
Okay. And is that present?
It is.
All right. So are you moving for admission of plaintiff's 1?
I am.
no objection.
Plaintiff's 1 is admitted.
I draw the court's attention to the last lines where he threatens to follow my entire career to the end. Even if I went into private practice, that makes me believe that he would follow me even into private practice. I'm moving to admit Petitioner's Exhibit 2. It's the email from Mr. ERAVI to me dated August 18th.
All right. Is number 2, what was on the petition, is B?
Yes.
Any objection?
No objection.
Plaintiff's 2 is admitted.
And I would draw the court's attention to the contents of it. On 2, he talks a lot about stuff not related to the case and issues that are definitely outside of the Walker case they are following. And Petitioner's Exhibit 3, which would have been C on the petition, is the email dated September 9th. Now, this email is a follow-up to a request for Cora.
Is it offered as evidence?
It is going to be offered as evidence.
Any objection to plaintiff 3?
No objection.
Plaintiff 3 is admitted.
And I would draw the court's attention to the last line that says, in jail, I really do have a lot of questions about your obsession with ducks. That has nothing to do with the case.
Argumentative.
Overruled. Please, next.
Petitioner's Exhibit 4, which should be D on the petition, is the email from July 9th, 2024. It is the Cora request that he made to everyone at the county.
Okay, are you requesting it to be admitted as an exhibit?
I am, Your Honor, just so that you have an understanding that it was a Cora request.
No objection.
Plaintiff 4 is admitted.
Petitioner's Exhibit 5 is E on the petition. It is dated July 3rd, 2024. And it's another email from Mr. ERAVI.
Okay, is that marked as stage 5? Excuse me, plaintiff's 5?
Yes, Petitioner's 5.
No objection.
Offered?
It is offered.
No objection.
5 is admitted.
And Petitioner's Exhibit 6 would be F, and it is an email dated Sunday, July 21st, 2024.
Is it offered?
It is being offered.
No objection.
Plaintiff 6 is admitted.
And Plaintiff's Exhibit 7 is an email dated Wednesday, October 30th, 2024.
Okay, hold on. Is 6 a two-page document?
6 is a two-page document.
Right. And plaintiff 7 is,
G on the original petition, and it's the email Wednesday, October 30th, 2024.
plaintiff 7 being offered?
Yes.
No objection.
Plaintiff 7 is admitted.
Now, since the petition was filed on November 6th, I was present for the beginning of the jury trial for Mr. Walker. I had been in the judge's chambers with Judge Rickey, Chris Pate, and many other individuals. And my sister died that morning. She did not wake up. And our family carries an underlying health problem, as you're aware, with my heart. And therefore, with my heart, we carry a genome that can cause sudden nocturnal death syndrome in adults, and we could die at any time in our sleep. My sister died, and they suspect it was either her heart or a blood clot stroke.
It's cause for speculation.
It's on her death certificate.
Okay. All right. Well, all right. The death of your sister is a sad and situation. I don't know that we need to have the whole history there. The fact that she passed away and this was the morning of trial. Please continue in regard to relevant issues concerning November 6th.
So when we stepped outside of Judge Rickey's chambers, and I was in the hallway, Mr. ERAVI left from the clerk's office window. We saw that video of where he left from there. There's not a camera at the top of the stairwell outside the judge's chambers. He left from there, came up behind me, was standing about 2.5 to 3 feet behind me, dropped his cell phone. He caused a big bang on the floor, which startled me. I saw somebody come towards me, and so I looked to see who it was. When I saw it was him, I looked at Deputy Hansen, who was there with me for security. Deputy Andrews was near the area and moved towards us to also watch him. We were there briefly for probably less than a minute that he approached me. Then it does give me concern that he approached me knowing this case was filed, to be near me, to possibly either record me or listen to what I had to say. So I motioned to Deputy Hansen that we should leave to my office, and we went to my office so that I was not near Mr. ERAVI, and I moved myself out of the vicinity of him just so that he could not be near me to cause any more physical contact with me. Physical contact is different than
Argumentative.
others, so the physical contact gives me fear.
Okay. That portion's permitted. Go ahead.
I do have fear of Mr. ERAVI. I am trained to stay calm, even if I am shot at, and to think clearly to get to where I need to be. I do have former training as an EMT that also helps me stay calm in these kind of conditions. I also have training as a first responder. And I've been put in other positions to be in dangerous situations, even being at crime scenes, to try to stay calm, cool, and collected and be able to think outside the box. So I do stay calm on the outside, although I do have fear he is going to hurt me. Mr. Spees has walked with him to, follow me within the courthouse. But when I was followed to my car, Mr. Spees stayed at the door of the courthouse. He did not follow me directly to my car like Mr. ERAVI did. He didn't stand behind my car. Mr. Spees backed off on the day of the door being yanked out of my hand. You can see it in the video that was shown 2 days ago. Mr. Spees did not approach me during the trial. He stayed at the clerk's window and stayed away from me.
Judge, it's irrelevant
Mr.
about Dr.
Well,
Spees.
okay, sustained. What somebody else didn't do, I don't find to be relevant.
Well, the defendant brought up in their opening arguments that no one else is being sought protection orders. Mr. ERAVI is the one who gets close to me every time, invading my personal space. And Mr. ERAVI is the one who caused physical contact with me. It is difficult to do the job that I am in anyway, but having physical contact gives me fear. I've received other verbal and written threats before, but this is an individual who has physically followed me more than once, physically gotten close to me, and physically caused harm to me.
When you say he's gotten close, what do you mean by close?
Within 3 feet of my person.
You mentioned personal space. What are you referring to as personal space?
Personal space to me is about a 2.5, 3 foot radius of a person. It's different, like if you're in an elevator situation. They have not gotten on the elevator with me, but they have physically been close to me. Like when I'm trying to get on the elevator and waiting, that's a small hallway up here at the top of the stairs. My only means of exit would be through past them if the elevator doors don't open. And they block that way, especially Mr. ERAVI is the one usually closest to me. He was the one closest to me on that occasion. He is the one closest to me when I'm going up the stairs, and then he approached me during the morning of the trial. And he walked right past me and then stood about 2.5 to 3 feet behind me, where I couldn't see him.
Are you finished with your testimony?
He continues to email me consistently, weekly. If it's relating to the case, I don't generally take notice of it. If there is anything that's a threat in it, I take notice of it. If there's anything in it that's personal, again, there's things that he wouldn't know unless he went to go talk to different individuals.
Argumentative.
So
Sustained.
I just pay attention to if there's something in there that's dangerous to me. And I have had threats from their followers, but that's not him making the conduct. It's caused by his statements and behavior, but it's not him doing it. So that's why I did not put it in the petition.
Anything else?
I can't think of anything else, Judge.
Right. If you have anything that are part of notes as to, that you would have in regards to remind you of what you needed to testify to, those need to be put away. Any documents or notes of facts, those you can be kept there, and counsel can review those as asked. She's finished with testimony. Okay, you've turned over things that still had sticky notes on there. So what are we talking about here?
The only thing I have is a case law case for later argument and my notes I made in the margin of the petition. So I don't have anything other than, these are the notes regarding their evidence. The rest of this is just bullet points of what I testified to.
Not to refer to those or to refresh your recollection with those during cross-examination then. If you need to look at if you're asked about the petition, then a copy of the petition can be provided. Ready to cross-examine?
Thank you, Judge. Ms. Gillett, these weekly emails, are they the ones that you've admitted in evidence?
These are the emails that I've received from Mr. Arabi.
When you say weekly, those are the emails.
I don't know that I said weekly, but I get frequent.
Yeah, you said
from him.
he emailed you weekly. You don't remember testifying to that today?
I don't remember what I specifically said.
You just said it 2 minutes ago, and you don't remember
I'm going
saying...
to object to arguing with me. I don't remember the exact wordage.
Okay. And in any event, if you testified that he emailed you weekly, the only emails you're referring to are the ones that you admitted into evidence today, correct?
These are the emails, yes.
You talked about your medical history, you talked about medication. What other prescriptions are you prescribed?
I take metoprolol. I don't know that it's relevant, but if you want to know, I take
Well, is it an
metoprolol.
objection or not?
Object to relevance.
Okay, the nature of the medications that she takes, if counsel wishes to ask if those somehow interfere with thoughts and so forth,
Well-
as to item by item of a person's personal prescriptions, I'm not sure it would be relevant.
Well, she has talked about trauma and emotional distress. She's taking medication for anxiety. I think that's relevant to her perception.
That type of medication, yes, if there's things that typically would have a warning of some sort in regards to not operating heavy equipment, that sort of thing. But I don't want things going to any and all.
Well, and I don't know what she's taken, but have you been prescribed medication for anxiety?
I have.
And what would that medication be?
I have two.
Go ahead.
I have hydroxyzine and I have Ativan. They are both PRN. I rarely take them.
I get that. Now, the next question is, how long have you been prescribed those anxiety medications?
I was prescribed them in 2022
Okay.
when my spouse got dementia.
Okay. Now, and are you currently taking anxiety medication?
I do, occasionally.
Today, did you take any?
Nope.
Okay. How often do you take your anxiety medication?
It's so rare. Once every 2 months,
Okay.
maybe once a month.
Do you go to therapy for anxiety problems?
I have a psychologist that I talk to. She's a PhD in psychology.
And you go to her because you have anxiety issues?
I go to her because I have severe issues that I have been through in my life.
Anxiety being one of them.
Not the anxiety so much as processing the death of my son.
Okay. All right. And so and how often do you go into therapy for that?
Once a month.
Okay. You, on July 29th, you remember that video that was shown there by the elevator?
I do.
And you told Mr. Irving that he could not be filming you at that place, didn't you?
He's in a judicial area and there are signs all
You
over up here.
told him he couldn't film, correct?
Correct, he should not film in a
And-
judicial area.
And that's a misrepresentation, isn't it? You said you can't film him in a judicial area, and that's incorrect, isn't it?
No,
That's not a judicial area in that hallway by that elevator, is
it
it?
is.
Counsel, that's argumentative. As to facts, as to what was said and so forth, that's relevant.
Okay. And you consider this entire building a judicial area that cannot be photographed?
The second floor.
All right. Not just this courtroom, but the entire hallways and all that, correct?
I do.
And do you know if that opinion is shared by the judge or anybody else in this building other than you?
It is.
Is there a rule in Elk County that filming is barred other than in the courtroom, as far as you know?
Currently, Judge Ricky has had signs posted for the courtroom.
I'm asking about other than the courtroom. Is there any rule?
I'm not aware that Judge Ricky has imposed it in the hallways.
Whoever might have one, is there any rule other than in this courtroom that bars photography or videotaping?
I'm not aware Judge Ricky has changed that rule.
Anyone else?
No.
Okay. So there's no rule that bars videotaping that you know of outside this courtroom, correct?
Incorrect.
And where's that rule that bars?
Statutes say in judicial areas.
Okay. You wanted this proceeding to be closed, didn't you?
I did.
Because you didn't want bad publicity.
No.
And you are a law enforcement officer of Elk County?
I carry a badge and I am the Chief Law Enforcement Officer of Elk and Greenwood County.
And so that's a yes?
It is a yes.
And if I can approach, I'm going to hand you the
But,
exhibit.
hold on, what are you approaching with?
Exhibit C, it's her petition.
You mean?
So let me hand you Exhibit C.
Okay, counsel, we don't have a court reporter, so before you start speaking again, if you could be by a microphone, please. Thank you.
And, Judge, I'll give you what I've marked as Exhibit C.
This is defendants or plaintiffs?
It would be her, but I've marked her petition in this matter as Exhibit C.
Defense Exhibit C.
Yes. So this is Defense Exhibit C. If you look at page 2, you do say I'm a law enforcement officer when I'm working or on official duty,
It is correct.
and you're talking about your official capacity as prosecutor.
It is.
Why did you put that in your motion?
Because I am. And I know that it makes it difficult for me, but I am.
In terms of what? What difference does it make in terms of your allegations of stalking that you're a chief law enforcement officer of Elk County?
Because it's pertinent for the judge to consider under all of the case law as to whether or not it interferes with my personal life or my official life.
Okay. And you would agree that a criminal investigation or a criminal prosecution is a matter of public concern?
The criminal prosecution is of public concern.
Okay. Or criminal investigation? How about that one?
It could be.
Okay. You say the First Amendment, hate screaming at individuals in person is not protected?
Is that in the petition somewhere?
Yes.
What line?
Well, just let me ask you the question. Is hate screaming at individuals in person protected speech in your opinion?
It depends on the situation.
When can you hate scream and it be protected.
Okay, counsel, is hate stream a term of art?
In her petition, she refers to it. I'll see if I can find it. Let me move on. It's in there, I'll find it, but if you use the phrase hate screaming at individuals in person, and then you cite Sampson, a case called Sampson, you see that?
Mm-hmm. What page is it on?
Page 2.
Page 2.
Bottom of the page.
I don't see where I used the word hate.
I said you cited to Sampson. See that?
I cited Sampson.
Okay, that's all I need. I'm approaching with Exhibit G. I'm handing it to you.
This is defendant's G?
Yes. And looking at this case that you cited in your petition, it refers to, on the next to the last page, where the court cites language being used.
I'm going to object as this is legal opinion and appropriate for argument, but not questioning.
You cited it in your petition. I'm asking you if you're aware of what Sampson says.
That's permitted.
The part that I cited had nothing to do with that. That part's irrelevant.
I don't really care. I'm talking about Sampson and what it says. You see what it says there? That calling someone, quote, stupid son of a bitch, and other words, clown, big fat ape, smart aleck, big fat oaf, and stupid son of a bitch is protected speech. Right?
It can be, depending upon the situation.
They said it's protected. You don't agree with this?
Not when it's coupled with battery.
Okay. Now, and the worst word that you remember Mr. Irby saying to you was what?
Over the course of our interactions, he's used the word cunt, bitch, all kinds of different words.
Okay, you've cited 2. Anything else you can remember as bad words?
I think it's his followers that say Nazi baby killers, not him.
Okay, and you're not holding him responsible?
No.
Okay.
That's why it's not in there.
But you bring it up in your complaint as though he's responsible, don't you?
They are his followers, and he gives them our information.
But he's not responsible. He can't be held responsible for what they might say, correct?
That's correct. One of his followers has actually threatened to kill me and admitted to it on
Please
Facebook.
just answer the question.
As the chief law enforcement officer of Elk County, you possess one or more firearms?
I do.
How many?
Ooh.
Counsel, how is that relevant?
She is able to protect herself, Judge. She is a law enforcement officer. She can probably bring a firearm into this courtroom.
What does the number of firearms an individual owns, how is it relevant today?
Okay, let me just get to the other question. But the fact that she has a firearm, all right. And are you permitted to bring a firearm into the courtroom?
I am.
And into this building?
Yes, I am.
Do you have one in here today?
I do.
Where is it?
On my chest.
All right. What kind of pistol do you have on you today?
I have a 9mm Glock G 43. Not the X, the regular G43.
Loaded?
Absolutely.
One in the chamber?
Absolutely.
Did you tell the deputies here you got concealed weapon on you?
My sheriff in both counties encouraged me to carry because sometimes there's not a deputy in the courtroom, and it's my job to protect the judge. And I go to qualifications with my officers every year. And
Got it.
I do the same test, and I practice every 2 months. Yes.
Got it. So all this about you being scared, and you packing a 9mm with you, and you probably had that on you when all the other times, too?
Well, no, not one of them.
Well, on the events that you talk about, July 29th, were you packing that day?
That is the one day I didn't have it.
Didn't have it.
Mm-hmm.
But the September 9th, this other one,
Yes, I did.
in the elevator, that you had that firearm on?
Absolutely.
Okay. You said now that on page 2 of your motion, September 9th, 2024 meeting, said you saw Dr. Spee's video of the meeting, and you characterized Mr. Irvy's speech at the meeting as yelling. You've said that over and over here today, right?
Yes, I feel he yelled. It's a personal objective.
Excuse me?
It's personally objective.
Personally objective. What are you trying to say? What is that?
You might think something's not yelling, and I think it's yelling.
Right. So.
It's objective.
Yes, and you think that whatever volume that video showed, whatever that volume was, you say it's yelling.
Yes.
Right. So it'd be fair to say every time you say yelling, we can go to that video and listen to the audio, and in Gillette's mind, that's yelling.
It was.
Okay.
He elevated to the point of telling him to get out of the way.
You say he lunged at the door. Now, you allege this from what? You didn't see him do that.
As I turned around to shut the door, I saw him jump out for it to pull it, and you can see it on that video.
You say he lunged.
Mm-hmm.
Okay. And, there's a security camera on the other side of that door, isn't there?
There is.
You didn't put that into evidence, did you?
Nope.
Because it would have shown that you tried to hold that door closed.
Nope.
And those security cameras don't have audio, do they?
No, they don't.
How did you get access to those security cameras?
The same way you can subpoena ducis tecum.
And you subpoenaed those personally?
I subpoenaed the sheriff, subpoena ducis tecum, through the legal process of the court, asking him to bring the specific videos. You can access that subpoena on Odyssey.
In the subpoena that you say that you submitted, it has a ducis tecum to it?
Yes.
Bring all the videos. And you're saying you hadn't reviewed those until the day that he brought them here?
Correct.
Okay. And how many you didn't make an open records request for them, did you?
When you subpoena an officer...
All I need is a yes or no.
Oh, no, don't have to.
Okay. And how many videos, security videos, did he give you?
The one I specifically subpoenaed the time frame for.
How many? I saw a bunch on that laptop. How many did he give you access to?
Just the 1 hour of footage. Now, if you want me to explain how the system works, I can explain those.
Okay. You're telling me he only gave you an hour's worth of various security footage on different cameras?
There's 4 cameras for the hour.
At a certain time. Okay. And you say in your motion that Deputy Love heard this loud bang and he came upstairs to see what was going on. Remember?
Correct.
But the video doesn't show that, does it? He never came up there at all in terms of that bang, correct?
I went off of what he told me when we talked for my part of the investigation.
All right. So you know that's not true.
I never looked at the video.
You know that's not true what you alleged. He didn't come up there, did he?
I found out the same you did in his testimony.
Let's admit it's not true. Can you just do that?
I went off of what the deputy told me at the time that
Right.
we had my
Fine,
investigation.
fine, don't admit it. But it's not true, right?
He said he went to the bottom of the stairs.
No, you said he came up the stairs. You know that's not true. Correct? You said...
Asked and answered.
Yeah, you haven't, okay. You said that Mr. Irving was screaming profanities and name at me the entire time behind me,
Yes.
right? And you think that's substantiated in the video?
I think he yelled at me all the way up the stairs.
With profanities.
Did
didn't do
you
that, did
not hear your client scream bitch at
Did you
me?
not argue with me? You're saying he came up the stairs yelling profanities?
Yes, he said bitch multiple times.
Oh, as he came up the stairs.
And
All right.
asked me about the dog multiple times.
Now, Judge, I need to take a break. I've got that telephone.
Yes, well, we're in recess until Mr.
Baker.
Baker, excuse me, trying to read and...
No, I got
At the
it.
same time. We're in recess so you can take care of your hearing.
Thank you, Judge.
We'll reconvene when you're back. We're back on the record. Ms. Gillett is on the stand. Defendant and counsel are present as well. It appears that the sequestrations are still out of the courtroom, so we'll proceed.
Yes. You referred to someone as your husband, and then in one of these motions you talk about a boyfriend. Is that the same person?
No, I'm divorced recently.
Okay, so the man you're talking about as your husband, you're divorced from now.
Yes.
Right. And then this boyfriend that you talked about, that's somebody subsequent to that.
Oh, yeah.
I'm going to hand you, if I can approach, Exhibit D, which is what I call the Walker motion. And you recognize Exhibit D?
I do.
And in that motion, you characterize both Mr. Irving and Dr. Spies as media.
Yeah, they believe they're media.
You characterize them as media, correct?
Because that's how they define themselves.
Okay. In fact, you claimed they didn't conduct themselves as local media, correct?
No.
You don't think you said that the local media did things differently than this media?
Maybe
That
I misunderstood your question. They're not local media. They're not from here.
No, I didn't say they were local media. You said that this media didn't do their journalism the way that this local media conducted themselves in that motion, correct?
Correct.
Okay, now, and you asked for a restraint of media, which was in part Mr. Irving and Dr. Spies, if you look at page 3.
Correct.
Against the media and against the news agency in page 5, correct?
It's a partial restriction request.
It's still against the media and news agencies, which you characterize as Mr. Irving and Dr. Spies, correct?
Yes, and I'm going to object to these as being irrelevant. They have to do with the Walker case. They don't have to deal with the physical.
Well, I'll explain that. It's relevant.
Okay, there's an objection. If you have a response.
I do. Media, we have an ability, it goes to the legitimate purpose of what they're doing.
Okay, well, in regards to Exhibit D and the questioning, the objection is irrelevant to these proceedings. Your response?
Are you talking to me, Judge?
No?
To me, Judge, the issue is, you're going to be considering what is a legitimate purpose. She's a public figure, and put aside Mr. Irving and Dr. Speeds, they are media. So media has a,
Well, hold on. The objection is overruled. You may proceed.
and you identify this media news agency as the Kansas Freedom News, Richard Smith, Lawrence Accountability, Dr. Justin Spees, and Michael Irving on page 5, correct?
Yes.
You mentioned privacy. You worried that something Mr. Irving has done has revealed your home address?
Yes, he put my tag out on his live stream.
Your home, and you think that's a basis why the judge should grant your motion here today? Yes?
Part of it.
Okay, but
It's not the primary basis.
no, get it. But it's still, you think your home address is private. And that's one of the things you think Mr. Irving did that was incorrect, correct?
Absolutely.
Do you file for elected office?
I do.
And when you make that application, don't you have to submit your home address?
I do, unfortunately.
And that's a public record, isn't it?
It is if someone requests it.
Okay. So your residential address is not private, is it?
It's not, it is on my election paperwork.
Yeah.
But that's not on mainstream media.
You don't think he couldn't publicize what you filed as a public record, your address? You think that's wrong?
He could request it, and if he put it out there, it would be an issue, but
An issue for you,
it is a public record to get.
and that's one of the things you think he's done, which is the basis for your motion here today, correct?
He put my tag number out there.
Asking about your residential address.
He gave access to that, yes.
Now, how do you know that he gave out your residential address?
Individuals let me know that he had been filming me and they saw it.
Okay, okay. And then as far as, you say that no one can photograph you or your vehicle on Elk County property? Is that your contention here today?
I think that I could be photographed in a lot of places, but that's not the sole basis, and that's not in my petition.
Object as non-responsive. Are you
I'll object as to
Hold on.
relevance.
If there's an objection, wait for me to make a ruling. The ruling is, or the objection is sustained. Please keep your answers to what has been questioned.
You need me to repeat the question?
I'm going to object to anything regarding this motion in the line of questioning is not relevant as to what is in the petition for protection.
You say that no one can photograph you or your car in public,
I believe
correct?
the judge has to rule on my objection before we go further.
All right. The objection is overruled. The part of the test that this case has on stalking is going to be course of conduct. Constitutionally protected activity is not included within the meaning of, quote, course of conduct. So if there's arguments in regards to constitutionality of things, I'm going to hear it. But let's please stay on point.
Okay. Well, my contention is you think that photographing you or your car on Elk County property is private. Isn't that correct?
It's an invasion of privacy.
All right. And you don't think anybody should be able to photograph you or your car that's parked down there in that Ford, whatever it is that you're driving, that I saw. Isn't that correct?
That's not what the motion says. So no, you're not correct.
How about photographing you in your car? Does that violate your rights as a public prosecutor, the chief Elk County law enforcement officer?
It does not, but that's not what the motion is about. You're mischaracterizing the motion.
You go on, you say in that motion on page 8, you say that you have to have thick skin because you're a public official, correct?
I do.
and that you should accept derogatory language. You say that.
I do.
And then you go on to acknowledge that you are different from clerks. The line is far narrower for them, right?
That is correct.
So in your Jill Gillett world, you ought to be able to bear up under more derogatory remarks and say a non-public official, a clerk.
That is correct, because that's the law.
You obtained Axon and security camera footage. You've said that you got that through a subpoena. Is that correct?
Absolutely.
And you're testifying here under oath that prior to his delivery here in this courtroom, that you had not reviewed any of those Axon or security footage. Is that correct?
Absolutely.
And that footage that you had was on a laptop that you had in this court?
No.
When I saw you with the footage, and we were looking at the files on that, of that security footage, you're telling me that's not the footage?
It was on the thumb drive the sheriff brought me. It's not on my laptop. No, it was not on my laptop.
Okay, it was on a thumb drive. And do you have
Absolutely.
that thumb drive that was subpoenaed?
Absolutely, the sheriff brought it.
And the laptop that you were using at that, who owns that?
It was just purchased for my use at Greenwood County.
Elk County, okay, so county owns that?
Yes.
Okay.
We just bought it.
If you look at that Walker motion, you mentioned 2 core requests on page 3.
Yes, he sent some CORA
Ms.
requests.
Nita, yes. You filed those as exhibits in the Walker case?
I'm not sure if I have or not.
And they were the core requests from Mr. Irving?
He did make CORA requests.
Were those 2 core requests you referred to in that motion, the Irving core requests?
Yes.
Okay. Now, you said those needed to be sealed in that motion, in that case, right?
I did ask for them to be sealed in that case.
And they were sealed.
They are now, yes.
But in this case, you went ahead and revealed those same documents, correct?
Not the responses.
The requests. You revealed the requests.
No, you're mischaracterizing the question. I'm going to object to mischaracterization.
Okay, counsel, I'm not sure where we're at here.
Well, here's the thing. We're talking about what is private and what is not. But I'll move on.
Right, question's withdrawn.
All right. You complained in the Walker motion that the request could get video footage of the live streaming to the courthouse on security cameras of Elk County in page 3, correct?
Correct.
You said those are not public videos.
They are not?
Why did you publicize that video, security video, in this proceeding here if it was not public and should have been secure?
That's why I asked for this proceeding to be sealed, and you can subpoena at any given time the subpoena of the Ducis Tecum to bring security footage to the court, but I asked the judge not to give you a copy and for it only to be used for this court hearing. That is sealing it to this court hearing, which is a PFS and is not readily accessible to the public.
You think this proceeding is still closed with all these witnesses?
As far as security purposes are, it's not being put out on the media.
Okay, let's do this. And you said it's not footage for a case in that motion, correct?
Correct,
But
absolutely.
it is footage for this case.
If someone were to subpoena, it could be
You used it as footage for your case, correct?
through proper courtroom procedure.
And you said in Walker, if it was given to the public, it would allow individuals to know exactly where the cameras are, what they view, and how they plan or plot a security breach, right?
Correct?
And you just played a video that you said would do all of those things in open court, didn't you?
During a protection from stalking.
Counsel, how is that relevant to the stalking case?
Because it goes to her credibility, Judge. She makes a statement in one court and says, oh no, this is all, but when it comes to her personally, all rules are off and she gets to disclose any and everything. So it's an inconsistent statement. It goes directly to her credibility.
Counsel, are you saying that when there's a trial and things that may be not open to the public, they can't be used as an exhibit in the trial?
What I am saying is she made affirmative statements to the court saying you can't show these security because it's going to, everybody will terrorize us and all that. Yet when it comes to her own personal interest, all bets are off, and then she enters it as an exhibit in a public hearing. It goes to her credibility. Which one is true?
Okay, you've made your point. Let's move on.
All right. On November 6th, you said that video that you entered was a continued course of conduct?
Yes.
The continued course of conduct was Mr. Irving going to the clerk's office? That's what we saw in the video.
No, his continued course of conduct was coming towards me at the trial.
And you're not telling the court that Mr. Irving doesn't have a legitimate reason to go to the Elk County clerk's window, are you?
No.
In fact, he has a legitimate reason to be in this building, correct?
Kind of, yes.
And you say what?
Kind of.
Kind of. Kind of has a legitimate reason.
Yes, kind of.
Okay. But he still has one.
He has an interest in the Walker trial. I don't believe that it's appropriate for him to be here to harass me. I don't believe it's appropriate for him to be here for other reasons.
I'm not asking about any of that. I'm asking about legitimate reasons. He has a legitimate reason to come to the court and go to that clerk's window and ask about documents in this case, doesn't he?
He can.
And that's a legitimate reason, isn't it?
That would be a legitimate reason.
Okay. And in fact, he has a legitimate reason to come and watch trials as a citizen,
Yes, he may.
as a journalist.
Yes, he may.
All right? And he has a legitimate interest in talking to the county prosecutor and the chief law enforcement officer about charges that may be pending against him.
If it is an actual charge of pending against him.
He has a legitimate interest to find that out, doesn't he?
In a proper form, but you can't hide an improper action in a proper one.
Yeah, okay, that's what you say, correct?
Correct.
All right. And let's look at your emails. And I've got them marked as Exhibit A.
Absolutely. They're up here already.
And it's A.
Yes.
All right, now, are these a repeat of what's been marked as,
Yes,
they're
identical.
In a way, these are in chronological orders. Hers are not. So this is chronological, and I want to go through the chronology. But they should be a duplication. This is just in chronological order.
okay, thank you.
And Judge, I move to admit these exhibits that I've,
Okay, which exhibits?
A, B, C, D, G.
I only have A, D, and G. B was already admitted, it's a video. B1 and 2 are 2 videos.
G was a Sampson. It's you could take judicial notice of it, but
We only have A, D, and G, and B was already admitted.
C is your complaint.
Okay, defendants A, D, and G. Now, some of these have exhibit stickers and some do not. What are the ones with the exhibit stickers?
I think the witness.
I have them.
Okay, so A, D, and G is what I have, and the G I have is not the exhibit sticker, it's a copy of that.
And then I have,
Are those the ones that are offered now?
and then I have a C that's the complaint that he handed. It's the petition.
I'd move to admit those.
Any objection to those? Those are admitted. So A, C, D, and G defendants are admitted.
All right, so if you look at A, those are comprise the communications that you say exist from Mr. Irving to you,
Absolutely.
okay? July 3rd is the first one.
Yep.
You're claiming, and then the second one is July 9th, correct?
Yes.
And you identified those two emails as one of two course of conduct events that substantiate your complaint, correct?
No, they're just examples to the judge.
Well,
They're part of the complaint, so the judge could see all of it.
I don't need to have you argue with me. You said in your complaint, you listed incidents, and then you listed 9. Isn't that correct?
They are conduct. They are contact with me.
They are the course of conduct and that you list. You list 9 course of conduct events, correct?
Absolutely.
Okay, so let's talk about the first 2 course of conduct events that you claim support your petition. The July 3rd email and the July 9th email.
Yep.
You claim that each one would cause a reasonable person to suffer substantial emotional distress. Correct?
I don't allege that in my complaint that those specifically cause it. I just say they're part of the conduct.
Okay. So to be a course of conduct, you know it has to cause a reasonable person to suffer substantial emotional distress, correct?
Correct. But I'm not going to hide something from the judge.
So let's just admit. So neither the July 3rd nor the July 9th email, you're not claiming they would cause a reasonable person to suffer substantial emotional distress, correct?
No.
You agree with me?
Oh, yeah.
And they wouldn't place a person in reasonable fear for his or her safety, correct?
No.
You agree with me?
Sure.
Okay. And you agree with those emails was not conduct that, quote, seriously alarmed, annoyed, tormented, or terrorized you, correct?
Right.
You agree?
Yeah.
And that you're not claiming that they didn't have a legitimate purpose,
Nope.
and that they were, in fact, protected activity.
He could email those emails.
All right. And so, well, let's keep going. So, July 3rd and July 9th, he hadn't done anything in your mind to constitute a violation of the stalking statute, correct?
Not yet.
Okay. Well, let's keep going. How about July 21st? You listed that as an event.
There is information in there that would alarm someone.
Well, let's talk about that. You're telling this judge this email would have caused a reasonable person to suffer substantial emotional distress. Is that what you're
Pardon me,
claiming?
counsel, I want to be sure I'm looking at the same thing. This is D, or no?
Yes, it's Exhibit A,
A, all right.
and it's July, and I've got it greened out.
It has an X at the bottom
July
of the
20.
page.
Yeah, July 21st.
Okay, thank you.
All right.
I'll let you know.
So, July 21st, you have an email that's captioned Cora Request, isn't it?
It is captioned Cora request.
Okay, and it's from Lawrence Accountability, correct?
Yes.
That's that media news outlet that you identified, correct?
Yes.
And then it's addressed to all the commissioners at their official email addresses, correct?
It is.
And then one's to the sheriff at his official address.
Yes.
And then there's another one, Doug Blacks at the Kansas House KS Gov.
Yes.
And then there's a one to the Senate official email,
Yes.
correct? And it's one to the CO attorney at Elk County's org.
That is
And
correct.
that's your official email address, correct?
Yes.
And you're not claiming that Mr. Irby ever emailed you anything to your personal email address, are you?
Nope.
Okay? And you're claiming that in this core request, are you telling the court that he didn't have a legitimate, that the media didn't have a legitimate interest in making a core request?
I'm going to object because that's mischaracterizing what's in the email. He has the right to make a CORA request.
Overruled, you can answer the question.
He can make a CORA request.
That's legitimate.
A CORA request is.
That's legitimate.
Correct.
Okay. And in it, he says, he's talking to them about certain situations. And he has a right to email and talk to these representatives, doesn't he?
He can email and talk to representatives.
And that's legitimate, isn't it?
That part is.
Okay. And where in this email are you claiming that something in this core request would cause a reasonable person to suffer substantial emotional distress?
It's not about substantial emotional distress.
I'm asking that question. Where, if any, would what he said would cause a reasonable person to
I'm
suffer?
going to object because you're trying to use a legal definition in the question, and that's
No,
trying to
no.
make an argument.
The objection is overruled. If there's something in here that, if it doesn't show something that believe that meets that description, then you can say so. If it does, then you can say that.
So in here, he
So
says,
I asked that question. I want you to identify if it is something that he said.
absolutely
Let
yes.
me finish.
Okay,
he said.
hold on. Now, counsel, you're both experienced. You know the rule. One person talks at a time. So wait until he asks the question before you speak. And when she speaks and answers, then don't interrupt. So we can't have both attorneys speaking at the same time. Please, let's go.
Thank you, Judge. Here's my question. It's very discreet. Identify where in Exhibit A on the July 21st email where anything that Mr. Irby said would place a reasonable person to suffer substantial emotional distress.
So in paragraph 2, he says, I and my associates are not uninformed rural folk who will go along with your lawlessness, nor will we just go away. That was assured for you by the lies Gillett enunciated in Judge
I don't need
Ricky's
it to
courtroom.
read. He's not asking you to read that. If that's a portion that you believe is responsive to what a threat is or however it's phrased, then please tell us that, what the concern is.
That part coupled with the behaviors that were happening.
Not asking about behaviors. I'm asking about something, this email only. So you've read something you say that would cause a reasonable person to suffer substantial emotional distress. That part you just read, you're claiming that would do that, correct?
It's not just it, but that adds to it, yes.
I'm asking only about this email.
That part bothers me, yes.
I didn't ask if it bothered you.
Yep.
Not asking that. That's not the standard. You realize that. Just because he bothers you doesn't mean he's stalking you, right?
That part does.
Well, other than bothering you, can you identify then anything in that email that would cause a reasonable person to suffer substantial emotional distress? Yes or no?
That part does, yes.
Okay. Anything else? And while let me withdraw that question. The reasonable person is, who are you saying this would cause substantial emotional distress to in this email?
Me.
You. Okay. Now, let's ask the other one. Where in the email would place a person in reasonable fear of his or her safety? What did he say in this core request on July 21st?
That same section.
Okay? All right? And sending this email, you claim was conduct that seriously alarmed, annoyed, tormented, or terrorized you. Correct?
That section and the last section where he talks about the other threats.
And you're claiming that nothing he said in here serves a legitimate purpose or was protected activity. That's your claim here today.
No, part of it can be.
I'm asking what part, if he had a legitimate purpose and it was protected activity, what part's not?
Those parts that he goes into. The second paragraph beginning and the last paragraph.
The one you read.
The one I read in the last
The
paragraph.
last paragraph, in closing, you can choose to use lies and hyperbole to attempt to turn our words or actions into some sort of threat. That sentence,
Yes, the last paragraph.
I just read the first line of that last paragraph. That one causes a reasonable person to have substantial emotional distress,
Yep,
and they're in fear of their life,
yep.
and that has no legitimate purpose, nor is it protected activity in your world, right?
No legitimate purpose.
And then he says, I strongly encourage you to pursue all true threats like the one mentioned by Jill during the hearing.
Again, counsel, like I told her,
Okay.
I don't need it read into.
All right. Do you know if he's even talking to you?
I'm one of the people who the audience is of that email.
Okay. All right. And he said, all right, let's move on then. So now we've got one course of conduct that you say occurred on July 21st, and then we have the July 29th meeting,
Yes,
right? So as of July 29th, you have two events that you say meet the statutory requirements of bringing a stalking claim against Mr. Irving, correct?
beginning to yes.
Well, that was nice. Beginning to, or does it?
I felt it really met the actual, what I feel is the letter and the meaning of the statute when he caused physical contact with me.
Okay, so having said that, you've got two events that you claim meet the statutory requirements as of July 29th. Isn't that correct?
I could, yes.
And you didn't file anything as of July 29th, even though you claim you were terrorized and emotionally distressed and in physical fear of your harm, right?
Correct?
So let's go on. July 29th. You sought, in the Wonker motion, you sought all kinds of ex parte relief against Lawrence accountability.
Let me interrupt here. Okay, it seems like we're getting into a little different area. It is almost noon.
Okay.
I'm going to recess until 2 o'clock or soon thereafter as my hearing is done and we can begin, and we'll pick up with that. We're in noon adjournment.
Judge, do you want the exhibits left up here?
If they have been marked and, if they've been marked, yes, they need to be left with the court. If they've been mentioned, not necessarily admitted, but most of these have been admitted. But if they've been marked and mentioned, I need to keep them at this point. So if counsel have those, please bring them to the bench and we'll keep them here.
Well, that would be here.
Yes, both of you can. All right, we're back on the record in Gillett versus ERAVI, case number 24DM17. The appearances are the same as stated before. Ms. Gillett, I believe, is still under cross-examination. We'll take the witness stand. You continue to be under oath. And Mr. Baker, once she's settled in, you may begin.
Thank you, Judge.
And Judge, you have the exhibits if he refers to any.
Is there particular ones that you need to have out?
Ms. Gillett, you mentioned that you didn't think Dr. Spies had violated the statute, the stalking statute, and that's why you didn't pursue any claims against him. Is that correct?
That's correct.
In the Walker motion, you did want lots of different relief against Mr. Irving and Lawrence Accountability and Dr. Spies and the other media people, right?
Anyone not complying with local rules.
It's terms of those you wanted relief against them.
I wanted them to not videotape the trial.
You wanted the relief that you stated in that complaint, yes?
It's a motion, and there's lots of relief requested there, including increased court security and other issues.
I got it. So this will go a lot faster if you just tell me yes or no, and I don't have to keep asking the question. So I'll do my best to be direct if you'll do your best just to give me straight answers. Will you do that for me?
Then I'll start objecting as misconstrued questions.
All right. And in that Walker motion, you wanted them to be fined, Mr. Irving, expenses for change of venue. You wanted them restraint of speech. You didn't want them to be able to publicize. Is that correct?
There's numerous reliefs in there.
As far as what I said, are those things correct?
I don't know if it was specifically them fined, but the defense and/or parties violating.
I can read it for you if it's going to be an issue.
Counsel, D has been admitted. I can read the motion.
Okay, and all I'm saying is, we're just going to get to the next set of questions. You knew what they were talking about when they walked up to you on July 29th talking about those charges.
Where?
July 29th. They talked about the video, the incident, where you say they're yelling and screaming profanities at you, and they mentioned that you were lying about the charges. You knew what they were talking about.
No.
And you have no idea about any charges that are being considered against Mr. Irving?
Anything that has been turned in, I am not making charging decisions on.
Well, that's not my question. You understand that he's being investigated on some charges?
He is.
Okay, and you're aware of that, and so when he referred to the charges, you don't know that he was talking about those charges that are being contemplated here in Elk County.
He repeatedly said he wanted to know if he was getting arrested.
I'm asking you.
That's all I knew is what he was asking about.
Let's just get past it. You had no idea when he said charges. You had no clue what he was asking about or talking about then. Is that your testimony to the court?
I knew that Deputy Love was going to send over affidavits, and that's it.
Okay, about some charges.
About him. It
About
doesn't matter whether
misdemeanor.
it's a charge or whether it's an affidavit.
Okay, and that is a foreplay to a misdemeanor disorderly conduct, right? Citation, right? You're aware of that one?
Officers don't charge. They request charges.
You're familiar with the request to charge Mr. Irving with a misdemeanor disorderly conduct then?
I knew one might come.
Arising from the July 29th meeting, correct?
The July 29th meeting is what they were asking me about. That's
So now you
when
know.
they were asking me.
So the charges that he's talking about referred to this misdemeanor citation that had been submitted to your office.
Okay, I'm confused because you're kind of like mixing stuff up.
Okay, don't worry about it. Let's just move on.
Okay.
You don't know, so let's move on. July 29th, we're looking at Exhibit A, and we're looking at, you said that July 21st, rather, and we've gone through that, and then you said that one counted, that met the statutory requirements for stalking, correct?
Can we pause for a second?
No.
Judge, these are your notes on the petition. I think they're backwards.
All right, can the bailiff get those, please?
I don't want to look at anything the judge wrote.
Okay, yeah, this is my copy of the, working copy of the petition where it's some highlights and underlining, so.
Is that the petition up there on the bench?
I believe that it's A, I think I gave that to council, and I may have given it to you.
A, you got A.
No, there's not an A up here.
Those are the emails.
I got the emails, okay.
That's okay. You got the emails, that's all.
Okay.
All right, so we're back. July 21, you say met the requirements for a course of conduct, correct?
Yes.
The next event in your complaint, in Exhibit A, is a August 18, 2024
Yep.
email, correct?
Yep.
And in that email, are you saying that met all the statutory requirements that are stated in that statute?
Well,
Yes or no?
I'm going to object that that's like misleading question.
Okay, well, you're the one that claimed this was an event. I want to know, and an event has to contain certain statutory elements. You know that, don't you?
It does.
So this August 18, 2024 email, does it contain all the statutory elements to constitute a course of conduct under that statute?
It doesn't have to meet every single, little one,
Does
it
it
can be
meet-
one.
Counsel, hold on, excuse me. Isn't this a rule, something that the court will need to determine if it meets that test?
I'm not asking about this. I'm going to be asking the question is, once we get to two, we've got two course of conducts that she thinks meets the statutory requirements. I'm going to ask another question. Why didn't you file? So that's why I'm trying to get to it. And if they don't meet it, Judge, why are they listed as events in the complaint?
All right.
So, August 18th, you're going to say it doesn't meet all the statutory elements.
I'm going to say it meets some of the statutory.
Well, let's answer my question. It doesn't meet all of them, does it?
It's responsive.
Okay.
Move on.
And which ones does it not meet the requirements?
Well, it's not a physical, it's a verbal, and it does have some verbal threats in it that would meet the verbal threat.
Which one? That puts someone in apprehension of fear?
Yes.
What statement is in there that puts someone in apprehension of fear for your life?
Why does he send it to me? Not a good strategy. Videos are a spotlight. Shield against illegal arrest. Conspired retaliation. There's all kinds of stuff. It basically is a rant from him.
Okay, and you think that puts you in fear of your life?
It's one of the elements.
You think it puts you in fear of your life?
It makes me in fear of bodily harm.
And you think those statements then would cause a reasonable person to have substantial emotional distress?
I think that it causes
No, that's my question.
heightened
You're not answering my question. I ask if it would cause someone of a reasonable person to suffer substantial emotional distress. Yes or no?
Yes, coupled with everything else.
Well, coupled with what else?
Physical action that follows it.
In this email.
The physical action that follows it.
Yeah, I'm not asking about the other stuff. This one event that you say, standing alone, which you said was an event, you say it doesn't meet all the statutory requirements, correct?
It
doesn't meet all the statutory correct.
Objection, okay, hold on. Counsel, we keep seeming to go over the same territory. Obviously, it's a course of conduct. The witness can testify as to how she felt, whether or not that is appropriate or should be a reasonable standard is really for the court to determine.
Well, Judge, here's the thing. I think I'm entitled. If she says, and she listed each one of these as a course of conduct event, each one stands on its own as being sufficient. You got to get two. And so now she's saying, well, it doesn't contain all of them. Well, why did you list it as an event then, if it doesn't meet all the necessary elements? And then I'm trying to say, well, which ones it didn't meet. So, and the whole thing is here, you've got a chronology. She says, well, I've got all these events, and I got 4 events, and I still haven't filed one. Okay? Why? If you're so terrified, why?
Hold on. I think it's fair in regards to asking what events that she did. Trying to go through everything that it's not will take forever.
Well, and that's my, yes, it is. And so I'm trying to, we've already cut out 2 that she says don't meet. We've got 1 now, she says it did. We've gone through that. This one she says is incomplete. I guess I can leave it at that if no one's curious. But, okay, so this one doesn't meet all the statutory elements. So, okay, let's talk about another email. We've gone through 4 events. Let's talk about April 18th, the next one. No, I'm sorry. Let's talk about September 9th. There's a September 9th email. Records received today. You see that?
I do.
And it's to, who's Paul Dean?
Paul Dean's the county counselor, and he's the assistant in Greenwood County. He does the traffic only on Fridays twice a month.
And all these email addresses are all official email addresses
They are?
of county officials, correct?
Yes.
Including you.
Yep.
So, are you claiming that this email meets all the statutory requirements of a course of conduct? That would be a yes or no.
Yes, the last line.
Yes, it does?
Yes.
So tell me where in this email where it causes a reasonable person to suffer substantial emotional distress. The language, just quote it for me.
Because he had already physically assaulted me, yelling about ducks all the way up the staircase, so bringing them up again makes another threat through
Hold on.
2
Hold count.
prior thing.
Please. He asked what section here? So
The
you,
last section,
which is what?
where it says, "and Jill."
Okay.
So read the sentence you say causes a reasonable person.
Objection. The judge has already said not to read them. He can read them himself.
I just don't know which one it is. Is it the last verse, it says, Jill, I really do have a lot of questions about your obsession with ducks. Is that the sentence you say would cause a reasonable person substantial emotional distress?
It does.
Okay. And that would put someone in physical harm of their safety. You think that too?
This is to be subjective from my point of view, and yes.
Okay. Yes, okay. And so now we've got 2 events that you say meet the statutory requirements. How come you haven't filed for a stalking injunction?
Because the behavior continued after this.
I thought you were scared. I thought you were terrorized. I thought all those things were happening, and you've got 2 of them.
Oh, one question at a time. If you're going to ask a question, one question,
All right.
and answer.
All right. So you're telling me you had enough to file, but you didn't do it, right?
Absolutely.
Okay. And so, and then now we go to and you don't think he has a legitimate purpose in asking you about a duck?
Nope.
Because
It's not his business. It's my personal life.
even if you stole the duck?
Did not steal the duck. It's been explained.
I know you say it has, but if you had stolen a duck, or the police come to your house about a duck, that's a matter of public concern. You'd agree to that, don't you?
Nope.
Okay. Let's go to September 26th. Let's go to the September 9th meeting. And you've already described that, right?
Yes.
And let's go then now to the September 26th email. You say that meets this email, somewhere in this email, it causes a reasonable person to suffer substantial emotional distress?
Absolutely.
Okay. Is it some parts or all parts or which part?
Several parts.
You want to identify them for me?
The title alone is The Catalyst Is You.
Which one? Oh, that one? Catalyst of what?
You ask your client. It
I'm asking you, what did you
It could be
interpret?
taken a number of ways.
I get it. What would that cause emotional distress about? A catalyst of what?
He's blaming everything that has to do with Robert Walker's case, all of his behavior, on me instead of himself and his own behavior.
Right. And you can't, that's not something a county prosecutor can hear? Yes or no? You can't hear
Combined
that?
with a physical aggression against me, yes.
That statement right there, just in standing alone,
Yes, subjectively, to my point of view, yes.
county prosecutor shouldn't be able to listen to that kind of stuff, right?
No, I see it all the time, but this is different.
Okay, so you see this language all the time, and standing alone, that wouldn't cause substantial emotional distress.
But
Right.
subjective to him physically having contact with me, it does.
You'd like to tack on something else that happened outside of this one event, and you say, well,
It's a course of conduct.
let
Part of
me,
the course is the prior conduct.
you said this email was a course of conduct, right?
It's one event. The course of conduct is all
I
of them
didn't
mashed
ask that.
together.
All right, here we go. And of course, each one that you've identified here in the email, you say that would seriously alarm, annoy, torment, or terrorize you as a prosecutor and the chief law enforcement officer of Elk County, right?
His course of conduct does, and I think it's intended to.
Okay. In the July, in the complaint, it's either in this complaint,
I don't have it in front of me.
hold on, you identify Robert Desmond.
Yes.
That name sound familiar?
Yes,
You say that he made a physical threat against you?
he did.
And is that something that you're saying Mr. Irby is responsible for? That'd be a yes or no.
Kind of in a roundabout way.
Kinda. And you say because, and you're not saying that Mr. Irby made that threat, you're saying Robert Desmond made that threat.
He did.
Okay,
He's a follower of theirs.
I see. And so anybody that reads a newspaper ad or a newspaper story, in your world, they can be attributed to the author of that newspaper.
No, but I think you can incite violence. That's what the president was charged with.
Oh, I see. All right. And so, okay, you might just hold on. And you didn't file anything against Robert Desmond, did you?
Do I?
Robert Desmond.
Have I charged him?
Have you done anything about him?
No.
Why? He's the one threatened you.
I don't believe he lives close enough to harm me, and if he traveled this far and he did, then that would be up to my security to take care of him.
Well, when these emails came in, Mr. Irvy was somewhere else.
He comes here frequently.
Okay, I got it. And you said in the Walker motion that the officials received. There's no doubt in your mind that you're receiving these emails as an official.
Some of them not.
They went to your official email address, right?
Hiding something through the official
They
email
went-
is
I'm sorry.
Counsel, hold on. This has been gone over and over and over in regards to this being her official email. We've covered that ground many times. Let's not keep rehashing that same thing. If there's evidence of something else, then please let's get to it.
Well, she was going to tell you it was private, even though it went to her official. But okay, let's move on. And you realize the issue of possible criminal charges against Mr. Irvy is a legitimate reason for Mr. Irvy to come to the courthouse to ascertain what the charges were or if they're being brought.
It's a legitimate reason to come check it, to see if it's filed, but not to
I didn't ask
personally attack me.
Didn't ask that. When you filed this motion, November 1st, Lawrence Accountability was following and publicizing things happening in the Walker case, right?
They are.
Excuse me. You said November 1st, there was a motion in the Walker case, and then there's a petition in this case.
Yes, and this petition was filed November 1st, so
So it's a petition in this matter.
That's what I'm saying.
Okay.
So prior to the petition being filed in this case, November 1st, you were aware that Lawrence Accountability was publicizing lots of things about you and the Walker case.
I
correct?
am.
You were.
Yeah.
And in the Walker case, and well, let's strike that. So we've identified numerous events that you have said met the statutory requirements, but you still didn't file your complaint until November 1st,
Yep.
correct?
Yes.
And one of the things that happened in the Walker case prior to November 1st that you got bad publicity on was a thing called Bill of Particulars, in which Judge Rick said your work was sloppy. Isn't that correct?
That has nothing to do with this and is irrelevant.
It's
Answer the question.
He actually said my staff's work was sloppy, not mine.
All right, that's responsive.
okay. And he also then, you didn't get that Bill of Particulars in time, correct?
That's correct. I was in a jury trial.
And he then said count one on the disorderly conduct, it got booted from the case.
Objection relevance.
It goes to the timing of and why you're doing what you're doing.
Overruled. You may answer the question.
It has to do with the email received by Mr. ERAVI on October 30th.
It has to do with the fact that when that happened,
Nope.
hold it, let me finish. You got this bad ruling, you got embarrassed, and they publicized it prior to November 1st, and that was the straw that broke the camel's back, wasn't it?
Nope. It was
You
an
filed
email.
on November 1st, after that happened, after they publicized this, didn't you?
Nope.
You did file this on November 1st after they published that, correct?
I filed it November 1st after he emailed me on October 30th, and I received it November 1st in the morning when I got to work.
And and you keep up with that, because you were aware of that publicity that was being sent out about you.
I don't watch any of their stuff. It was the email that was the trigger.
I see. You don't know anything about his live streams? Is that your testimony? The things that they were, the media was publicizing about Walker? You're saying you just didn't know?
I don't watch it.
You didn't know?
Period, ever.
Didn't say you watched it, you knew about it though. Somebody may have told you.
Nope.
Okay? So you just were completely ignorant of the things that were being publicized through Lawrence Accountability. That's your testimony here today?
Yeah, I don't care about their website.
I thought you were aware of it. And that's why you said, hey, they're public. Okay,
Asked and answered.
okay.
Sustained.
Now, you filed it on November 1st, the electronic filing. If I see it here. Says it was filed at 4/24/2024, November 1st, right?
Yes.
Where were you when you uploaded that?
His petition, at what time?
4/24, November 1st. It says you uploaded it. Where were you?
I think I was in Greenwood County.
At the courthouse?
Mhm.
Okay. And you use courthouse facilities to do that?
I used my office.
That would be a courthouse facility, wouldn't it?
I was in my office.
Yeah. Your county office.
Yes, I'm an elected
Okay.
official.
And you can't upload unless you have a bar number and you're in the system, right?
I used my personal bar number.
Yes. And pro se litigants can't do that. They can't just, unless they are registered in the system, they can't upload documents into the system, right?
They can if they apply for an account, yes.
That's right. And so when you used that, and where did you, the motion that you made, where did you create that at?
Well, the motion is filed in a criminal case, and I did that in my official capacity.
The motion for this case, where did you,
There isn't a motion in this case.
the petition?
The petition in this case was written by myself on my personal time,
On what equipment?
on my laptop.
That's owned by the county.
The one laptop, yes.
Okay. And did you do it all in one sitting, or did you do it over a period of time?
A long period of time.
And that was on that same laptop?
Yes.
And so you're saying that, when did you think you first started drafting this petition?
After the, it wasn't after the physical grabbing the door.
That's July 29th, right?
Yes, it was after the physical grabbing the door.
July 29th.
It was probably around August 15th or so.
What makes you say that, August 15th? Why that date?
It was somewhere in the middle of August.
So by August 15th, you're drafting a complaint, and so you're working on it, you're putting it together, you got plenty of time, right?
Yes, I was trying to gather up all the emails that he had sent me.
Up through August.
Yeah.
Okay. The summons wasn't issued till November 4th. Why was that?
We send those to the sheriff's office when it's a PFA. It goes directly from the court to the sheriff.
Who's the we?
Well, the clerk's office does. They send it over to the sheriff to have service done on it when it's a PFA. So it's whenever the sheriff gets it from the clerk. I have no idea. I don't control any of
The
that.
fax banner says Aaron Mendo, that's the clerk here,
Clerk of the district court.
and so it's faxed from her over to Douglas County.
It would have been, yeah.
How did that happen?
I have no idea. I'm not a clerk. Well, used to be, but I'm not now.
Now, and so, did you personally tell Mr. Irby that if he follows you, it could lead to stalking?
I did.
Okay. But at the point you told him it could lead to stalking, it hadn't actually resulted, correct?
Nope. It was an actual warning to let him know to stop being physical.
Now, and you know Mr. Irby always has his phone on him.
He does.
He's around you. So anything that you say he said is going to be on that phone, right?
It is.
Okay. And you say on page 4 of your sworn complaint that he knows that in person you told him that he was following me around, that it could lead to stalking.
Yes.
And when did you tell him that it could lead to stalking?
When he followed me to the elevator from my office.
What date?
That's the first instance.
July 29.
Yeah, in
Okay.
July.
Now, you indicated that in your motion, you seem to indicate that the media has to quit asking you questions if you say no comment. Is that what, did I understand that correctly?
I don't know that they have to stop, but the continued harassment is inappropriate when they've been told no comment or I'm not commenting on current pending investigations.
So in your mind, if the media says, you say no comment, and they just keep asking you questions, you think that's stalking?
I do sometimes in a way.
Okay? And that's what you're alleging here. You're saying, I said no comment, and they kept asking you questions. You said, you're stalking, right?
It's the course of conduct over months.
Got it, but just in that event, you told him, no comment, and you said, I told him no comment.
Object is asked and answered. You ask the same questions a lot, and I've answered this question multiple times today.
Okay, so anything else, because he didn't take your instruction and continued to ask you, you thought that was stalking, correct?
Asked and answered.
You think it was stalking?
Asked and answered.
All right. And you realize that the media doesn't have to stop asking you questions if you say no comment. You realize that, don't you?
If they think that that's their right, they can, I guess.
Yeah, it'd be a legitimate purpose, wouldn't it?
No.
Okay. And, you said in there, he continues to message me with no response from me. And you're talking about the emails in your complaint, correct?
Yes.
You're not talking about text messaging, right?
No.
He never text messaged you. He never called you on your personal phone. He never showed up at your house, right?
I don't know if he's been to my personal house.
To your knowledge.
To my knowledge, I have no idea.
So, and he's never emailed you on personal email, anything like that, correct?
Counsel, you've asked this.
Okay, I'm sorry. So let's talk about the duck. You said that in your complaint, Mr. Irving or his associates, and you're talking about what, the media, the Lawrence Accountability,
One of them.
have contacted someone, you said that, but you don't know, right?
I don't know who they talked to.
You don't even know if they talked to anybody.
I don't know how they would otherwise find out about a baby duck that was trusted to me to take care of.
All right, but you have no personal knowledge. You're just connecting dots, and you're just speculating.
Absolutely.
Okay, thank you. And then you say that from the Fredonia area to try to gain personal information. And that's pure speculation, because you don't know.
The only records at the Fredonia Police Department.
You don't know what they said or did with other people. You have no personal knowledge of that, do you?
Nope.
Now, in this personal information that you say was what? That you had a duck?
They keep alleging I kidnapped a duck, and that's not true. It's a false statement.
The personal information that you're alleging is about this duck. Is that correct?
That's one piece of personal information.
Okay, well, let's just keep it on the personal duck thing. September 9th, you said he brought up the duck incident. Family made a report their duck was missing and it was returned. You said that, right?
Yes.
Well, you would agree that the chief law enforcement officer of L County, the county prosecutor, has got somebody's duck. That could be stolen property.
Not to my knowledge.
Really?
It wasn't to my knowledge.
You didn't own that duck, did you?
I was called to render aid as a person who takes in animals.
Object is non-responsive. You didn't own that duck, did you?
It was not mine. I was fostering.
Thank you. Correct. You didn't own it. You got the duck, and somehow police showed up at your house about a duck that you did not own, correct?
Already been testified to. Objection.
Answer the question, please.
The police showed up to ask for the duck.
Yeah. And that's a matter of public concern, that you've got a duck you don't own, and it belonged to somebody else, and the police have to come out and get it from you. You'll admit that.
It isn't public concern.
And that, how did they, the duck that you didn't own, how did they find you? Do you know?
I do.
Okay.
I made a post on Facebook that a baby duck was lost. It was trusted to me, and if anyone knew about it, to let me know,
Fair enough.
because I am a rescuer,
Got it.
and I can even be contacted by the Department of Parks and Wildlife to do their rescue.
I got it. All right. In any event, the police came, did they take it directly from you?
Yes, I gave it directly to them.
And then they put it in the car or pickup and took it back to the owner, right?
Oh, yeah, absolutely.
And so, and then, so Mr. Irby, when he says, hey, I want to know about that duck,
Not any of his concern.
it's not a legitimate purpose in your mind.
No.
And did that cause you substantial emotional distress that he said, hey, how about that duck?
Yes.
And did that cause you to be in physical apprehension of harm, physical harm to yourself, that he asked you the question about the duck?
It gave me concern of harm of him prying into my personal life, yes.
Physical harm is what I said.
I am afraid of physical harm from him,
From that, asking the question about the duck.
from the course of conduct.
I object is non-responsive.
Yes, it is. Move on.
All right. And then you say something about slander and libel.
Are you talking about the petition or the motion?
I'm talking about your petition. I think you bring up one or the other, don't you? Where do you talk about slander and...
Yes, he's screaming in the courthouse that I'm a duck kidnapper when I rendered aid because a little boy brought a duck to someone else's home and said he found it, and they were concerned about its care and well-being until we could find out if it was wild or not. And he's screaming through the courthouse that I'm a kidnapper?
It's non-responsive. I mean, you just give it a name.
Yeah, it gives me concern.
What is the elements to defamation in Kansas?
It has to be untruthful, which it is.
Anything else?
It has to try to damage the reputation, which he tried to do in the courthouse.
Okay. It has to be a false statement, right?
It is a false statement.
And you're saying he made by asking you the question about where's the duck, that's a false statement?
Oh, yes.
In the complaint, maybe it's in the Walker complaint. Did you complain about,
The Walker complaint is not part of this, and I'm going to object to relevance. You keep bringing it up, but it's not relevant in this case.
you bring up the same issues in the Walker complaint that you...
Well, hold on. What's your question? She made an objection in regards to relevance. So your question again, please?
The question is, you made allegations of slander and libel in the Walker case.
Objection, it's not relevant to a course of
Overruled.
conduct.
Answer the question.
I don't remember if it's in there or not. That's been clear back in July. A lot of water goes under the bridge, and my sister died, and I've had a lot of trauma since then.
Okay, so you don't remember if you made that allegation. And so one of the things you claim in this petition is you claim that he defamed you or slandered or libeled you, and that's a basis to obtaining the relief in this case.
No, it's a separate issue.
But you're claiming it here, are you? Or are you?
It's an issue that he's prying into personal things.
Are you?
And misconstruing them.
I'm going to ask you a yes or no question. You've raised up slander and defamation and libel. In this case, are you claiming that is a basis for the relief that you're seeking in this case? Yes or no?
Course of conduct.
Non-responsive. I'm not asking about course of conduct.
I'm going to overrule the objection. You can answer, is the claim of...
It's part of it. I would say yes, it is part of it.
Forms a basis for your complaint.
Part of it. Part of the complaint of course of conduct.
So, November 1st, did you take a day off when you worked on that and filed that petition?
No, elected officials are different than employees. I don't know if you understand that.
Didn't ask all that.
I don't have to take a day off to work on personal things.
Didn't ask that. I just asked you if you took a day off, yes or no?
No.
Okay. And you're not taking a day off to do this little hearing either, are you?
Unfortunately,
Yes or no?
no.
No.
Because I don't have to write it down.
All right. No further questions.
All right. You may redirect.
Oh, there's a lot there. Elected officials are always on call. As the county attorney is on call 365 days a year, 24 hours a day. Even when I go on vacation, I receive calls from deputies very frequently, and I answer their questions. So, no, we do not take time off. We are salaried. We are required to work 7 days a year or something like that, 12 maybe. I work 5 days a week, and I rarely get to take time off. I have appeared from almost every vacation I have taken since becoming county attorney. So no, we do not get to take time off. So even today, I am on call. If there was a homicide today, I would have to leave and go to the scene if I'm asked to. And I do, and I get up in the middle of the night, and I spend evenings helping with search warrants, and rape investigations, and homicide investigations, a multitude of different kinds of investigations. I've spent nights up till 3 o'clock in the morning, spent all-nighters with my officers, because I am a very active county attorney with them. With that being said, no, we do not take a specified day off, because I am never off, the same as the sheriff. As that is said, when it comes to the issue of the baby duck, I've already explained what happened. It was entrusted to me by individuals to keep. Messages were sent out to see if they could locate the lost baby duck's owner, or if it was a wild duck because of its breed. I raise or can be trusted with birds that are even migratory if they're injured. I have calls of people asking for...
All right, now, I would ask you to keep the redirect to things that haven't been testified to. As you noted,
Okay.
you testified to this.
Now, it is a course of conduct, and the conduct totality with multiple events is what added up. I have testified...
Those are legal conclusions, but...
Sustained.
He asked me about whether or not Sheriff Walker gave me anything before the hearing. The answer is no. He is subpoenaed, ducis tecum, with items.
It's been asked and answered, it's just...
Yes, sustained.
With that, when I asked Sheriff Walker for specific videos, he did call to have a narrowing of that time frame, so I gave him the narrowed time frame. He obtained the videos that he had access to that I asked for in my subpoena and brought those with him to court. I, as an attorney, try to keep what is personal and official as much as possible separate, which is why a special prosecutor is asked for. So, no, I never had access to those videos, and no, I do not have access to the court system. In fact, someone once has broken into my office here at the courthouse,
Object is irrelevant.
and I never looked into it or was able to look at it. So, no, I do not access the court cameras of the courthouse. Trying to think of what else I needed to... On the Walker motion, you asked me several things. There are things that Judge Lee can look into in that motion. Most of it is heightened security, and if there is a change of venue, which Gary House was asking about, then I was going to ask, and it's in there, that if there's any change of venue, the cost can be charged to the defendant or anyone causing the change of venue. So that is part of it, and a big chunk of why Lawrence Accountability and Kansas Freedom News are discussed, and it's discussed about other individuals making threats towards us that are followers. We have had a big long list of derogatory names, some of which are hate speech, referring to Nazis, that have been called in by other individuals, and that's why none of that is alleged in the complaint, because it's not Mr. ERAVI making them, it's his followers. And I did not allege any of the incidents against the other officers, such as driving by their homes, because again, that's not directed to me, it's directed to individuals surrounding the case. And so I did not allege those. I kept it strictly to his actions against me, and that's why I feel the motion is not relevant in this case, because I narrowly tailored the incidents directed at me.
Objection, he's just making an argument.
Sustained.
I'm explaining why it's so narrowly tailored. I do not want any of the emails that he had back and forth with me to be like, oh, well, we have this email and it's not whatever. I want the judge to be able to see all of them and the complete evidence, which is why every email is included. The course of conduct heightened for me at the time that he caused physical contact with me. And I have thought all along that he would not be able to control his temper to the point that he would either lunge at me, hit me, hurt me, or bump into me. And his closeness in proximity to me, I knew at some point he would come into physical contact with me because he has a hard time to control his temper. And that is why the course of conduct added up to the point that he got so close he yanked the door out of my hand.
That concludes the redirect.
Yes.
Recross.
No further questions.
Thank you. You may step down.
May I approach, Your Honor?
With the exhibit. Thank you. Does the plaintiff have any additional evidence?
The plaintiff rests, Your Honor.
Plaintiff rests. Defense?
Judge, we'd like to make a motion to dismiss, close of that evidence.
You may make your motion.
And Judge, I've written, got a couple of things that,
Is he planning to file this as part of the court file?
I haven't been given anything.
I will.
I'm entitled to 7 days to respond to the motion.
This is a motion at the close of evidence.
All right. You make your oral motion.
Judge, I'm going to hand you also for your edification. I marked it as Exhibit F, but it is this Logan case, and I'm going to refer to it in this motion.
Okay, this is not a case that was cited earlier.
It was, but I'm going to track through it, and just for the court's edification, I've got some things highlighted that I just want to point out to you. So it's just for the court's edification.
All right. The court's been handed a document that's entitled Motion to Dismiss.
If you're handing the highlighted case to the judge, I need a copy.
You got it.
Which is a 9-page, well, the signature of Mr. Baker, well, actually, it's not, it's electronically signed. So was this filed with the court then or not?
Not yet.
Okay.
Not yet.
All right. And plaintiff has a copy of this now?
Yes, it was just handed to me.
So, Judge, you've basically heard the complainant She's basically said this, that she has this subjective idea about what will harm her, and she's just added up all the contacts she's ever had with Mr. Irby. And then she's just tried to connect all that. I've handed you the Lowe case from Florida, and I've also cited a Kansas case, but in the Kansas Cindy case, the lower court was overturned, and the appellate court said, look, there was a legitimate reason for the parent to contact the child, even though the other parent didn't like it. You're not going to find any cases, they're rare, where a public official tries to get a stalking order against media or something of that nature. It is just doesn't happen. The Lowe case is one of those rare cases, and that case was a state senator, and she asked for stalking, a ruling, and the lower court gave it to her. The Court of Appeals reversed it. And so I'm going to kind of highlight what it is that when they looked at that, you can read, it says that she's a public figure. And on page page 7, I've highlighted their statute is identical to Kansas.
Okay, now you're referring to
I'm referring to Exhibit
Florida case?
F, the Lowe case. So page 7. And I've highlighted, it says injunctions are not available to stop someone from uttering insults or falsehoods. Well, she wants this injunction to stop insults and falsehoods, even if, and she hadn't even proven falsehoods. Let me just say this. She claims that asking about a duck is defamation. It's ridiculous. A remedy is not available to prohibit defamatory or libelous statements. The reason for this is there's an adequate remedy at law, an action for damages. Merely foisting insults, as Respondent did in this case, is not defamation. Now, the only thing that she ever said, he said, which is out of that July 9th or 29th video, which he said, you're a bitch. Now, she's already behind the door, and you ask a good question, and just remember this, Judge. All these contacts, she says, put aside the emails, because that's almost, we'll get to that. But all these contacts that she says are there, they happened in the public. They're entitled to be there. They're the media. And when she says, oh, they yelled and screamed profanities, you've got the video. They weren't doing any of that. They didn't scream and yell at her going up the stairs. And so when she closed that door, he, of course, yes, I opened it. He did call her name. You know what? When she went into her office, they stopped. And the same way, when they went to the elevator, she had Joseph Love there, Deputy Love, and she was there, and she's telling him, hey, you can't record here. But when she went into that elevator and closed the door, they didn't follow her. They didn't do it. The idea that they did something to violate or intrude upon her, the public, is just absurd. But even what she describes is, she says, well, my address is private. She's a public official. It's already out there. Her car's parked up there. I saw it. You saw it. Everybody sees it. It's public. They go into it. Page 7. Conduct that serves no legitimate purpose. Legitimate purpose is given not only comport with common sense, but must also comport with let me read this. Any lack of usefulness or utility. Now, she's not being, there's nothing here they're coming to your house or, all that. This is all official business. It's strictly official. Everything they did was emailing, coming to a public meeting, open meeting, all that. It's all something of public concern. The media would be very interested in a duck that ended up at her house that was, stolen, whatever. But the fact that police show up at the county prosecutor's office and they have to take this duck back, that's a matter of public concern.
Objection, that's misconstrued. Not my public office.
This is argument. I'm going to permit him to make his argument.
So and she's a chief law enforcement officer. So, and just to say, hey, I just want to know about the duck, I know it's embarrassing to her, but you can't manipulate the court system in a way that says, well, now that, you're embarrassing me. Conjunctions are not, on page 7, it says whether a communication is a legitimate purpose is construed broadly and will cover a wide variety of conduct. So as the media, which she says wants accountability, and they all are, they have an interest in what this prosecutor is doing. Let's talk about the other thing. They got charged. Somebody somewhere that Joseph Love said to them, hey, we're charging you out of that July 29th meeting. We're going to cite you for a misdemeanor. Now, put aside that, think about what happened in the Walker motion. She was wanting ex parte relief against people that you don't have any jurisdiction over. And she wanted them fined, prior restraint of speech. I mean, monumental things. I think that was totally frivolous. You don't have any personal jurisdiction over these individuals. So when they find out about that, of course they're going to talk. They're not just, interested in Miss Gillett's personal life. And then you come to the other charge where they say, we're going to charge you on this other thing. They're swinging a big bat here against them. And they're trying to shut down negative publicity.
All right, hold on a bit. You keep using a plural, they and them. And
okay, I say this, Jill Gillett. Jill Gillett. And when I say they, I'm talking about all the media, including Mr. Irving and Lawrence Accountability. So that all this is put all together. On page 8, while Respondent's presence may have made Petitioner uncomfortable, he was well within his rights to attend and express his opinion on the film subject matter. Mr. Irving was completely within his rights to attend these open meetings. And the one part where you saw where Ms. Gillett interrupted Mr. Irving, she's not a commissioner. She's running nothing in that meeting. She interrupted him. And so he said, hey, Jill, be quiet. Shoot. He was perfectly within his rights. He had already appeared before the commission prior to that, and he had an issue with the idea that you have to identify yourself to come to the court. That was one of the things there. That's in the early part of that meeting. Later in the meeting...
Which wasn't published. It's admitted, but just not played.
That's right.
Okay.
But you'll see he addresses that, right, and then as the meeting ends up, you see him back in the back with his camera. And then that's when she's making a presentation, and that's when he starts talking. She interrupts him. There's nothing wrong with that. And then when she comes out, of course, you saw that. And they said, hey, now that you're here, let's talk about the duck. Why are you lying about us about the charges? These are legitimate reasons. They're not asking about her husband or anything like that, nothing personal. It has to do with all the things that affected them. And that's legitimate, Judge. he made no threats. No threats. None. Now, her idea that he threatened her from these emails is ludicrous. And it is an objective point of view. She actually contends that those emails would cause a reasonable person substantial emotional distress. Nothing. A call request, 2 call requests. He emailed all the officials. You know, if he was trying to be stealth or secretive, he wouldn't have done that. And done it with, he CC'd everybody. He CC'd state representatives. And so here she is, she says, well, I don't like the fact that he said he's going to follow my career. Well, she's got a professional career. She's a public official. Yeah, I'll follow you. You're not entitled to that kind of privacy. She said in her motion, you've got to have thick skin. Well, she doesn't have thick skin. And if she doesn't want to be a public official, if she doesn't want to be that, get out of the business. Now, if you read through this, it's an objective, reasonable person standard, and this idea that you've got a public official in the media and they're contacting, that simply blows all of this out of the water. She didn't even, to say that they can't ask her questions. And here's the other thing. She said, you know what, Dr. Spies did not violate the statute. Well, he was every bit alongside Mr. Irving all along. He was right there. He did everything he did. She said, well, the only thing that Mr. Irving did was that one time when he went out and I was walking to my car and Dr. Spies stayed there, but Mr. Irving, he went on ahead. He said that he crossed the line. There's nothing there. I mean, the woman is carrying a Glock right now. She has one in the chamber. All these contacts, they've got deputies here. At the elevator, Joseph Love was there. And she's saying she's petrified. And yet she says, I'm an EMT, I'm trained, I'm a law enforcement officer, I shoot, I do all these things. And yet she's this fragile. But it doesn't matter what her subjective beliefs are. The standard is objective. Think about this.
Mr. Baker, what do you see as the standard that the court has to apply at this juncture in the trial in regards to your motion to dismiss?
Preponderance of evidence. I mean, there is a preponderance of evidence. I mean, if that's what you're asking.
Well, in a criminal case, you know, at the end of the state's motion on a motion to dismiss, the evidence has to be considered in the light most favorable to the state.
And yes. And you can, even if you construe all the evidence you put in, none of it. You look at those emails, you can read those for yourself. They do not constitute anything that would put a reasonable person in apprehension of their physical safety. Impossible. And there's nothing in there that says they weren't for a legitimate purpose or that they would have caused substantial emotional distress. Nothing in there. So that fails. And then you saw the video, July 29th. He wasn't yelling. He wasn't even angry. You know, she says yelling and screaming. If you would have read her complaint without the videos, you thought we were in a different world. He wasn't yelling. He wasn't screaming. None of that. It all happened outside. And so she played that November 6th, and he said, well, they came up to the clerk's office. Okay, he has a right to go there and ask for records. Oh, but, you know. So there's nothing here, Judge. She doesn't even meet the elements that are necessary. There are no 2 course of conducts. Even though she listed 9 or 10, right out of the box, she said the first 2 emails don't do it, and you heard her talk about the others. So, you know, you've got public media, and you've got this standard that is a reasonable person, and Judge, there's no way she even alleged it, much less putting the evidence on. What she thinks is private about a duck and the police coming is not, that's public, a legitimate purpose. That's a public concern. And they had legitimate reasons, he did, for asking her, have I been charged? Why are you charging me? You asked for all this relief in the walker. What is that all about? And they went to the clerk, they went to everyone. She's a prosecutor, chief law enforcement officer. They have a right to ask him those things. Well, she said, she thinks that if she says no comment, that, boy, if you cross the line after that. That is not what public officials are entitled to. I mean, you see that all the time on TV. Mr. President, whoever, they ask questions, and they keep asking questions. Now, they don't follow into the helicopter, and neither did they follow into the office. You just saw, they gave her space when she said, God knew and all that. Okay, fine. But you don't see any lunging, you don't see any of that stuff. Nothing. Now, think about the relief that she's trying to get. A prior restraint on speech to the media, to him. Don't even come to the courthouse, because this is where I work. You can't even come into the courthouse. You can't attend the Walker trial. You can't do any of those things. Judge, this rogue case is right on. I hope you read it. I'm going to ask that you just dismiss this case. The evidence is not sufficient, so I ask that you dismiss it.
Okay. Well, in counsel, I'm going to give the plaintiff an opportunity to respond, but I just want to, at this juncture, how should the court interpret the evidence that's been heard? In the light most favorable to the plaintiff, because this is at the end of the plaintiff's case, or some other standard?
I don't know that you interpret it in the light most favorable to the plaintiff. I think you're the judge of credibility, and you've heard the testimony. It's evidentiary.
Okay. Well, I'll hear the plaintiff's motion at this time, or excuse me, response to the motion. But I'm cognizant, and I anticipated there'd be a motion. I wasn't anticipating a written motion, nor was I anticipating a case citation from another state that's now been provided. That wasn't provided earlier, so I will ask if the plaintiff wishes to make a response, and I'll go from there.
Your Honor, I believe when there's a written motion, the individual who the motion is towards has a full 7 days to respond to a written motion. I also was just handed a case from another state, and case law from another state is advisory but not mandatory. I did look up a lot of law that Kansas has, and I pulled up the case of State v. Smith, which is a case that involves a criminal conviction of a woman for violating a PFS. The conviction was reversed, and it has a lot to do with First Amendment, but it's only verbal speech. It has nothing to do with physical. Because when it comes to physical contact, there's a whole different ballgame. But that case does give some of the pertinent information on what is and isn't permissible, how Kansas looks at protections from stalking, and what the overall arching issues are. First off, this motion is factually inaccurate. His argument is factually inaccurate. That's not what the testimony shows. This isn't my neighbor's duck. I was not the one who found it. I was entrusted to care for it because that's what I do in my personal life. I actually have a rescue. I have multiple pens. A lot of drakes are eaten or killed or harmed because of issues with duck care. The ratio is 5 ducks to 1 drake. I know all of this. I actually have a bachelor pad for rescue drakes. I know that's a lot for the board and off topic.
Right now, I would like response in regards to their motion to terminate the case.
This is extremely factually inaccurate from what I can quickly skim. His argument is factually inaccurate. It's not my neighbor. It was a neighbor to the little boy who found the duck and brought it to another's home. And I was entrusted to care for it. I actually posted the missing post on Facebook that helped my law enforcement friends come and find the duck with me and return it to its rightful people. Because I'm friends with many, many law enforcement online, and I have represented officers, and I work with officers every day, both when I was a defense attorney and as a prosecutor. So some clarifying stuff was enacted in 2016 in the Protection from Stalking Act, and those laws kind of delineated what is protected speech and what is not. And a communication involving a judicial proceeding, an official proceeding, an official request, those can be made. And I absolutely agree those should be made. He talks a whole bunch about the Walker motion and the Walker trial. I specifically say in there that legitimate media concerns, processes, and everything should be honored. However, not legitimate things should not. That they should not be permitted to be live streaming onto their social media to get ratings and views. Robin Wonderlook is an example. She often sends a request to the chief judge way ahead of time and says, can I legitimately record for my own purposes to help me report on the case in the newspaper and to help me with my notes? And she may not even record all the proceedings, and he may limit her. And I brought that to the court's attention in there, that I am not asking to ban all media, but to have there be no live streaming or things of that nature.
All right. I'll ask you the same question I asked Mr. Baker. What should the test be at this stage of the trial in regards to, like as I indicated, I'm very familiar with the criminal case, the light most favorable to the state or to the plaintiff, on a motion to dismiss at this juncture, meaning at the end of the plaintiff's case. What do you feel the burden is on for that motion at this time?
Let me get past this. It's sufficient evidence. I don't know that it says one way or the other if you take it in light most favorable to the plaintiff, but it is a de novo review because this is a criminal case standard, and I don't believe there's like a civil. I read a lot of cases, and I couldn't find one that had a civil standard. This may be a case that would be the determining factor, and I think that is a very, very good question. I believe you would apply the civil rules, and I believe Mr. Spies is recording in the hallway through the window. And
Right.
I just turned it off.
All right, counsel, I'm going to take the defendant's motion to dismiss the case at this juncture under advisement. There's evidence that in the form of video that the entire video was admitted. However, only certain portions of it were published. Additionally, there's arguments here, and they may be valid arguments and so forth in that regard, but I want to take up the any evidence that the defense wishes to take up at this time, in their case in chief, it's 3:15. So I'll take it under advisement. And Mr. Baker, your first witness.
We'll call Dr. Justin Spies.
All right. I'm going to have some inquiries prior to you beginning.
Sure enough. And Judge, I may have to be down here. I guess I'll try. I got this video.
Stand there, please. What was that, sir?
Go ahead.
All right. Sir, if you'd raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You're under oath. If you'd have a seat. Please state your name.
Dr. Justin Spies.
Okay. Doctor is not your name. It's a
Title.
title that you've earned. Okay. What type of doctor?
I have a PhD in lifespan human development from Kansas State University.
Right. Were you present earlier when there was a motion for sequestration for witnesses to be outside of the courtroom?
Yes.
Did you hear my admonishment?
Of?
Things I told the witnesses that you couldn't do?
Yes, sir.
Have you complied with that?
As far as I know, yes.
Okay, now what do you mean by as far as you know?
Or is there something in particular that I...
Were it was indicated that you were standing right outside the door. At times, were you?
Standing outside the door?
Right outside the door.
In terms of... I was standing...
Please not be cute with this. Now,
I was standing outside in the hallway.
Were you listening to what was being said in the courtroom?
No.
Were you recording things that were happening in the courtroom?
No.
Very well. Mr. Baker, you may begin your examination.
Doc, I'm going to hand you what's been marked as Exhibit E. And would you describe Exhibit E?
It's a photo of myself and Michael Irvy with our YouTube channel names underneath our pictures of ourselves.
If you look, it's got several pages. So if you'll turn the page. So what's the next page?
Similar thing, a picture of me and Michael Irvy with Dreaded Accountability YouTube channel.
And turn the page. What is that one?
That's pictures of me and Michael along with the Elk County Commissioners, the Elk County Prosecutor, Gillett, the Elk County Sheriff, Walker, and a picture of a giant elk.
Okay, so would you consider you and Lawrence Accountability citizen journalists, cover various counties, Elk, Douglas?
I do.
Okay, and in that media coverage, do you go in and record public meetings, things of that nature?
Yes.
And as part of that coverage then, do you publish it on a YouTube channel?
Yes.
And that's something, how long have you done that?
Oh, I've been doing that for like a little under 2 years myself, yeah.
As far as Mr. Irvy, how long has he been doing media?
He's been doing that since, I think, January of 2020.
All right, and you've been involved in social issues in Lawrence, Kansas, the homeless encampments. You've publicized things about them, right?
Not the homeless encampments, but yeah, other things, along those lines. But
Mr. Irvy has.
Oh, he has, yes, he has.
Right. And so explain to the court then how you and Mr. Irvy got involved in this little town in this county called Elk County.
Originally, we saw how Robert Walker was arrested and how he was treated when he was arrested here at the courthouse for what looked like a violation of his rights. And as someone that's had that happen to myself, I became interested in it. And Through a YouTube video that I saw the footage of it, of him being attacked while he was handcuffed at the sheriff's department.
Okay. And then as you got more involved, did you and Mr. Irby come up here to Elk County?
We came up here, yeah.
And was there an issue also about the issue about having to identify yourself to even come in and do business in this building?
Yeah.
What was that issue?
Well, initially it was, the buzzer person asked the name and where we were from. And, we just didn't think that was right.
I'm going to object to relevance, Your Honor. None of this has to do with...
Okay, I've heard there's an objection, Mr. Baker.
Legitimate purpose. This is the reasons why they're coming, doing the things, covering media, all of those things.
I'll permit it.
So, and so then, with that, then were you at a meeting where Mr. Irby presented that issue to the commissioners, talking about having to identify yourself to come in?
Yes.
And was that July 29th, you recall?
Yes.
Huh? July 9th?
That we came up here?
Yeah.
We came up here July 9th, yes.
All right. And at that meeting, I think we've already seen that video in which after, and Ms. Gillett was there as the county prosecutor, you recall that?
I do, and just to clarify, July 9th wasn't a meeting. We came up here on July 9th.
Okay.
I believe. And the July 29th was a meeting that we attended.
Okay.
I believe that's right.
So there was the July 29th meeting.
Right.
Now, July 9th, was there some interaction with Ms. Gillett?
No.
Okay. So the July 29th, I think, was a video that we've shown the court in which Mr. Irby was addressing, do you recall Mr. Irby addressing the commission and Ms. Gillett interrupting him?
I do.
Describe that.
So Jill had gone down there and presented something along the lines of a finance that she wanted approved for a security camera. And when she was done presenting that, the commission opened the floor up for comment. And so Mr. Irby was commenting, and apparently Jill didn't like what he was saying, and so she interjected herself into that and told Michael, was basically telling me he couldn't talk. And that in itself is a disruption, because Jill she's not a part of the meeting. She's not a commissioner. She doesn't control the meeting. And so Michael, he said, you don't have what are you doing? You don't have the authority to do that. You're interrupting my time here.
Did Mr. Irby look angry or threatening to you?
No.
So, all right, so then did Mr. Irby finish his speech to the commission after?
More or less. More or less. Once you're interrupted, it's hard to, but more or less.
So now, describe then, I think the court has seen video, but Ms. Gillett leaves the commission building?
The room, yeah.
All right, and then you and Mr. Irby accompany her?
Yep.
Why would you do that?
Well, we had some questions because we had found out that there was a charge. We had found out from Joe Love that there was going to be a charge of interfering with public duties or something like that I think from the July 9th visit. And me and Michael were really confused about it because we had no idea what this would even be about. We hadn't done anything wrong. And we had gone around and we had asked the county clerk and I believe the sheriffs as well, Paul Dean, I think, as well, and we didn't get any answers. And so there was Jill, and so we wanted to know, are we being charged? And it seemed like it was just being hung over our heads as some kind of threat. And so that raises up, you have anxiety about that. You want to put that to rest. So we wanted to find out, are you charging us with something or not?
I think, so as you go up the steps, was anybody cursing her, threatening her, or anything like that?
Not that I recall. I know what I said to her was, is this stalking, Jill? Because in a previous time outside the elevator out there, she had, again, thrown that out there over our heads as some kind of charge she was going to levy against us. And I knew then that nothing we were doing rose to it. I knew that there was a high bar for that. So I was asking her on July 29th up to her office, is this stalking, Jill?
Okay.
Is us stalking you right now?
Okay.
And
You mentioned something about lying. Why are you lying? Did you say something about lying? Why are you lying about us?
I believe so.
All right, and so you went up the stairs in the hallway, and then what did you see next?
What I saw was, so I was behind Michael, who was behind Jill, and Jill opened the door outside her office, not her office door, but the hallway door, opened it, and went through the door, and as she was going through it, she pulled the door shut, which just doesn't make any sense because Michael was right behind him. There was no reason to pull that door shut other than to create some sort of obstacle.
Okay. And then what happened next?
So because Michael reached to grab the door to open it because he was going to go through it, it's a public space, Jill kept pulling it, and in that process, the door flung out between Michael and her pulling on the door like this. The door flung out, and it hit the wall outside there. And so immediately, my first reaction is I said, what a psycho bitch, because, she was just unhinged. That was ridiculous. And so it was entirely unnecessary, because that's a public space. There's no reason for her to be pulling that door closed unless she was just angry about something. And so we went down...
But let me finish up.
Hmm?
So you went through the door, and then where did Miss Gillett go?
She went into her office.
Okay, why didn't you go in there?
Because that's a restricted area. That's a restricted area.
So she closed the door, and that was it, right?
Yeah.
Did you pound on the door and, Jill, let us in?
No.
Okay.
No.
Okay, so then and then you went down, you said?
Yep, we felt it needed to be reported in some capacity, so we first went to the county clerk's office and reported it to the county clerk, Carrie Harrod. And then we felt that we needed to report it to law enforcement because, the charge that Jill and Joe were levying over our heads was disrupting interfering with public business. And they were trying to pin it on two other people as well for talking to somebody in public. So we said, if talking to somebody in public is interfering with business, then holding a door to get through a hallway to prevent somebody from doing public business is definitely interfering with public business. So we went and reported to Joe Love. He was still down on the first floor, so we went down to the first floor and we reported it to him. We showed him the footage. He straight up said, yeah, it looked like there was a crime committed there, and Joe committed a crime on Michael from preventing him to do his business. And so he took a report, and we raised concern that, well, who's this going to go to? Who's this charge go through? And he said, well, it's going to go through the county prosecutor, Jill Gillett. And we're like, well, that ain't right either. That's biased. And so he ended up telling us a little bit after that he was going to go ahead and contact the AG and have an independent investigator look at it to avoid that kind of stuff. But we reported it as a crime based on what they were trying to, their interpretation of that same statute definitely applied to what she was doing to Michael.
Well, let's talk about the allegation in the complaint is that when the door got slammed, that Joe Love came up the stairs.
No, we went down the stairs and found him still downstairs. Yeah, he never came up there.
Okay. Now, there was there, and we played the video, I think, and I guess I won't play that part. Was there another incident in which, was it September 9th, in which you were here at the courthouse and Ms. Gillett was here and you came outside?
The courthouse?
Courthouse, do you remember that?
Yeah.
Okay, so let's go back in time to what date do you think that was? Was it September?
Well, I believe that was I think that was July 29th.
That's July 29th.
I believe so. I think it was
Well,
still summertime.
describe then whatever date that was.
Well, when we went out, when we went outside the courthouse, we immediately saw, it was either one or two other county employees. I know it was one for sure because I know this guy had been filming us before, and he was standing out there filming us. So when we walked out there following Jill asking her questions, we saw that guy stand there filming us. So Jill kind of walked on, and we peeled off there to talk to that guy about him filming us, that public employee filming us. And as far as I was concerned, Jill walked off. I didn't even pay attention until she drove back by. We're outside the courthouse between the sheriff's department and the courthouse, a little driveway right there. And then she drove back by us. I thought she was maybe heading over to the sheriff's department. I didn't even know where she was going.
Okay, so let me, I'm going to show you a video of the, you described. Let's see here if I can get to it. This would be out of Exhibit B.
Defendant B,
Exhibit B, yes.
has that already been admitted?
Yes,
I believe it. Okay.
it's on that thumb drive, Judge. So I'm going to kind of start it, but do you recognize this as that July 29th meeting in which Mr. Irby is talking about the door?
I believe so. We've been to a few Elk County meetings, but I believe that's it.
Let me play it.
However, understanding his position, he's unable to see that. And,
Judge, I'm going to object. This video was not shown to me.
Stop the video, please. All right.
This video, I don't believe, was shown to me when we looked at videos on Monday.
Mr. Baker?
No, I think it was, Judge.
No, he skipped over some.
Okay, this is defendant B.
Yes.
There's a whole bunch of videos on this disc that he's called B. I don't remember this one being shown to me.
Well,
There was
it was.
videos of them chasing me up the stairs. There was the phone call with Joe Love. I don't remember seeing this one.
Judge, we got to live. I'm telling you, she's shown this. I don't know how she's prejudiced. The video speaks for itself.
Okay, this is the meeting of what date?
July 29th. And it's also going to show this incident in which she claims.
Yeah, it was not shown to me. As far as I knew, they didn't bring this video.
Can I finish?
Okay, please.
It's going to show the meeting and where they follow her up in the incident with the door, and then later, it's the same footage where they go outside and where she claims that Mr. Irby followed her out to her car and looked in her window and all that. That's the video. She's not, she was shown this, but Judge, I can authenticate it, and we've got a limited amount of time. She's going to run the clock out here, I think.
I'll permit it to be.
I am writing you this evening due to serious allegations made by the Elk County Attorney, Jill Gillett, during the July 18th pretrial hearing in the above referenced case. This is 2023 CR 00029, State v. Robert Walker Jr. In her attempt to disguise her own failures to disclose discovery information to the defense, but in also to leverage her office in a scheme of retaliation, Ms. Gillett chose to levy several accusations such as interference with judicial process, jury tampering, and harassing court staff and court officers. Ms. Gillett even took the unusual step of claiming a release of information by the defense attorney, another officer of the court. Now, your plaintiff did not articulate that I have a misdemeanor charge of interference with court process or public process. So I can make no charges of plagiarism. Deputy, what charges of plagiarism? You told me you had dated charges for allowed in the court of the defense attorney. Is that correct? Yes, I can.
to do was bring it up to the county attorney's office and try to find out some information on the sheriff's.
Charges, they need to actually give us a copy of that and let us know what we're being charged with. So, let me roll up my tripod just a little bit before we. But we're gonna have more county commission meeting here in just a little bit. If any of you guys are up county viewers, I'm sure you'll want to stick around. All right, what do we got here? Is this the courtroom? It's a hallway that looks on the other side. District Court. Oh, there's just.
Okay.
I'm gonna read that sign.
And let's see if I can, now, let's see.
There's two signs on that door.
Yeah, I was gonna say, maybe I could expand it, but I don't think
The
I.
sign says, please keep door closed for summer months. The air conditioner is on. Thank you. I've seen it 100 times and read it 100 times.
Yeah, okay, so those signs are there, all right. Go ahead.
Okay, let's see if I can get back. Now I've done something. Let's do.
On the other side. District Court.
Hey, how's it going? Good, thanks. Hey, I learned the other day from Deputy Love here that he was charging me with something, and I was just wondering what that would be and if I could get the charging document and any citation that would entail.
I wouldn't have it unless, check with the county attorney, see if they've heard anything in yet. That'd be the next door over.
County attorney. Okay, thank you.
You're welcome.
Oh, she's behind a buzzer.
Looks like it.
A ring doorbell even.
Hey,
Hey.
how's it going?
We've,
Okay. Question. I learned from, can you hear me?
Yes.
Okay, I didn't know. He made no reaction whatsoever. I learned from Deputy Love last week that he was charging me with some charge here, and I haven't gotten any paperwork, so I was wondering if I could get the charging documents or citation or whatever that would entail, please.
He told us it was submitted to you. I've been charged as well, apparently.
Yeah, both of us, we'd like to see.
He's told us a number of times that it's being submitted to the district attorney's office. We'd like to know what we're charged with.
Okay, I'll need your names.
Sure.
And
Yep, sure. My name is Justin Spies. Spies, yep.
S-P-I.
I can write it down if you'd like. Would that be?
Okay, one moment.
Okay.
All right,
And so
do you have any
are
way
you-
for me to contact you?
Are you an attorney? Oh, that's so.
We're gonna
No,
be.
I'm not the attorney, I'm just the.
What's your name?
Secretary, my name is Jennifer Stark.
Okay, Jennifer, we'll wait right here. We need to know this information. We've been told repeatedly, we've been charged by the sheriff's deputy, and he's told us repeatedly that he's brought it to this office specifically. So we need to know.
Right.
Just a quick search or something.
But if I mean, if it's not in the computer yet, then I don't have
Ma'am,
access to it.
ma'am, we're living under threat of arrest right now,
Well, that's-
day to day.
That's fine. Would you at least check?
Yeah, I'll check.
Is it something as simple as like you could do it right now, or do you need some time, or what?
Yeah, it'll take a few minutes to
That's fine.
check.
Yeah.
A few minutes is great.
Yeah,
That'd be
alright.
great. Yeah. Right here. Okay, you know, us, that politeness right there will get us charged.
Ms. Gillett, would you and Deputy Love care to comment on what we've been charged with?
There are no comments on any pending or ongoing investigations.
Is
You
there-
guys need to leave the courthouse, and you
That's
should
fine.
not be recording in the judicial areas.
Ma'am, we're
under
allowed to
judicial
record
orders.
here, and I'm sorry that you
We're
don't
not-
understand
we're
that.
not- we're wanting
You're not
to
willing
charge
to
you.
comment on our charges? They're not gonna comment on our charges. It sounds like,
They keep calling it an investigation.
yeah, so it sounds like we are being investigated, in fact. And the idea that we can be ejected from this area is a little insane. We're gonna wait for an answer, because if we've actually been charged with a crime, we're gonna find out today. And there's not gonna be an arrest made.
Well, is the relevance of this?
It shows that this is our first contact. They're up there.
Well, first contact with whom?
Miss Gillett. And it shows the legitimate purpose of why they're there in the first place.
Well, what I'm hearing now is somebody commenting off camera in regards to their beliefs of various things. Ms. Gillette's not there. I don't know if that's Mr. Irving or if it's somebody else.
It is Mr. Irving, and I can, is that Mr. Irving that's accompanying you?
Yes.
Okay. So this is the lead up. You're gonna go back into the meeting, I think, and then you'll see this is the complete run-up, and then you'll see this incident where she claims they went outside and did all this stuff. So that's where it's going. We've got another 10 minutes, I think.
You may proceed.
We're going to have to press up because we're not going to be levying unfounded charges against people.
Maybe I could speed this. Right, no, sorry.
The clerk's office on the day that we have the live. And that's just not possible, and we can obviously prove that that's not the case.
So, Ms. Gillett, we'd really like to know what
No
we've been
comment,
charged
I've
with.
told you no comment, do not harass or stalk.
Ma'am, I'm asking you questions. We've been apparently charged with a crime and nobody wants to tell us what we've been charged with. Why is that? I mean, Deputy Love says we've been charged with 22-15 or 21-5922.
Why are you lying about us in court? We don't have that medical stuff.
You
know
disclosed
it.
the medical records, not
You disclosed
us.
it yourself, Jill. We don't have it now, we didn't have it then, therefore we never disseminated it, but there you are lying about it right there in court. Is that allowed?
That's
Is that allowed,
a pretty
Jill?
serious
You
offense.
You guys
just
should
lie.
not be filming
Why
in a
not?
judicial
Oh,
area.
I thought it was the
There are
court.
rules
Isn't-
not to
yeah,
film
the
in
court-
judicial
Yeah,
areas.
this is a
We're not in court.
constitutional right
We're
that
like
you
right
guys
outside
down
the
here are gonna have
bathroom.
to understand.
I've told you I have no comment. If you don't stop
We
following
can
me, I
continue
will
to
charge
ask
you with
questions.
stalking.
You're gonna
We
charge
can
us with
continue to ask
stalking.
questions,
You're gonna
Jill.
charge us with
You lied
stalking.
about us in court. We'd like to know why.
Yeah.
There's
It's a
clear
legitimate
video
question.
evidence that we didn't disclose the records, that you were the one that in fact disclosed the records in open court.
And you lied right there.
And Deputy Love is claiming that we're charged,
You lied to the court.
but we
and
can't
you
produce
lied-
any charges.
You lied. You lied about us.
Deputy Love just asked
We
her
don't
if
lie about you, Jill.
Deputy
Why are you
Love,
lying
hey,
about us?
Deputy Love just asked her if she wanted us arrested, and she shook her head no.
But you guys have been charged with don't
Any further discussion or return to open session at 2:14? Motion carried.
That's good.
Don't need to comment. Don't make for long. I'm happy to let you go.
Let me hear. All right, so back into the meeting.
Me personally, I find it disrespectful.
Is that part of the First Amendment?
Well, we find it disrespectful to be charged and investigated when no crime has
I don't
occurred.
have anything to do with that. I'm just asking you.
Okay.
personally.
Jill Gillette and Deputy Love do, they're both right here, they could easily tell us whether we're charged or not.
Okay.
Do you want me to tell you how to talk?
But instead, they'd rather
What's that?
You want me to-
conspire to arrest
I'll
us
take
for
my
stalking. What?
Do you want me to tell you how to talk? What if
No, I
find-
didn't tell you, sir. I didn't tell you.
Okay.
I just asked you politely.
Do you want me to ask you politely to talk differently?
Sir,
Talk about
I'm not trying to.
talk about disrespect.
Sir, I have come, sir, I've been polite, I'm just trying, you know, I have respect for ladies and fellows, and I'm, that's just.
All I said is, would you want me to tell you?
Never heard of it.
Would you want me to ask?
If I'm talking out, if you think that I am being vulgar, if I am, yes, if you think so, you can ask me.
Right.
I didn't tell you.
You asked me
anything.
during the meeting, now you're asking me. Yeah, I don't understand why you're asking me.
Sir,
They don't teach manners in.
hey,
Well, I ain't gonna speak there, Joe, so thanks,
I just, that's just.
It would be better if you guys would consult Topeka before some of the things that you're doing, guys. Really.
John, that's an all call.
So that might let's see here. Are they doing an executive session? Is that what they're doing?
I believe so, yes.
Okay, hold on. You're asking the witness a question. You can't have both going at the same time. Go ahead and ask your question.
So we're looking at this now in the meeting, and now we see everyone leaving. Is it your understanding we're going to some sort of executive session?
That's right.
There's an interaction missing there where I told him not to interrupt the
Yeah,
meeting.
I object to that, Judge. She can't testify.
All right, go ahead and play. Is this backed up now?
No, I'm going forward.
It goes from here to here to here to here, so.
It's a bureaucracy, is that what you're saying? Okay.
So I don't have any access to any of that right now, so I can't tell you.
Okay, thank you. Appreciate it. Man.
Hey, guys. Hey. Were you the one that was helping us last, like on the 9th when we were down here? Yeah. We're trying to figure out what exactly we've been charged with. We were told that we were somehow harassing you guys. Okay. We were told that we were somehow harassing people here and we've been charged.
I don't know anything about charges. It was the phone calls that we were talking about, not the individuals here.
But Deputy Love has told us repeatedly that we've had a charge filed against us and that you guys had made statements regarding that.
We have not.
You haven't made any statements?
You guys haven't made any statements saying that we've done something wrong?
We were.
That's what we thought. That's what we thought. We were nice. Everyone was nice.
We were explaining about the phone calls.
Yeah. So this discussion with, who is this woman?
This is the county attorney, Carrie Harrod. I don't know.
No, she's not the county attorney.
Oh, I'm sorry, the county clerk, Carrie Harrod. That's right.
And so she's explaining in context.
Right. This video is of the elevator incident. The door will be on a separate incident, I believe. It's a separate thing.
Okay. All right.
And we appreciated the way you guys handled that.
We wasn't talking about the two gentlemen here.
Okay.
Okay.
So.
Great.
All right. That's
Thank you.
interesting. I think that
We
probably
figured everyone was friendly. Everyone was nice.
Yeah, have a good one. I think that pretty much clears it up, guys. What do you think?
Sheriff's Department, right?
Are we being charged or
Sheriff's
not?
Department.
Can you answer that question? Are we being charged or not? Do we have an answer whether we're actually being charged or not?
Session, and I don't make that. I'm not getting it. The only place that I know that you can go actually to the clerk's office upstairs.
There we go.
If something was filed, that's where.
Well, see, what we're finding out is it doesn't seem that anything was filed. This isn't just an idle threat from Deputy Love, which is definitely a 1983 violation, so we'll handle it appropriately.
Okay, back to session. Hopefully we can find out.
We were just referred up here, I guess, by Paul Dean, the county counselor. We need to find out if we're actually being charged or not. Joe Gillett says we're being investigated. Joe Love says he submitted charges to the DA's office. Nobody wants to take anybody's responsibility for it, and at this point, I'm really looking at this like it may be just a threat.
Okay, I can see, either you can look in our public access portal to see if anything's been filed, or I can look up you by name, if you wanna look it up, or if you want us to.
Well, is it gonna be the same? Do you have more info than what's gonna be here?
No,
Dang,
no,
I'd rather not mess with that computer, but.
Me neither.
you don't want to.
Yeah, if you wanna just look it up, we'll be happy to give you the names. You want them, here, I'll write them down. You guys have been really nice all day, thank you. It's IE, isn't it, Justin?
Yep.
IENS,
HS.
is that right?
HS.
That's an H, okay.
Yep, SPIEHS, yep. that's
Okay.
it.
ER,
AVI.
ERAVI.
Yep.
So, this making place, Judge, we've been going after this. I think my client needs to Take a bathroom
All right, it's the 3:50, let's start back up at 4 o'clock, please.
break. Thank you, Judge.
There are restrooms downstairs as well as up here. We're in recess. All right, we're back on the record from recess. The witness is on the stand. Both parties are all present. It appears that any sequestered witnesses are still outside, or at least not in the courtroom. Mr. Baker, you may continue.
I don't know. I mean, being told that you're charged by a police officer like that, isn't that some kind of a civil right violation? I would think. I would think it is. So, Jill? No charges listed, huh? So you're actually investigating this? Ma'am, are you saying that we're actually under investigation? Because your offices up here are saying that there's no charges filed. So what exactly are you investigating? Are you ever going to tell us if we're charged, or is this just a criminal trial that happens without any kind of oversight at all? You just rule it yourself?
No comment.
No comment.
Why'd you lie in court, Jill?
Yeah, you're the one that released the medical records in open court, Jill.
And then blamed us for it.
Do you often lie in court? Judging from what we're hearing, it does seem that that's the case. You want to share it with us? If I give you an upload link, would you share that with us? I'll put it in the video. Huh? Okay. So is Jill going to the sheriff's department? No. Looks like she's probably just going to leave.
District court lady came back and said that no, there's nothing in the system.
There's nothing in the system with our name on it, huh?
Did a search and there's nothing. Nope.
Nothing in the system.
So kind of narrowed it down and see what.
I don't know. It'd be interesting if it was.
We narrowed it down. Nope. It seems like it would be at the sheriff's department.
Man, is that Watts? Is that Watts? Is that the guy that was inside?
So I think.
Well, there goes Jill.
If there is a charge, then
She's not going to tell us what we're charged with, but only that she can't discuss an ongoing investigation.
Dr. Speeds, it was alleged that Mr. West, in this case, that Mr. Irving was not only yelled, but got in front of the car where she couldn't back out.
She said that?
Is that true?
Did he do that?
Did he do that?
No, I think the video speaks for itself. No.
In fact, he didn't even follow her out to the car, did he?
No, he didn't.
And is that video an accurate depiction of what happened at that time?
Yes.
Hold on, counsel. Is this depicting, who's narrating this?
Well, I can ask.
That's if you could, for the witness.
Yes. So who is, I hear two voices.
The narrator is Michael Irving, and that's also his footage.
Okay. Mm-hmm. And it's there with you.
And I'm right there.
Okay. So it's the two of you.
Right. And when I said earlier about the guy that was standing there filming us, you could see one of them when we came out. He was the guy that was standing there filming us.
All right. So when we back up, there's a car, and I don't see Mr. Irving there. Where is Mr. Irving at this time?
He's holding the camera.
Okay. All right. And then it comes off. So wherever this camera is, that's where Mr. Irving is.
That's right.
Okay.
Is that the guy that was inside?
So I think.
Now, anyway, Mr. Irving could have gone over there to that car, having the camera there, and blocked her from and looking in her window and all that.
No, not at all. If she said otherwise,
She did.
it doesn't check with reality. The reality is he's 50 feet away.
But only that she can't discuss an ongoing investigation. They do this to their citizens down here, thinking that it's some way to keep control of them, and we're going to end that practice, Jill. You're not going to be threatening arrest and threatening charges on people to gain compliance and to gain control over your citizens.
This dialogue all through, was there any point in there when you considered somebody yelling, screaming?
No, not at all. In fact, we're being nice and cordial given the fact that we're giving the runaround the entire time we're there of charges hanging over our head.
I got you. Okay.
For your citizens. Yeah.
All right. And then this, I want to do the, have you, we've seen this video, and I'm going to kind of get through it. But this is that meeting, July 29th meeting, July 9th meeting, right?
Okay, counsel, you're talking same time this video's going.
I'm sorry.
Please.
I'm sorry. This is September 9th, this video I'm showing you.
Yes, I believe so.
Okay. And this is a public meeting in which you and Mr. Irvie are attending.
Yes, this is the Elk County Commission meeting.
All right. And so let me get here. And then you've already described kind of what happened. Does this seem to pick where you testified where she interrupted Mr. Irvie?
Yes, that's right.
To come out of the diversion fund. Any further discussion?
Yes. Do you guys actually know what the diversion fund is used for?
I heard the commissioner say any further discussion.
Yes, that's right.
What did you think that indicated to you?
Any further discussion from people that are there attending the meeting to discuss the topic that Jill had just presented on?
All right. And then you hear Mr. Irvie, then...
Start talking.
No, I'm not asking Jill to shake her head. This is public comment. Get out of the way, Jill. Get out of the way. This is public comment.
Excuse me, this is our meeting and I am allowed to
I
stand here.
don't owe you
No,
any respect.
You're acting disrespectful.
Be quiet.
No more.
Be quiet. Nobody wants to hear from you. Now, what I want to know is, do you guys actually know
This is not a
what...
public comment, it's discussion for the
You don't
commissioners
run the
only.
meeting, Jill.
You don't
You have no
know-
authority here. Be
You don't
quiet.
understand Robert's rules.
Quiet, please.
Do you guys have any discussion?
$3,550 you're just going to spend without other public comment? You're just going to move ahead? Do you guys actually understand? He opened it to public comment and now you're just going to shut it down?
I have something I want to say as well.
You're just going to shut it down? So you're just going to let her spend money and let her do what she wants, and you're going to open public comment and just shut it down because Jill doesn't want to hear it.
You opened it for comment, and something I wanted to say as well.
Okay. I couldn't tell the commissioners were saying, were they adjourning the meeting or what were they doing?
No, I don't believe they were adjourning the meeting. I think they were just going back on their offer for discussion. We're just shutting down discussion, I believe.
And I see various people with their own phones recording.
That's right.
And so...
They already voted.
He opened it for comment out here.
They voted.
Do you guys have any other questions for?
I do. I'd like to know about that duck.
Thank you.
Did you kidnap a duck, Jill?
What was his question? Mr. Irvie's question, did you hear what he asked?
No, I didn't.
For comment out here.
They voted.
Do you guys have any other questions for?
I do. I'd like to know about that duck.
Thank you.
Did you kidnap a duck, Jill?
Kidnap a duck.
Yes.
What was the thing about the duck?
The thing about the duck is I don't know anything about the thing about the duck. Michael had mentioned the duck thing to me a couple of times, and I intentionally was like, I don't care about this crazy duck story, so I don't know anything about it. I know that he asked about it, and I know that it upset her, but I don't know any background until all this, until,
Were you interested in whether public officials had stolen property or stolen duck or something like that? I mean, was that something of a public concern to you?
It seems like it.
Counsel, why is that relevant to the proceedings for this case? What Dr. Spies, what interests him concerning ducks?
It's all over her complaint. She says you can't talk about the duck. It has no legitimate purpose. She is the one saying that. And so you've got a duck thing that he asked about. She says it's not only not legitimate, but it's defamation.
Oh, your client, the defendant, this is not the witness isn't that person.
Yes, all I'm saying is that you can these people are together. She said that he didn't violate anything. That Dr. Spies didn't violate anything. Well, if he didn't violate anything, neither did Mr. Irving. So here we go, and that's all I'm trying to show to you.
Please proceed.
I hear you kidnapped a duck and threw a fit inside your house when the police came to go back for the owner. Is that true?
Jill, is this stalking? Is this stalking? Did you know that the stalking statute says that it doesn't apply when you're conducting official business, especially within the public, which is what we're doing?
All right. I know that you do all the talking. Was Mr. Irving saying anything as you went up the stairs at that point?
Not on that set of stairs.
Okay.
Because you were trying to charge us with some bullshit charges, so we're just asking you about it, and you said, oh, I'm going to charge you with stalking now.
All right. Again, Mr. Irving is the one doing the talking. I mean, you're doing the talking, not Mr. Irving.
Yeah, I'm doing the talking. It's weird that she's saying that he was yelling at her.
You were there, was he yelling?
No, he wasn't even saying anything, let alone screaming anything. I mean, that sounds like a lie.
Okay. Now, let's back that up.
Okay, counsel, I don't want you going back and forth and playing the same thing again and again. If you're going to play it, play it.
I'm going to play it slower, Judge, if I could.
No, I want you to play it in real time.
Because you were trying to charge us with some bullshit charges, so we're just asking you about it, and you said, oh, I'm going to charge you with stalking now.
On your laws, don't hold the door on me. Don't hold the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want. She tried to pull the door closed on me.
What a psycho lady.
Can I stop this?
You're going to stop it? Yes.
So it's been characterized by Mr. Irving lunged at her. Did you see Mr. Irving lunge?
Nothing could be further from the truth.
Did you see Mr. Irving make physical contact with Ms. Gillett?
Not at all.
And did you hear Mr. Irving at all say anything, I'm going to get you, I'm going to hurt you, I'm going to, anything like that?
No.
Did you see anything that was of a threatening nature?
Not even close.
Okay. And then you heard him say the words, bitch. Is that right? Yep. Did you ever hear him? And you all have phones all the time, right?
Mm-hmm.
Did you ever, I'm going to use this word.
Wait, hold on. Please answer out in words. We're making recordings.
Okay.
Oh, thank you.
Apologize. Yes.
So I'm going to use a word. It's a bad word. But she says that Mr. Irving called her a cunt.
She said that he called her a cunt?
Yes.
That's a lie.
Okay. And you were with him during these times, right?
I'm with him during those times, and I also know that he specifically says he does not say that word.
Okay, and in fact, you videotape all this, right?
Right.
And but you tell this judge that none of the video we've seen here says he's ever called her a cunt.
I didn't hear him call her a cunt in the video or in person.
Okay, all right. I have no further questions.
Ms. Gillett?
Mr. ERAVI, or sorry, Mr. Spees, you were over,
It's Dr. Spees.
I haven't been.
Counsel, please don't interrupt.
I'm sorry.
Now, were you, do you do all of the comments online with him and his videos?
No.
And have you caused any physical contact with me?
I don't know what you mean by that.
Have you ever caused anything to be in contact with me physically?
No.
And are you usually behind Mr. ERAVI? Were you behind Mr. ERAVI in the elevator hallway?
Which question am I answering?
Were you behind Mr. ERAVI in the elevator hallway?
I don't believe so.
Now, was he closest to me?
No.
You think you were closest to me?
Yes. I was in the corner. The elevator was in front of me. Looking this way, I was in this corner. He was over here. You were over here.
Do you ever email me?
No.
Do you ever contact me outside of your videos and social media presence?
No.
Have you ever sent any direct messages to my work email?
No.
Have you sent any messages to my personal email?
No.
Do you contact me by cell phone?
No.
And why would you not contact me in any of those manners?
Say again?
Why would you not contact me by any of those manners?
Personal preference.
And do you know that personal contact is different than public contact?
What do you mean by personal contact?
Like, to directly contact me is different than what you do in your media presence.
Counsel, how is that relevant?
It's relevant because they say, why didn't I charge him? Or why didn't I ask for this on him?
Not the defendant.
Correct, but their argument is, why didn't I file on Mr. Spees and just Mr. ERAVI? These would be reasons why.
I don't think it's relevant to go through everybody that wasn't sued or anything as to why they did or didn't do something. So please, let's move on.
Now, let's talk a little bit about his questions about the discussion in the commission room. Have you studied commissions and how they work?
Object is irrelevant.
What do you...
Relevance, counsel?
It starts amping up because they think there's a public comment and there's not.
They? Still irrelevant.
Well, the video shows what happened.
Right. Are you aware that's not a public comment?
Hold on, I haven't ruled.
Okay.
I'm going to sustain the objection.
Okay. Are you aware there's not a public comment going on there?
No, I'm not aware of that.
Are you aware when a commissioner, the head commissioner chairman says, any discussion, it means between the commissioners only and not public?
Object is irrelevant. What happened in the commission meeting?
You gave them latitude.
I'm going to give some latitude with that.
You've got to answer it.
Were you aware that that's not for public comment?
No.
And isn't that what I said? That it's not public comment, it's just for commissioners?
No, you said this is our meeting.
And I was part of that meeting, wasn't I?
Yes.
And when the commissioners said open for discussion, they didn't mean public, did they?
No, in all fairness, we were a part of the meeting as well.
Okay. When the commission recognizes someone to speak, only that person is supposed to speak. Did you realize that?
Yes, I do realize that.
And do you realize that when other people start speaking and interrupting, it's interrupting the flow of public business?
Yes, I do.
And do you understand that I was telling Mr. ERAVI it wasn't his turn to speak?
I understand that you were interrupting the meeting by your own rule right there because you weren't supposed to be speaking.
And do you believe that him telling me to shut up and get out of the way was appropriate when it wasn't public discussion time?
Objection is irrelevant.
We've gone as far as this is going. I'm going to allow this. I've seen the video. This is not the defendant, so let's move on.
And you didn't characterize him yelling at me in the commission like that as yelling?
Not at all.
Do you believe that's a subjective term?
No.
And did you brag or Mr. ERAVI brag that your followers have harmed individuals?
Object is irrelevant.
It is relevant. They brag that they get their followers to hurt
You're
people.
gonna need more foundation for that.
Did you guys brag about that?
Not only,
Irrelevant.
It's relevant.
Okay, hold on. My ruling is there needs to be more foundation in regards to that to show if it's relevant or not. So you're gonna need to back up to establish, if things were done or not, if there needs to be some foundation.
Okay.
Not just repeat the same question.
Did you tell the officers involved with your interactions that the two of you are under investigation for for your followers harming people?
no,
Did Mr. ERAVI say that to one of the officers?
not that I'm aware of, because it's not true.
And have your followers, in fact, made threats towards me?
Object is irrelevant.
Council response?
And there's been arguments between their followers and them on social media.
Objection sustained.
Now, Mr. Spees, do you have any convictions?
Dr. Spees, please.
Do you have any convictions?
Yes.
And what is your conviction?
I have misdemeanor endangerment and misdemeanor child endangerment.
And were you aware I knew that?
I hadn't even thought about it.
And was that in a public setting as well,
What?
when you got the charges?
Was the charges at a public place?
Yes.
Judge, it's irrelevant. He's not the defendant, whether he's done something in public. I mean, he's admitted he's got the charges. Why? What is this relevant to?
It's relevant as to, I know that the two of them have amped up to try to harm people before or
That's lie.
after speech.
Stop. I'm hearing her. No more interruptions when I'm hearing this, okay?
It's relevant if I have knowledge of an actual conviction.
Well, he's indicated he has a
Right.
conviction.
And if
You're
it's
asking if it happened in public.
because they're saying
Why is the relevance?
because they're trying to say all of the events that happened with me are in public and it wouldn't have gotten out of hand when I know that he took a dowel rod after a child and their dad.
Objection is sustained. Next question, please.
All right. Are you aware if Mr. ERAVI has any convictions?
I don't believe he has any convictions.
No further questions.
Be direct.
No further. Thank you.
Hold on. Doctor, approximately how tall is the defendant?
I'd say he's probably like 6'2" or 6'3".
Thank you. You may step down. May this witness be released from the subpoena?
Yes.
All right. Doctor, you can either stay or go. Any exhibits, though, need to come back up here.
We'll call Mr. Irby.
Sir, if you come forward, please. Raise your hand, please. Right. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You're under oath.
Mr. Irby, you have Lawrence Accountability as a media YouTube kind of channel,
Yes, sir.
and you have used that channel to go across various counties, municipalities about social issues, public issues. correct?
Yes, sir.
And if I understand it, your interest in Elk County began with this courthouse and Robert Walker and how to get into the courthouse and all of that, right?
100%.
Right. And and then as you use your phone, you would use that then to publicize what you found. You'd give commentary, things of that nature, right?
Yeah, video record or live stream, either one, yes.
So do you consider yourself a citizen journalist?
Yes, sir.
All right. And did you ever have any personal interest in Gillett before, at any time?
I'd never been to Elk County myself. I didn't know anybody down here.
All right. And so would it be fair to say your interest was strictly in her as being a county prosecutor for Elk County?
I didn't even have an interest in her per se.
Okay.
My focus was that button. Okay. That's why we came here, was because we saw that button as a Fourth Amendment violation.
All right. And then you, I understand you got a call from Joe Love about some sort of misdemeanor charge.
The way that happened was there was a visit to the Sheriff's Department by a couple other local individuals, and during that visit, Joseph Love had told those two individuals that myself and Dr. Spies had also been charged with interfering with public duties or something of that nature.
And that would have been at what where?
I understood those charges to have originated from the July 9th visit to Elk County, and our interactions with the clerk's office is the way he put that. But that phone call, it wasn't that Joe called me out of the blue. When we found out from that recording, when we heard on that recording that we had supposedly been charged too, I immediately made a call to the sheriff's office and requested somebody to call me and tell me what I'd been charged with. And Joe Love returned that call.
All right. And that, we're not going to play it, but it was recorded, yes. And he said he knew it was recorded. Mm-hmm. All right. And
when you answer a question, please do it in words so we have the record.
All right. So let's go to your course of conduct. What were you trying to do when you came first up here in that initial July meeting? You were trying to find out about what? The charges?
Okay, to begin my involvement in Elk County, we need to step back to when I first saw the arrest of Robert Walker. Okay. And when I saw the interactions at the door and the button, the things that happened there, and the way he was attacked while being handcuffed. That was extremely disturbing to me. I immediately started looking into that and trying to find out a little bit more about what had happened. Once I had watched the videos and reviewed what I could review as far as what had happened, I drafted an email to the county counselor. I had never met her, but I drafted an email and suggested that this is a bad case. And I think I titled the email suggested dismissal or something like that. But I suggested that she dismiss this case in the interest of justice and laid out some of those reasonings.
Okay. And in fact, there's a 1983 civil rights action that was filed by Mr. Walker about that against Watts and the other.
Objection relevance.
Counsel?
Public concern, it goes to his legitimate purpose. This is all newsworthy.
I've been told, Mr.
Hold on. That wasn't the question. You asked about if there was a 1983 civil rights. Why is that relevant?
Because that is a public document that has public implications. I can move on, Judge. I'll withdraw the question.
Question's withdrawn.
All right. So then you're up here. You've done other activists with the homeless in Lawrence, correct? And you've done other things in other municipalities. You've attended public meetings in Lawrence, Kansas, correct?
Yes, sir.
In Douglas County?
Yes, sir.
You've done that all throughout Kansas, haven't you?
I wouldn't say all throughout Kansas. I've gone to Douglas County, Johnson County, Jackson County, Elk County, and either Anderson or Miami. It's been a while.
All right. So this appearing in front of this board, it was not just another day at the office for you then, maybe?
Yeah, it's what I do.
All right, and then we've seen these videos, but one of the things that you've heard is that you can't have, in order for you to be stalking, there cannot be any legitimate purpose in anything that you've done. You understand that, right? So tell the court, I mean, we've talked about the legitimate purpose and protected activity, but tell the court exactly what you're trying to do when you were asking her questions and talking to the commission and doing what you were doing.
I'm trying to elicit information from public officials. I mean, it's quite that simple. When I'm told that I'm charged and that those charges have been submitted to the county attorney, my obvious next step is to contact the county attorney and say, hey, I'm being told I'm being charged. What am I being charged with? Somebody who tells me no comment, I still have questions. I don't care that you said no comment. I have questions, and I'm the person you're saying that's being charged. I need to be told what I'm being charged with and give me some documents.
Now, I heard the worst word that you said was, I'm going to say bitch, right? Mm-hmm. You said bitch.
Yes, I did.
Did you ever call her a cunt?
No, and that's a word that I don't use because my wife hates that word, and if she found out I'd used it, I'd be in trouble at home.
Okay. And again, if it had been, it would have been captured on some sort of video. Right?
We had video going the whole time we were here.
All right, and let's talk about the duck. You asked her about the duck. Why ask her about the duck?
Honestly, the duck, I thought it was kind of funny. I had been hearing stories from people. She has alleged a number of times that I've been in contact with people in Fredonia. I don't even know a police officer in Fredonia. People had, when they saw our live streams and saw us protesting the button, protesting some of the things that were happening here in the county that we noticed. And when we came here, our first goal was the button, but we started noticing other issues. So we started talking about those things. And naturally, what happens when we go to a rural area, and we've seen this in Jackson County as well, when we start publicizing things, people will start contacting us with stuff and just telling us stories. Somebody told me that there was something about a stolen duck in Fredonia that involved Jill. So I started asking about it.
Okay. So you asked her.
Mm-hmm. Exactly.
And in fact, from what you know, the police did come.
Everything that I have learned about the duck, quite honestly, has come from Ms. Gillett in these filings. I knew nothing about the story. I had people telling me that there was something about a duck, that police were sent to get it. That's all I knew. Every bit of knowledge that I have about the whole duck story now has come in her filings in here in the trial.
Well, you phrase it as a kidnapped duck. I mean, it's kind of a...
That's the way it was referred to me.
Okay. And so let's go to the other incident. I mean, we played the elevator. Mm-hmm. I noticed in all the interactions that when she went in the elevator, you didn't follow her in there, did you?
Nope.
And then when she went into her office, you didn't go there.
Nope.
And so let's talk about that incident in which she said you went out to her car, you blocked her, you looked in the window.
Nothing further from that. I mean, you saw the video, just like Dr. Justin said, that you can see in the video that I'm standing out here by the courthouse. I don't know the directions, but I'm standing closer to where that maintenance vehicle is parked, and you can see that 30 or 40 feet away is where she's pulling away with her car. Okay. So I had, when she said that earlier, I was blown away. I couldn't believe it.
Okay. No further questions.
Ms. Gillett?
I have a few. All right. So you're claiming you've never contacted any of the Fredonia police officers?
Nope. I have not reached out to Fredonia PD at all.
And you haven't reached out to anyone at the Wilson County Sheriff's Office?
No.
And you're trying to claim it was a public citizen that wouldn't have known about the duck that told you about it?
Sorry, say it one more time.
You claim it was just a citizen that wouldn't have known anything about that told you it?
There were several citizens here locally in Elk County that had told me that there was something about a duck that was stolen. I was told it was stolen or kidnapped.
Okay. Should you actually find out facts before you make statements?
Jill, I asked a question. I didn't make statements. I asked you if you had kidnapped a duck.
I asked the attorneys to be formal in regards to addressing witnesses. Do not respond to her.
Apologies.
Calling her by her first name.
Apologies.
As a
I've answered the
journalist,
question.
isn't it your duty to only report facts and truth?
As a journalist, I report information.
They should be truthful, shouldn't they?
I report information as I receive it, and I let the public make their decisions based on that information that is shown in video.
And are you aware what liable is by a journalist?
Say again?
Do you know what liable is by a journalist?
I don't have a liability as a journalist.
No, what a liable charge or suit is for a journalist who reports false facts.
I don't understand what a liable suit is.
All right, so you say all of this started with an entry issue with the courthouse, correct?
Yes, the button.
All right. Are you aware it's the least restrictive means compared to all the surrounding courthouses?
I have no knowledge of that.
Did you do any investigation to the neighboring counties and how they get access?
Judge, I think this is irrelevant about an investigation. What does that have to do with stalking?
Counsel?
They brought up the entry button and all of that stuff, so I'm just exploring it more.
I'll give some latitude because it was brought up on direct.
Do you realize I don't control that?
We've learned that it is apparently the sheriff department that controls that button and that it was put in place by a janitor with no ordinance. That's what we know
sir.
about it.
That wasn't the question.
Okay.
Please answer her question.
Okay.
Did you realize there was a county resolution for that button?
No, my understanding is there was not a county resolution.
This is right here is the only,
And this is from when?
this is 2010.
January 25th, 2010. J.P. Logan
Do you realize it was the chief judge of the judicial district that required that button?
reported that as a result of a threat to district court, security cameras with video reporting are being installed at 3 entrances. Card swipe entry and other visitors need to be buzzed in by the sheriff's department. All 3 officers were notified, all 3 commissioners were notified. So this doesn't look like there was any kind of directive. This just, who's J.P. Logan?
No, that's not the information that I was given by the county clerk.
It's in the minutes.
Who's J.P. Logan?
He was an old maintenance man that used to work
So
there,
then- So I'm
he did,
understanding that the maintenance man,
he,
Have you read the minutes for the
Say again?
county? Have you read the minutes for the county?
Carrie provided them to us. I have them on video.
Okay. Now, you say that those are your legitimate purposes for being here. Is yelling at me about a kidnapped duck a legitimate purpose?
I don't believe I yelled, Ms. Gillett. I asked you questions.
Well, I was going upstairs loudly.
Actually, during the time that you were going upstairs, I wasn't the one asking you questions.
And are you disputing that you grabbed the door out of my hand?
I would dispute that I grabbed the door out of your hand. What I did was I grabbed the door to try to open it.
Did you realize I was still shutting it? It wasn't even fully shut yet when you yanked it out of my hand?
No, what I would say there is that you were holding the door because when I tried to open it, there was resistance holding the door in place.
Wasn't I still pulling it shut?
No, the door was actually closed when I tried to open it.
I think the video speaks for itself. Did you notice that in your video I pull my hand back after the door comes out of it?
No.
So you didn't notice that in the video that I pull my wrist up because I'm in pain?
Ask and answer.
Sustained.
Now, did you think for 1 second that you'd actually hurt me?
I never made contact with you.
Now, didn't I tell you repeatedly no comment?
Yes.
Didn't I tell you to please stop following me?
Yes.
And do you realize I receive multiple threats per week from your followers?
Object is irrelevant.
I'm going to allow that.
I am aware of one threat.
Okay. Do you realize that I get them weekly or more than once a week?
No, I have no knowledge or anything to add to that.
Are you aware that they call us Nazi baby killers, cunt, bitch, whore, and other inappropriate words constantly every day?
Judge, it's
Sustained.
Now, I don't watch your videos. Are you aware of that?
You've said that in here.
So I never watched that video to confirm how far out you went. I'm going on my memory from
Can I
months ago.
She's testifying.
Yes, counsel asked the question. That's not a question.
Are you aware I'm only relying on my memory?
How do I answer that?
If you don't know the answer, you don't know.
I don't know how to answer that.
Okay. Now, do you think you should publicize inappropriate claims from other people without further investigation?
Ma'am, I'm a journalist. I publicize what I choose.
And could you see how your behavior could add up to me being afraid of you?
Not at all.
Do you realize that I'm much shorter than you?
Yeah, you're shorter than me. Yes.
But you weren't aware of my health condition, were you?
I don't know anything about you, Miss Gillett, sorry.
And you're not aware of any of my history or anything that has happened to me?
No.
And, have you had any accusations of violent issues?
Vague. Accusations of what?
You're going to need to be more specific, counsel.
Have you had any charges alleged against you for violence?
Well, Judge, that's going to be...
Overruled.
If it's knowledge that I have...
I overruled. You can answer the question.
I'm trying to think if I'll just go ahead and tell you, I have a trespassing charge from 2023 where I was protesting constitutionality at a homeless camp. I have a felony interference charge that currently has a lawsuit attached to it as well, a constitutional issue. I have been charged with disorderly conduct. I believe it was in 1996. And that was at a party at a lake. I don't even remember the circumstances of that. But as far as violence, I don't believe I've ever been alleged to have been violent with people.
Okay. Could you see how having disorderly conduct, criminal trespass, and felony interference comes across as being a violent person?
Object is irrelevant.
And I would wonder if she's looking into me.
Okay. Counsel, there hasn't been testimony concerning your knowledge in regards to that.
I know.
Well, the objection sustained.
Are you aware that when you followed me the first time, that I looked up if you had any public cases that would have public access?
No.
No further questions, Your Honor.
Redirect.
Sure. Mr. Harvey, she asked you about the button. Did you ever ask Ms. Gillett about the button at the...
No.
In fact, you weren't asking her anything about that button thing.
Not hers, it's the commission that we asked about the button.
And as far as you were asking her, it was simply about those charges.
Right.
And then you asked questions about a duck.
The only reason we were addressing Ms. Gillett was because we were told that we were being charged with a crime.
And as far as this idea that a public figure says no comment, does that mean media quits asking questions?
It means nothing to me. I'm going to still ask my questions because I demand my answers.
And if you allowed the public figures to stop questions or
I'd never get answers.
All right. And let's remember, you may be taller, but she's got a Glock with her.
That's right.
Today, right now, with a bullet in it. Did you know that?
I didn't.
All right. Would that have changed anything?
I'm going to have to think on that because it makes me very uncomfortable that she is carrying a gun in here right now with the way she's talked about me.
Yeah, well, anything else concerns you about that?
I mean, that's the concern, that I have somebody that's, seems to be persecuting me for things that she says that I did and making up things that I didn't do, at the same time that she's claiming that she's scared of me when she's carrying a gun. I'm a little uneasy.
No further questions.
Recross?
Do I have a constitutional right to protect myself?
Yes,
Do I have a constitutional right to protect others that are around me?
yes,
Do I have a constitutional right to protect the court officials in the courthouse?
right, yes.
And if I was even scared to do so, that I would be justified in defending myself or another, even if I had to pull my gun?
I can't claim.
Irrelevant and calls for speculation.
Sustained.
Well, they're asking about my gun, Judge.
I sustained the objection.
No further questions.
All right. Sir, you testified you are a citizen journalist. Is that a term of art?
The citizenry has the right to free press and right to communicate. We take that on, we take citizen journalists on as we are communicating information to the people, and we are using the modern outlets to do that. Citizen journalism.
Is there a particular definition of some sort that you follow?
There's, how do you define a constitutional right to journalists? I mean, that's a tough one for me.
Well, okay, well, I know what a journalist is. I know what a citizen is. Sometimes when there's words put together that means not what the two words together, or the two words mean. I'm just asking if there's some particular special meaning to the term citizen journalist.
In my mind, I guess I would say that the difference between a citizen journalist and what we would normally call a mainstream journalist is the citizen journalist is independent, does it on their own, not attached to big news. We're out there doing this from a view of a responsibility as a productive citizen to watch out for these things and spread this information that needs to be known by people.
So when you say big media, you're referring to traditional medias like TV and...
Yeah, like when you look at the news channel, KAKE and thing, we're citizens versus this class media.
All right. You also used the word that you're an activist. What was your definition of activist?
My activism role has mostly evolved around homeless issues. The role that I take with...
Hold on. I don't mean what the issues are. It's just what you mean by an activist in you, as you see yourself.
In activism, I believe that you're reinforcing a viewpoint that you have, and trying to, I guess, garner public support for that viewpoint in activism. That's what activism is. I try to draw light to issues and make people concerned about them. That's activism in trying to get people involved and do things about problems. Let's try to solve some of these problems, bring awareness.
Is there a crossover between a citizen journalist and an activist in your role, as you said?
I don't think they walk well together at the same time, but they do intersect from time to time. You can't be an activist and be a journalist at the same time all the time. An activist sometimes requires you to push the boundaries. Sometimes in pushing those boundaries, we're going to take risks. One of the risks that I've taken is, I spoke of the trespassing case that I have. We take risk by purposely going across a line that they say you can't cross. And when we take those risks, those are generally very well calculated and done with the idea of the law in mind. And we believe we have the law on our side to take that action. Now, again, I say I do that mostly in the homeless environment. Being an activist in a judicial environment is not going to work. I can't come in and force you to do anything. I can't come in and force her to do anything. I can try to influence her to do things, but I can't force her.
Counsel, any questions based upon my queries?
Yes. Activism, would you characterize it as something not about yourself?
Yes, 100%.
Okay. And are there, as a citizen journalist, and if you know, do courts recognize that phrase? Have you ever seen it used in other courts?
Myself, I'm not aware. I'm not familiar.
Okay. And there are citizen journalists out there that have blogs, they have special interest, and they're out there advocating certain specialties of the law, correct?
Yes, sir.
And it could be anything from guns rights to, free speech, or you name it.
Yes,
There's
sir.
little niches and all that across the board, right?
Yes, sir.
And so your purpose, again, going back to the legitimate purpose and protected activities, do you understand that you can use your speech as a protected activity?
100%.
Right. And in terms of being a journalist, asking questions, confronting the prosecutor about the duck that was stolen, you consider that protected activity.
Yes, sir.
And you consider that part of just asking questions.
Yes.
Right, okay. And no further questions.
Ms. Gillett?
So would you consider some of your activities here activist activities because of the button issue and trying to get rid of it?
When you say trying to get rid of it, we have tried to clarify where the legality of that button came from. We've asked questions. I don't know that I would consider myself an activist there more than a reporter. We've been asking a lot of questions about that button.
Are you aware there were threats to the district court in this very room as to why that button was put in?
Beyond the scope. What you asked.
Sustained.
So is some of your activity here activist activity?
Ask and answer, but...
The activity here has been...
Hold on, there's an objection. I haven't ruled yet. I'm going to sustain the objection. Next question.
Are you behaving as an activist when you're talking with me about certain things, especially about Mr. Walker?
Ask and answer.
No, that one I wasn't. You may answer that one.
The first thing I want to correct is that we've never talked. The only thing that's ever happened between us is that I've asked you questions.
And I've always said no comment.
Or other things.
Or I don't comment on ongoing investigations. Do you realize I have certain responsibilities to not comment on specific investigations?
I have no education about your responsibilities.
Do you understand it's my responsibility to protect the constitutional rights even of the defendant and that I do so in the courtroom?
Can you say that question one more time?
Do you realize it's my responsibility to even have to protect the constitutional rights of defendants even when they're giving them up in the courtroom?
I do 100% believe that is a responsibility that you do carry.
Do you realize I do that all the time
No, I
without
don't.
no one's knowledge?
No, I don't. I've seen the opposite.
Are you realize that some of my judges know I've done so and no one else does because I stop things?
Sustained.
So are you acting as an activist when you email me?
Ask and answer, Judge.
No, that one you can answer.
The suggested dismissals, you might be able to call that activism a bit.
No further questions, Your Honor.
Very briefly.
In terms of emails, could it also be journalism?
Definitely.
Okay. And as far as her constitutional Do you think she has some constitutional duty to not talk to the media about a...
Okay, counsel, didn't I sustain your objections on that area?
Oh, okay.
Okay, thank you.
Got me on that one.
Wasn't a guy?
I know. It kind of did bite me. All right. Boy, what was I going to ask you? No further questions.
Thank you. You may step down.
That's all the evidence we have, Judge.
Okay, is there any rebuttal evidence?
Just a little bit, Judge.
Who are you calling? Very well. You may take a stand. You are still under oath. You may make your, offer your evidence.
Judge, it's my recollection, I thought he came out further than he did in the video. I, again, do not watch the video, and I'm trying to go off memory from July.
Judge, this isn't rebuttal.
It is.
Well, I'll make the rulings, please.
Okay.
I'm going to overrule the objection, and she can testify in regards to the video, her perception.
Judge, and I'm going off my memory 100% because I do not watch their videos. People send me links all the time begging me to watch what they say about me. I don't. I don't care what's on their media. And there's reasons for it that I'll put in my argument later, but I really don't watch their videos, so I've never seen that video, and it was not showed to me Monday. My recollection was that he came out further than the video shows. I do remember having to wait to back up, and I think I waited for that truck, but I remember waiting and being apprehensive about driving by them. But I really do, in my mind, thought he came out further than he did. So
Does that conclude?
that's about all I have.
Cross?
Well, you did lie, though, didn't you?
No, I relied on my recollection, and that's it.
So if you just think you remembered it and it's not true, that's not a lie in your book.
No, it was very different in my mind.
Got it. And you had a long time to work on that complaint, right?
I did, but again, I don't watch videos. So
I know you don't. But you had your memory, right? And you were very specific. He not only stood behind you and blocked you, he went up and looked at that window. You said that specifically, didn't you?
I thought he did.
Yeah, but it never happened, did it?
I thought he did.
I know you did, but it never happened, did it?
I just thought he did.
Yeah. And you swore under oath that it did, didn't you?
My recollection was that he came out further and looked at my back window.
And then you said that Joe came up and the bang door, and that was not true, too.
I thought he did, but it's been a lot of months.
Yeah, no kidding. Okay, no further memories or questions.
Ms. Gillett, is the video that was played this afternoon, which I believe was Defendant's B, that was in the outside between the courthouse and the sheriff's office, is that the incident that you referred to in the petition?
It is, yes. Yeah.
Any other comment based
No,
on
none, Judge.
No.
Thank you. You may step down.
Thank you. Judge, do you want this exhibit that's up here?
Yes.
Judge, I have exhibit.
Any serve rebuttal?
No. No, Judge.
Okay. Now, I can't recall right now if I said this on the record or just with counsel. But my intent, and I believe I shared with counsel, if there was video that hadn't been published during the course of but was admitted, I would view in court. So has everything been viewed at this time?
There may be some video on this exhibit B that has been admitted that we haven't viewed in court.
Okay. Is the relevant portion to the video what has already been played?
Yes, yes, it would be from either Mr. Irvy's camera or Dr. Spee's camera. There is that recording from Deputy that we haven't played, but we've referred to it here that's on this, talking about they're going to get charged.
Okay.
So and I would just suggest that it substantiates credibility.
And Judge, there's a Supreme Court ruling that only what we watch here in court is allowed to be admissible to the court. And that's why the other day I was trying to put timestamps on it on Monday, because there's a Supreme Court ruling that you're limited to what we show you in the courtroom. If they want to play all those, I was going to object to the recording with the deputy. It's 100% irrelevant to my specifications of what's going on.
Okay, hold on. Counsel, in regards, okay, does the plaintiff have any video that they're wanting considered as evidence that hadn't been played?
No, and the only thing you have up there is what's been played.
Okay.
My videos are just what the sheriff brought.
Thank you. You've answered. Okay, Mr. Baker, if there's something you want me to consider, I want it played in the courtroom now. If there's not, then, it'll be just upon what we've played.
If you'll give me a minute just to check.
I don't think the first two got played.
Do what?
I don't think we played your first two or your last two.
Yeah, we did. Didn't we? But if you want us to, let's do this. Let's see. We played that, didn't we?
You've got the monitor turned on. What are you?
Well,
You threatened him to file charges on the call. Did he which were the crime?
let's do this. This is the call.
I'm going to object, Judge.
Okay, and when have I been charged with that?
Judge, I'm going to object. We don't have a witness.
What's the objection?
We don't have a witness on the stand to authenticate this. We don't have a current person to say it's an authentic recording. I know Mr. ERAVI is one of the people on it, and Joe loves the other one, but we don't have a witness to be putting in more evidence. It wasn't played so far up to the trial. If he's wanting to play it, he's going to have to move to admit it, and then we can make arguments as to relevance.
All right, Mr. Baker.
Judge, I can move to reopen the evidence. I can verify it through Mr. Irving. It's a conversation that he had with Deputy Love, and we've already heard the testimony about what he said in that conversation without objection. This would be the best evidence of the testimony you've already heard.
Okay, well, part of my concern is that the videos that you've played, it's gone from looks like two different individuals that's been spliced together, very thing, and not in a way that interferes with what's there, but there was what appeared to be the defendant's camera or phone, and then Dr. Spee's.
Well, there were, yes, I think you did see video from Mr. Irving's, and then you saw Dr. Spee's. So I don't think those two got intermingled at all.
No, not intermingled, but they were on one presentation, I guess. It wasn't a separate media or anything like that.
Well, no, they were separate. No, they're separate videos.
Okay.
So when I played those are separate files, when you see those in that USB.
Those are defendant B?
Yes, it's this USB that I've got.
Okay.
It has everything on it, Judge, so it's going to have the stuff not played and the stuff played.
Counsel, I think it'd be a lot cleaner if we, with what's been presented, because if what you're talking about is another view of what's already been seen.
Yeah, the only thing I would do is this recording, and you've already heard the evidence about it, testimony about what it is that was said. I guess you don't have to have it. I mean, nobody rebutted it. It's unrebutted, and it just says, hey, you're charged, and that, okay, let me go, and you heard him ask around. So, okay, so we'll just submit the Exhibit B with the videos that we've already shown you, and that'll be the closed evidence.
Okay. I do need to put some things on the record. There's a hallway outside of this courtroom, and I'm going to describe it. We've seen it on the videos. I work in this courthouse, have for many years. There's things that I see and I know are here that I don't know that there's a record per se. So I'm going to put on this second floor, there's a north stairwell and a south stairwell. And it comes up to a landing on both sides. There are double doors there. Those have had signs on there for years, indicating it was read into the record. I see it every day, but I couldn't tell you exactly. But basically, it says, please close the doors, and we keep these doors shut. And that's the doors that we're talking about in regards to where the plaintiff was on one side and the defendant was on the other. That would have been the south stairwell. I'm familiar with these doors and how easily they go back and forth. I wanted to put that on the record because I don't think I can divorce my consideration of the evidence without my own personal use. So I wanted that on the record. Anything else in regards to that? Or
Judge, I guess we reiterate the motion, or
in the closing argument, I'll hear the state,
Plaintiff.
the plaintiff, and then I'll hear the defense.
Judge, let me, if I can approach, I'll give you Exhibit E.
Is it marked?
Yeah.
Okay.
Yes.
Okay, thank you.
Judge, a couple of things. He's made a big deal over the fact that there are lots of other emails and stuff that came up in the beginning. The standard is a course of conduct, not the individual events that establish the fear. This is a course of conduct. It started months ago, and the conduct continued to ramp up until there was physical contact. I still believe he lunged towards that door. You can see him hurry across that landing and grab that door out of my hand as I'm shutting it. It did injure me, and if the video is watched, you can see that the point that the door comes out of my hand and it swings wide open, then I pull my arm up in pain, and you can see that in the video. I went ahead and took some time on my phone to log into my personal KBA account. Again, that's my personal account, to look up the preponderance of the evidence issues for the court issue you were asking earlier. I don't believe there's a light, most favorable finding made by any of the courts as far as how you view the evidence, that it is the legal and relevant evidence as a reasonable person might accept as being sufficient to support the conclusion. Conclusion of law is a standard review of unlimited when it gets to the court to review any conclusions of law. They mention 60-3106A
prove the allegation of abuse, and this is out of the PFA standards, which are adopted by the Protection from Stalking standards, and that's KSA 60-3106A. Prove the allegation of abuse, or in this case stalking, by a preponderance of the evidence, and the defendant shall have an opportunity to present evidence on the defendant's behalf. The two cases that I researched specifically are Barnett v. Barnett, which is 945 Pacific 2nd, 870, and Paida, P-A-I-D-A, versus Leach, L-E-A-C-H, 260 Can, 292. And that is 917 Pacific 2nd, 1342, decided in 1996. So I went ahead and looked that up. I don't think there's a light most favorable to either party. It is the allegations of abuse by the preponderance of the evidence more likely than not. There is no requirement beyond a reasonable doubt. In this case, there are several issues ramping up. His last email to me is not anything that has to do with an issue, but just purely an email out of spite at the end of that hearing. Again, I don't look at anything that's online, and I establish my issues and how I see this defendant on our interactions with his emails to me and the personal interactions that he has had with me. He admits that a good chunk of his activity is activist in nature. He and his attorney claims journalism, and he's going to argue that he is a journalist. They are not recognized by the Kansas Press Association or a member thereof. He is not.
Counsel, are they required to be journalists?
No.
Okay.
He is not a class media, as he admitted on the stand. He claims to be a citizen journalist. Well, that's some term that's been made up. And he admits that this is trying to influence me as the prosecutor. Targeting me as the prosecutor could be looked at as trying to influence me in my job. My job is already hard. I spend hours doing my job. Sometimes I am supposed to take the emotion out of my job, which I do almost every day. There's times where I have to try to take the emotion out. You know that in the court system, that's our job, to take emotion out of this.
Let me interrupt you for a moment.
Yes.
Now, you indicated that in regards to trying to influence your decision. Isn't that done in various forms that citizens do in regards to that? I mean, we're not talking about bribery. We're not talking about kidnapping a dear one and said, do this or else. These were emails and statements that were made in public places.
Yes.
Or emails that were sent to your address. How is that different than if somebody writes a letter to the editor and they, saying this decision should be made, or being critical of the prosecutor's decision?
So, Judge, I have had letters to the editor written on specific cases. People didn't have all of the facts. We have all the facts when we're prosecuting. In fact, there's a lot of times where the prosecutor has facts we can't give the court or we can't say to a jury. We're limited and barred so much. For instance, we're not even allowed to recite the criminal history of a defendant in a criminal case unless it's a conviction of dishonesty. They could be convicted of the same thing 6 times, and we can't tell a jury that.
But can't a citizen or a person do that? I mean,
he can put anything on his media presence he wants. If it's not targeted to me directly, as the Phelps case says, if it's not directly targeted to the prosecutor or to the person who is the intended victim, then we don't have a right to go out there and say, oh, they can't put it on their own page out there. That's why I don't look at his page. I don't care to. I don't want to give them another count on their views.
Let me stop you for a minute. We're talking, the issue has to do, constitutionally protected activity is not included within the meaning of course of conduct.
Correct.
And what I'm asking about is there a place where there's a line that crosses over in regards to it? There's certain things that we see and has happened in all jurisdictions where prosecutors are being criticized by either other citizens, the press themselves, and so forth. It's not always fair. It's not always accurate.
Nope.
But they're protected. Aren't those protected speeches?
The speech itself can be protected, especially his own on his own media, where he thinks he's being a journalist online or activist online. But
where does it cross the line?
It crosses
here.
It crosses the line here when he's addressing things that aren't part of my job. It crosses the line here when he starts having physical contact with me, with the door. It crosses the line when he is invading my personal space. When someone does something that is not in our personal space, that is different from crossing into our personal space. So, in this case, yanking the door out of my hand, getting within a couple of feet of me at the jury trial after he already has noticed this case is pending, coming up and the way I viewed it, he walks over towards these doors and then he dashes behind me and he comes within a foot of me. That scares me. It's a physical presence. They're crossing the line of, he's crossing the line of what he can do verbally when it turns into physically. And so I believe as a prosecutor, yes, we do have to put up with a lot of verbal abuse. And I have put up with a lot of verbal abuse over the years. But when it comes to our physical safety, that's when it crosses the line. When it comes to being, the activist activity turns into threatening us, threatening our careers, threatening everything. Now, he can go, they've made a complaint, and I answered it, and it was dismissed.
Hold on, just a minute. The part of the request in regards to the stalking is to have no contact, correct?
Correct.
All right. You are a public prosecutor. A lot of your business is conducted in a public courtroom and so forth. Where does that line, or should there be a line in regards to an individual being in court and watching court proceedings or commenting, particularly if it's on a website or a published article, there. I mean, we're not talking about an ex-husband and an ex-wife where they don't have to cross paths.
Correct.
So what is the relief there in the unique situation in regards to a prosecutor and the defendant in this case?
In State v. Smith, 57 Canap 2nd, 312, which is 452 Pacific 3rd, 382, the case says the most narrowly tailored relief. And so he's already been told if he's got a quorum request and he wants something, that the form is with Mr. Dean or the county clerk. They fill that out, they send it in, and County Councilor Dean will deal with their quorum request. There's no reason for him to have to contact me for a quorum request. He's already been told the way to do that. That's why those quorum request emails are in there, because he basically...
My question, though, is in regards to attending a trial. Because
if he's going to be present at a trial in a public courtroom, then he can be in the public courtroom. He has to follow the rules of the media, the presence in the public. But as far as coming up behind Normally, this is the plaintiff, and I know Mr. Baker didn't know that, and normally I sit at this table as the state. So if Mr. ERAVI wants to come watch a trial and he wants to be on this side of the room behind the defendant, I don't care. I'm going to have extra security for the Walker trial again, and I'm sure he wants to watch the Walker trial. But in the hallway, if I'm down here in the judge's chambers, because we've been meeting with the judge, he shouldn't be coming all the way down that hallway towards me. He can stay over here near the clerk's office window. He could have been there to look at the clerk's office. There was no reason to come on down the hallway and stand right behind me.
Please be specific then as to what what relief you're asking this court to give based upon, the statements that you just made.
Specifically, not sending any messages to me that are not a public type message. Like, he can make comments in the media all he wants. It's specific messages to me that are specific, not part of my job. 2, coming near me in the courtroom or being in this hallway next to me trying to come into my office. If he has a question about the case, it can be submitted without any comment to me about me or threatening towards me. A simple question. He doesn't need to be making specific comments or threats towards me. The other thing is, I am down a long hallway in Greenwood, and I know you're aware of the Greenwood Courthouse. So down that long hallway, there's nothing down there but the Kansas State Extension Office and my office. There's no reason to be down there. There's a secure stairwell for the prosecutor to get up and down from the courtroom. He doesn't need to be in that secure stairwell. There's no exit at the top if you don't have a key. So not being near my office in Greenwood, if he's up here at the clerk's office, to not be messing with me or my door, not following me, not coming close to me, so that my person is safer and feeling safer, that he's not going to run up behind me like he did at the Walker trial and stand 2 feet behind me. I've expressed I can't watch my back and do my job at the same time, which is why I've had security to help Sheriff Walker not have to put an extra person on me when we only have 4 deputies. This is not a county like Johnson County or Douglas County that has 20 prosecutors. We have 1, and that's me, and I have to hire someone to replace me for a jury trial. It's very expensive to do so, but we do it. So what I'm asking very specifically is, don't be banging on my office door. Don't approach me when I'm down here at the judge's chambers or if I'm outside my office. Don't approach me in the courtroom. If he's here for a public trial, he needs to stay over behind the defendant that's closest to the door. Not to be directly sending me messages. If there's something that has to do with a question about a case, they can submit a quarrel request. We can answer it. That's absolutely fine. Most of my cases are no public comment. We've had homicides, and I've had to draft public media releases. He can be added to that list if he asks. I'm more than happy to put him on the public media release list if that's what he wants. But for my personal safety, my house, my boyfriend's house, and my personal offices and vehicles. And I have more than 1 vehicle, as you know, but because I drive them here to the courthouse. But my vehicle's my parking spot. I would appreciate him not being near those areas. That is the most narrowly tailored things that I can ask for.
Anything else? Counsel, I'm going to give you a chance to hear. I need to take a brief recess to make a phone call. All right, we're back on the record. Counsel, I have given you some discussion in regards to time constraints. That phone call took care of that, so take your time. I don't want to keep you longer than you need to, but I'm not under a time constraint now. So thank you for your indulgence. Let the record reflect that the parties are still present and we're ready for closing of the defendant.
Well, Your Honor, Jill Gillett, from the beginning, has targeted Michael Irving. She did it in the Walker case based on pure speculation. She wanted breathtaking relief without personal jurisdiction over him. Wanted him fined and police escort and all of that. I mean, that was the most frivolous motion. No personal jurisdiction, but I want you, Judge, to find that guy, to excommunicate him from the courthouse.
Hold on, now that's a matter before Judge Rickey on the Walker.
All I'm saying is it's going to her credibility.
Okay.
So she was not successful. She said, well, in the Walker case, well, he sent those core requests, and he's been here, and they're giving me bad publicity. That's all this is about. And it didn't work. So what does she do? She's still got a little prosecutor hat on, and then she comes around here and says, well, I'll file a pro se motion. Now, let's talk about first things first. She perjured herself today. In no uncertain terms, she lied. She lied. She lied about the deputy coming up about the door. I mean, if you would have read that petition, you would have thought this guy was a maniac. All the things she said. Okay, well, let's get the videos out there. And the worst one, the most blatant lie, was that thing about going out to a car. Now, dadgum, she wasn't vague about that at all. No, he followed me out there while he blocked me, and he looked in my window. I mean, that's like a dream. You know, she says, well, I thought I remembered that. That is perjury. That is unethical. That was a flat lie. And you know what? If she lied about that and lied about the other, what else is she lying about? Now, let's get to the other parts. Judge, your task here, the standard is a reasonable, an objective standard. Continuity of purpose that would cause a reasonable person to suffer substantial emotional distress. Substantial emotional distress. Not inconvenience, not irritation, not irritation. Substantial emotional distress. Nothing you saw in any of those videos would have done that. Nothing in those emails remotely would have caused anyone substantial emotional distress. Oh, he talked about my duck. Oh, he asked questions about my duck. Are you kidding me? Asking questions is protected. I am really astounded. She had all kinds of time. She said she worked on that complaint since July and been saving it up. Saving it up. And she says, well, I listed all those events, 9 of them, and there's a reason she took them out of order. She didn't list them in chronological order in her petition. She started out with other stuff. But when you list in chronology, the first 2, she says, oh, those were events. Oh, no, they're not. They don't. Oh, okay, never mind. Never mind. There's nothing in any of those emails. Nothing. He wrote those to the commissioners about business, and he copied her, asking her about a debt that the police had to come and take from her. That is a matter of public concern. The community knew about it. The chief law enforcement officer of Elk County had her dadgum stolen duck. That's news. She can be questioned about it. And she says, how dare you? She says, well, can you imagine if this was the Kansas City Star and she's asking for the same relief? Because that's really what it is. There's no difference. The media today is different. People are getting their news from blogs, from YouTube, from Joe Rogan, to influencers. There's all kinds of journalism that's going on today that is not what we call the traditional journalism. And that's what's happening in these YouTubes. These fellows go out and they investigate, they report, they have an issue with the button out there. But then they had an issue and he went to the prosecutor. They had an issue about what she tried to do to him ex parte. You can't talk to a prosecutor about that? You're trying to get all that relief against me, Miss Gillett? Ex parte without due process? If you can't ask her about that, if that's not newsworthy, but think about the timing. Just think about that. All that wrapped up, July, September, and she says, no, I'll just keep it in my back pocket. I'm so terrified. I'm so, but I'm not doing anything about it. Oh no. What broke the camel's back was the Walker. The Walker motion in which she got chastised, sloppy, and then she got that count 1 dismissed, and these fellas publicized that. And that was embarrassing. That was the straw that broke the camel's back. And by golly, I'm going to pull the trigger. November 1st, I'm going to file. There's no reason. The timing is all there. You would have to find, out of all that, she acts like this as a PFA. It's not. You would have to find 2 separate acts that have no legitimate purpose. You can't do it. But not for any legitimate purpose. You would have to find that in those 2 separate acts, that each one would have caused a reasonable person. How about a reasonable person with a clock strapped to their chest with a bullet in it? Remember, she's got that. She talks about that incident where he dropped the phone. That guy was there and another officer was there and she's got a clock. No reasonable person going to be afraid. She's just irritated about the bad...
Hold on. I've seen officers testify many times in regards to, it doesn't matter that they've got body armor, that they've got weapons. If somebody is doing things, isn't it reasonable that a person can be afraid, even if they've got something else?
That's not the... Well, to be afraid, yeah, but that's not this standard. That's not this standard. Him dropping his phone wouldn't cause someone substantial emotional distress, right? You got to have that one. It wouldn't cause a reasonable person to fear for her safety. Now, you got a Glock on your chest and 2 police on either side of you. She says, well, they talked to me at that elevator. Well, there's old Joe Love right there between her and them. She got that Glock on her. And they're talking in a normal voice. You think that caused substantial emotional distress? No way. No way. Fear for her safety? No way. Now, seriously alarmed, I can keep going through the list. Seriously alarmed, annoyed, tormented, or terrorized. Guess what? If she doesn't want to be a public figure and to answer questions, she even complained about her residential address that is in the public record. Her car is parked out there. I saw it. It's all public. Now, nothing she has complained. All she's done is just gather up all the incidences that had happened, connected that, and she says, there it is. I was scared each time. I was scared each time. And that's not the standard. Now let's just talk about that. She's doing counseling. She has anxiety problems. She's not your normal, reasonable person.
Counsel, in the training, the CLEs that I've seen, attorneys and judges have a substantial amount of those sort of issues.
It may be. It's still the reasonable person standard. So all this talk about her being subjectively, all that's irrelevant. You have to look at it through the reasonable person standard. So the reasonable person who's not having anxiety problems or whatever, but a reasonable person not going to have substantial emotional distress because somebody dropped a phone next to him while two policemen have got a Glock there.
But doesn't the evidence reflect your client right outside of the door, her private office door, the one that's secured, not the double door, referring to her as a, quote, dumb bitch, unquote?
Yeah, he cussed her. And you'll see there is nothing. I encourage you to read the Loeb decision. Because that is, saying dumb bitch is protected activity. It's not a fire in the theater. I can cuss an officer all day long and it's protected. I can give you case law all day long. In fact, that Sampson case.
Well, is there a difference then between what something may be protected speech that you're allowed to do, but then what about the perception of the person that's being directed at?
Doesn't matter. Doesn't matter, Judge. The course of conduct is, and Loeb will tell you that, just because he was uncivil or he cursed her. Now, think about this. Dumb bitch. Okay, we all have heard that phrase.
How things are said makes a big difference.
All right, so even if he's angry, it doesn't count. It's subjective, and that's not the issue. You're going to read in Loeb, and they've gone through this constitutional analysis, and one of the reasons they've done that is you'll not find it in case law where a public official is seeking relief against the media. It just doesn't happen. So you get the rare case, which I've cited to you, and they've overturned the district court, and they said, look, you're restraining speech. You were dead on. The idea that she doesn't want anybody to ask her, don't ask me about a duck, well, that's not your personal life. You're a public official. So, and really, one word, calling her one word, that would cause her substantial emotion for a reasonable person. You can't say that. You can't. And the fact is, Judge, that you saw him, he was never yelling. Never. He was screaming coming up those stairs. A lie again. She lied every way. In fact, the only questions that were coming up those stairs was out of Dr. Spees. But see, in her mind, you just lump it all together. Lump it all together. Here's something. She says Dr. Spees did not violate the stalking right. He was right there with Mr. Irving. Well, he didn't violate anything, neither did he. So, she's got it out for him, no doubt. No doubt. She's done it, and you would have to find these elements, and you can't do it. You could not say he has no legitimate a reason for the statements he made to her, or that he asked her questions about a duck, which is a matter of public concern.
I think we've overdone the duck.
Oh, yes, I do too, and it was a subject of a long dissertation, but it keeps coming up. Judge, you cannot possibly say there were two events that meet each element that had no legitimate purpose and was not constitutionally protected. Cussing is constitutionally protected. He uttered no threats of harm to her. He never made physical contact with her. He never said anything of that nature. And in fact, when I asked the officers, hey, did you see him being threatened? No, didn't look threatening to me. You can't find it, Judge. It's not here. It's not here. And you're just going to have to deny, I'm going to ask that you deny this petition.
Okay. And we've got protected speech and constitutional things there. But does that mean that a person just gets to keep asking the same questions time after time after time?
Sure does. Sure does. That's what the press does. Mr. President, Mr. President, any public figure. That just goes with the, I know.
The president's got a bunch of folks to take care of him, too.
It's still a public figure, and there's no different species, as she thinks. There's not a public figure for purposes of Elk County versus Johnson County. If you're a public figure...
Hold on a minute. Hold on. Can't a public official say, I can't answer that question, or I don't want to, and then have it dropped? Why not?
Because the freedom of speech and freedom of press.
Counsel, wouldn't you agree that there are statutes that deal with what information can be released, particularly in regards to if there's a warrant for somebody?
No, I get that, but that's not this case.
Well, wasn't there tons of questions in regards to whether your client and the doctor had been charged?
It's still a legitimate purpose to ask. Now you say, well, she said stop it. It doesn't mean that it forfeits its protected activity. It's still protected speech. You think, well, don't quit asking. Well, he doesn't. It doesn't lose its protected value just because. The courts are specific. They say it's threats of harm, fire, all that. Just because I ask questions that you don't want to answer doesn't mean it's not protected speech. And if it irritates you...
Well, okay, so the question may not be, may be protected, but how far do we take this? Please, let me.
Sure.
If somebody's going and asking a public official things, they don't get the answer they like or want, maybe it can't be answered, for whatever reason. Does somebody, because of the constitutional right to the media, or however you want to phrase it, how far can they follow? How close can they get without, at some point there seems to be some merit in regards to where a person could reasonably be concerned for their safety.
You may be, yes, you're asking that question. This statute puts it differently. This says, that's not the question it's not that they said no, but my repeated question would cause you substantial emotional distress. That's where you're stuck with that. Would it put someone in reasonable physical harm? Those are two elements that you got to overlay. I get your other one, but that doesn't overcome those two, right? And I would suggest to you that media, just because they say, and you know what that would turn? Every core request that's denied into a possible stalking. I made a core request, and they said no, we'll make another one. Well, you're stalking us. I said no, and no means no, we can't give it. I would be lots of stalking crimes. You can ask. That is a protected, you can petition government, you can ask, I can ask the official, and if you say no comment, who knows, tomorrow you may want to make a comment, or you may change your mind. Who knows? But the idea that they would say, hey, why did you charge us? You want to know, I want to know. And she said, well, I'm going to tell you. You saw them make efforts. They're not here just busting her up. They went to the clerk, they went to the county commission, they went everywhere. She wasn't the target.
Okay, counsel, now what, we say there's a procedure and they go through it and the court signs off on a warrant. There's lots of people that may have access and that knowledge. You mentioned the clerk. sheriff's office dispatcher, prosecutor. All these different people know, but we're restricted in regards to what that information can be given out until that warrant is served.
Well, that may be, I don't know that. But the fact that but the thing is, even if it is, you say, well, I'm prohibited by law from telling you, and you say, well, once I tell you that, you better not ask me another question. Now
well, isn't there a time then where it crosses over into harassment? Because you mentioned a clerk.
I got it.
Okay, and so the clerk can say certain things and can't say certain things. So does that mean an individual that doesn't, that when she won't answer a question, that can follow her home, asking her that question all the while?
Let's think about that. When they said they didn't know, they didn't pester those gals. They said, we don't know. Thank you. Thanks. But the person that does know is sitting right here. I mean, they ask. But here's the thing. The statute requires far more than just being irritated. It has to cause substantial emotional distress. I mean, you're impinging upon free speech. And so they raise this barrier, substantial emotional distress. You've been in court. You've heard it. I had my feelings hurt, whatever. That's not even emotional distress. It's substantial emotional distress to a reasonable person. And then were you in fear of your physical safety? No. You don't get it here. Now, so I can't help you. This is what the legislature said would constitute stalking. And they measured free speech and legitimate purpose, constitutionally protected activity. And this is not a private citizen. This is a public figure. Overlay that. So we're not going to her. We didn't go to her house. We didn't go to Greenwood. We've not done all that. You see the purpose. It's there. You'd have to find there was no legitimate purpose. And to say that you can never ask when somebody says no comment? I mean, there is a reason that they got called and said, hey, we're charging you, buddy. You guys are poo-pooing in our lunchbox. And I don't like the publicity. Why did she wait all that time? Why? I told you why.
Here, let me ask you this. Is there a line in regards to the media and an advocate? Because I'm going to refer to your client's email from October the 30th.
Read the part.
Pardon?
I'm sorry, whatever.
And that's the one where it says, disrespectfully, Michael Gervais. That's how it ends. But that seems to me to be more of trying to be an advocate to get her to change a decision she's made, that she's entrusted to make as the prosecutor.
Still protected activity, Judge. He can say disrespectful. It's not unprotected speech. That's what you have to look at. What is protected and not protected? The realm of protected speech is I can be uncivil, I can be rude. I mean, this is what law goes through. It's a Hornbook law. I can be boorish. I can be rude. But that's still protected. And in fact, that's part of the political process.
So are there any bounds?
The bounds, well, in this case, the bounds are no legitimate purpose, can't be, it's unprotected, and then it has to be substantial emotional distress and put them in fear. That's the overlay. So we're kind of talking esoteric on the line, but that's the line. So you say there's a line, but this is the line. This is the line. And you're not going to be able to say he did two things that did all those, each one did all those things. Had no legitimate purpose. It may have been irritating to her. You may say, well, she didn't have to answer. She didn't have to answer. She said no comment. And by law, she wasn't required, but she could. She could comment. She's not prohibited. They can give documents on an ongoing investigation under CORA. They're not barred from that. They're not barred. They have discretion. She could have said, yeah, we're thinking about that. I mean,
But as a practical matter, I've never seen a prosecutor, when they're looking at an active investigation, where they're giving out the police reports.
All I'm saying is, they're not barred by law from doing it. They can have discretion. There's no law that says she couldn't say that. She's not, it's not a HIPAA violation or something like that. Okay, she's got the right. You don't have to, but that doesn't mean she's barred from doing it. They do it all the time. And, here's the other part we haven't really talked about, and it goes to credibility. She made a big deal about these security cameras. And this was how to get these guys. Because, boy, if you know about these security cameras, and that's what these fellows are up to. They want all this CORA requests. They want these security cameras. And then in this case, she gives us a security camera from Sheriff Walker, courtesy. Walker, she said you can't use them in a case. Walker should have objected if he thought it was a, closed case. But he didn't do it. Personal courtesy to the county prosecutor. So so you're still, Judge, stuck with the statute. All the questions you're asking are good, but they're not you have to overlay it here. Two events that did each one of those things that had no legitimate purpose, was not constitutional protected speech, and that it caused the person to be in fear for her safety, and that would cause a reasonable person to suffer substantial emotional distress. I urge you to read that Lowe decision, because it is a case that captures this same scenario that is rare. And read through that. And they use the same identical language. They go through the constitutional analysis. In the end, they say you can't, this is public. It's a different rule that applies when you've got a public figure and the media, and particularly a public figure. And think of the breathtaking relief, the restraint, a prior restraint of speech. That's what she wants. Now, Judge, I don't think there is remotely a case here, not under this guideline.
And this may be getting a little far afield, but I understand your argument in regards to, the press doesn't have to be necessarily accurate. They don't have to be fair. They don't have to, they can be an advocate. And if they're putting it on YouTube or printing it out, whatever, isn't it different then if that individual is within arm's reach of you?
No. Geraldo would never get any stories. That's,
that's the journalist that got those buttons.
Well, that may be, but I'm just saying journalists all the time, hey, do you have a comment? Here's a microphone, and they grab them as they're going into the courthouse. I just want you to think about the restraint. They didn't do anything other than just be out in this hallway. They did go outside, which they're allowed to do, but it wasn't like she said. And when she turned the corner and went to his car, he didn't go down there like she said. He gave her respect. When she went to the elevator, he didn't go. When she went in her office, he didn't go. She might have something to talk about if he tried to bust in the office, but he just out in the hallway, outside. That's protected activity, Judge. He has a right to associate, and he has a right to ask annoying questions that irritate her. She's embarrassed. She doesn't like the bad publicity. Walker, she couldn't get it done, so she recalibrates and she's over here doing it. So Judge,
Counsel, I can't help but to think about circumstances. I mean, if there's an attorney trying a case, and it doesn't have to be a criminal case, it could be a divorce case, and then, emotions get high. And particularly in small counties, we don't have a lot of space. We don't have a lot of public areas. We don't have a lot of areas where an attorney can kind of get away. Here, this courthouse is an excellent example. How do we maintain the peace in regards to those situations?
well, again, you're not talking about public figures, okay?
Well, could be.
We're talking in hypotheticals.
Wouldn't it, an attorney who does high publicity cases? Sues people?
Boy, I don't think you'd be well, I guess you could try it, but now we're into New York Sullivan, who's a public figure or not. She's already admitted it. She's a public figure. She's already admitted they're media. She admitted it on the stand. She admitted it in the Walker. So let's just take those two concepts. So the hypotheticals, you got to land on all fours with what you're dealing with. And if we can parlay this if that's Kansas City Star, and you're telling the Kansas City Star you can't ask that woman any more questions, and don't you dare, have an investigative reporter. I mean, you see him come up to the door. Hey, I heard, all that. So the legislature has weighed all that and put that here, and they put a high bar, a very high bar. It doesn't matter her sensibilities. It's a reasonable person. And it has to be a substantial emotional distress. And it has to put her in physical fear of her own safety. None of this does that for each event. It just doesn't. And the way she tried to clean that up, she said, well, I'm calm. And she was calm. You didn't see her look distressed at all. You see, no? She's not screaming, she's not doing it. She says, so everything you saw says, and she says she's trained EMT, she's law enforcement. I mean, she's dealt with this, she says, I've had it, I've got to have thick skin. So you don't see anything in those videos that says she's even distressed. And she's got the time, in fact, she's got the time to wag her finger and say, don't record me. No. And lied about who could record. You can't record me out here. And I said no comment. So she's talking to him. She's not huddled in fear with Joe. None of that. So you think, well, I just take her word. She's calm on the outside, but she's just, terrible on the inside. That's not what you saw. That's not what you saw. So if you would try to do a subjective, that's not what the video evidence is. Now, I think you have to look at credibility. I really do. And you're the judge of that. And you heard these men, Dr. Spies and Mr. Irving, come up. And everything they said was validated. The videos that we have, validated. Everything they said was true. Everything. So, I think you can do that as well. So, Judge, I'm going to ask you to deny this petition.
Thank you. I'll allow brief rebuttal.
Judge, I'll keep it really brief. He keeps pounding the log versus book case that he gave us. I would point you to page 8. The respondent made no threats nor any threatening gestures toward her. I want to repeat that. No threats nor any threatening gestures towards her. Number 1, yanking the door out of my hand caused me 3 days of pain. 2, the 10/30/24 email triggered me to want to finally file this case. He's inaccurate. I didn't start this in July. I started gathering up the emails in mid-August. I started drafting this around September. And I was putting things together because things were amping up with Mr. ERAVI, and I guess he goes by Dr. Spies, coming down here. There's no legitimate purpose in yanking the door out of my hand. The 10/30/24 email has no legitimate purpose. 3,
the threat to follow me for my whole career. I don't care what he puts in the media. I get good press and bad press. I'm on YouTube every day. People make comments, good and bad. I don't go look at them. People tell me about them, but I don't care. I don't follow it. I know who I am inside, and I know that I try to do my best in my job as a prosecutor, and it's a very, very, very difficult job. Mr. Baker has zealously advocated for his clients, but he's wholly inaccurate in a lot of things. They did not request for a case. There's a big difference between them and the Star. As I was taught in law school, and I hope Mr. Baker received the same education, there are different levels between national, state, and local representatives. I'm a local representative. I'm not a state representative. I'm not the Attorney General of Kansas. I work in two very small rural counties who can barely afford to have attorneys on their own. And so I work in two counties where there is next to no attorneys. We have two in my two counties that are actually active besides.
Counsel, I would ask this be, this is background. This isn't rebuttal to his arguments. So if you don't have anything further.
I have a couple more things. Number 4, he followed me outside. There's no legitimate purpose in that. And number 5, he came towards me at the judge's chambers. There is more than 2 events here. It is not each specific event that has to raise fear. The law says the course of conduct has to create the fear. Not one event, not this event. The course of conduct added up together creates the course of what causes fear. So when we go from beginning to end.
Counsel. Based upon one of the things you said, is why can't an individual go outside and ask questions? We see that all the time in regards to people that are a public official or just a public, somebody that's...
He'd already asked me inside the courthouse. There was no reason to follow me.
Well, is that even the test? There's no reason to?
I didn't feel like there was a reason for him to follow me outside. He asked me in the courthouse. I answered it. Should have ended there. There's no legitimate reason for yanking the door out of my hand. There's no legitimate reason to approach me at the judge's chambers. He's not coming down there to ask me a question. He's not coming down there to do anything that had to do with court business. There was no reason to come to the judge's chambers door where I came out. My sister just died. She was literally found dead at 7 o'clock in the morning or a little thereafter. I literally found out at 7:48 a.m. when I got out of my car.
Now, we're talking facts and not a rebuttal here on that, so...
Right, but there is not a legitimate purpose for those things. The email on 10:30 has no legitimate purpose. It has nothing to do with bad embarrassment. It has to do with him personally messaging me. Nothing but awful stuff. But the yanking the door out of my hand, the threat to follow me for my whole career, following me outside and coming towards me at the judge's chambers, I would say those do not serve a legitimate purpose. He believes he can cross the line as an activist and that it is a risk for him to do so. Coming towards me down here at the judge's chambers, there's no reason for him to do it. He already had this served on him, and he still did it. Yes, I was very upset that morning over my sister, but I stayed calm, kept my mind about me, but him dropping his phone right behind me when I've already been hurt by him absolutely causes fear and is the course of conduct, not the individual event. Mr. Baker is misstating the law. It is the course of conduct, and there are more than one purpose here. The door coming towards me at the judge's chambers are 2 of the most blatant ones. They are threats of gesture, him coming towards me with no legitimate purpose, and him yanking a door out of my hand. You cannot find a legitimate purpose for either of those.
All right. Counsel, I know it's been late. I would like to review these materials. I'll try not to take very long, but I'd like to get a decision tonight. And can you bear with me?
Thank you.
Yes. Gillett?
Yes, Your Honor.
Okay, we're going to be in recess. And we're back in the courtroom. The parties that appear as before. I want to make sure we have all the exhibits, everything first. So, in regards to the petitioner's case, I have 1, 2, one through 7, and 11 and 12.
Correct.
And the other numbers aren't there.
No, those were additional videos we didn't play.
Okay. So those are all present here. Those. In regards to defendant's exhibits, which have the yellow sticker, actually I have 2 sets here on the document. So I'll return 1 set to counsel. And it goes A through E.
Correct.
F is a case out of Florida. I'm not going to accept that as an exhibit. That was, as I understood it, just a demonstrative, or excuse me, a copy for the court to review. Counsel had that as well. And then there is G, which is also a case, so it's not it's not admitted. That is a Kansas Court of Appeals decision, which is a 1977. That's the Sampson case. Sampson versus Sanborn. All right. Is there anything that I've overlooked in regards to exhibits that you need to address?
I don't have anything in regards to exhibits. I do have one comment regarding the case that he brought in because I took the time to read it while you were reading items as well.
It's not. It's not something that, frankly, was helpful to the court in regards to making my decision.
I believe the case was miscited to the judge as to the court as to what it actually says.
We're going to hear
That was
No, we're like I said, that wasn't something that I found help or considered in my reaching my ruling. All right. All right. The petitioner requests finding of stalking under the protection from stalking statute, which is generally under KSA 60-31 A01 subsection B at SEEK. And for the purposes of this hearing, there's no allegations of sexual assault. There's no allegations of human trafficking, so I'm not going to go through those and addressing them. But the evidence has to be considered by a preponderance of the evidence. In regards to the defendant's motion to dismiss at the conclusion of the plaintiff's evidence, that is denied. That has the effect of basically, I'm considering all of the evidence that was submitted by the defense as well as the plaintiff. So we've gone through the exhibits. All right. Stalking is defined through this statute: an intentional harassment of another person that places the other person in reasonable fear for their safety. Harassment means a knowing and intentional course of conduct directed at a specific person that seriously alarms, annoys, torments, or terrorizes a person, and that serves no legitimate purpose. All right. So it does call for a course of conduct, which is defined as conduct consisting of 2 or more separate acts over a period of time, however short, evidencing a continuity of purpose which would cause a reasonable person to suffer substantial emotional distress. Constitutionally protected activity is not included within the meaning of, quote, course of conduct, unquote. In reviewing this, I'm going to go back to the petition. Go through that. And it does request for a description in regards to the events that they claim. These are marked as, in the petition as incident 1 through 9. Once I announce my decision, if there's any post-trial motions, then I'll take those up. But once we're adjourned, how I typically do this type of case, PFAs, is we permit we ask the defense to wait a bit. The plaintiff leaves, and then to give some space. Any objection with that?
No.
All right. I'm not going to go necessarily line by line with these. In regards to petition referred to as Incident 1 on July 29th, 2024, that refers to the defendant following the plaintiff to office to the commission meeting room and then to the car after. That was also, there was video that was introduced, described in doctors. Is it Spies or Spieth?
I think it's fees.
With an S? Okay, thank you. I viewed the video, and it does not contain the evidence that I feel, by preponderance of the evidence, necessary to find that incident occurred in regards to one of the course of conduct incidents. The defendant did follow the plaintiff outside. However, that video does not reflect him approaching the plaintiff outside nor her vehicle. Whether or not there's a reason to follow the plaintiff to her car or no reason to approach outside the courthouse does not bar an individual from doing so. There's issues, constitutional issues in regards to the freedom of the press and protected speech, but these are public areas. These are not an area where there would be any expectation of privacy. If it was an officer following out that same way, I wouldn't see a problem with it. I wouldn't see a problem with it in regards to a private investigator. It's not, sometimes there's perception. So there can be very, sometimes widely different views in regards to descriptions of an event. But I do not find that that was qualified as a harassment under the definition that would contribute to the course of conduct. Regards to incident 2, that would be the incident on September 9th, 2024. That dealt with the commission meeting and then the defendant asking questions about the duck. There was nothing in regards to the questioning that I found to be harassing, unpleasant perhaps, but not harassing and not that would qualify under a course of conduct. The description in regards to the door, and I tried to give a description for the record in regards to the doorway that we're talking about. And I'll go over that a little bit. But there are double doors at both ends of the corridor that at this courthouse. Those doors come open very easily. They can swing very easily and do. Additionally, there are signs that indicate those doors will be closed. It is not uncommon for individuals in the courthouse to be pulling that door shut as they walk through it. Nothing in, as I indicated before, some of these things I can't separate from my daily activities at the courthouse. It's just something we do. So there can be a different perception in regards to what's occurring there and what is characterized by the plaintiff and what's characterized by the defendant. I don't find that there was a yanking of the door out of the plaintiff's hand. I don't find that there was screaming profanities through that entire time. Certainly, there were statements that, in regards to the name calling, that I thought is inappropriate, rude, insulting, but I don't find that it wouldn't be constitutionally protected. So I don't find that the incident described as incident number 2 qualifies for a course of conduct. Number 3, it again discusses the issue in regards to the duck and the situation there. And it brings up points in regards to somebody investigating or looking into things. That's not something that a person is barred to do. People research other individuals all of the time. Private investigators, and there was no showing that there was something that was done that would have violated any criminal statute that I could see or find, such as criminal trespassing or being in somebody's home taking photographs, which we've seen in some stalking cases, things along those lines. So even if it's characterized as snooping around, asking about a personal life, again, I don't find that to be something that would be actionable or constitute harassment in regards to that. I can see how that comment, that question, would be concerning, not because of the duck itself in the matter. And part of these things, and I'll go through these with incident 4, is an email and the words, threaten. And there's been the use of the term threatening a lot here, not just by the plaintiff, but the defendant, individuals that apparently are in agreement with the defendant in regards to things. Characterizing whether somebody's investigating that, that people characterize it as a threat, that doesn't constitute a threat necessarily. So I don't find that incident 4 is with the indicates a threatening to pry into the career for the rest of someone's life. People can and do research individuals and follow persons' careers, not always in a kind way, but again, that doesn't mean it's not, that they're not allowed to do so. It is protected. Incident number 5, email from August 18th. Whether or not the defendant has an understanding of what it's like to be a county attorney, most people don't, unless they've done that or worked in the criminal justice system. But that's not, um, individuals, in regards, individuals keep trying to intervene in investigations in the cases constantly, and there's a balance to be had. There's people that request people to prosecute, not prosecuted, and times that's uncomfortable to tell people what the decision is, but that's something that somewhat comes with the territory. So I don't find that even exists as it now. The step number 9, then another email, didn't find anything that constitutes a threat or harassment under the course of conduct. Same with 6 and 7, and that is the emails of July 9th and July 3. Number 8, incident 8, the July 21st email. Again, I did not interpret the statements of the defendant to be a threat and things that could be legally said, whether or not they're appropriate in a broader sense or rude. Um, that's not the test that has to be met here. Incident number 9, which was the exhibit G. Well, no, let's see, it was the October 30th email. That seemed very apparent that Mr. or the defendant was really working as an advocate for Mr. Walker. And the defendant admitted as such up on the stand. I wish people wouldn't do that, frankly, particularly when they're not requested to. I don't know, but I don't find that it is harassment. Again, there were things there were said in there that could be viewed as offensive and probably deliberately so. But the defendant was trying to get the prosecutor to not prosecute Mr. Walker. County attorneys have a great deal of discretion in regards to the cases, and we try those to courts, we try those to juries. So I don't find that incident number 9 constitutes a harassment under course of conduct. Nor the following in the courthouse to the commission room and so forth. Again, things that I think could have been handled better, but that's not necessarily, that's certainly not the test. So those are the incidents that are referred to by the plaintiff. I do not find that 2 exist. Therefore, I do not find that the stalking should be granted. So I decline to do that. So the petition is denied. As I indicated earlier, there are times that their perception is not always the same. There's argument made in regards to lying and perjury. I didn't find that to be the case. While certainly the evidence didn't support the petition, as I've already noted, I've seen worse situations where things were perceived, and honestly so, that weren't accurate in my view. So the petition is denied. Are there any other rulings that need to be made in regards to the petition?
No, Your Honor.
No.
So I made my decision. Other issues concerning the courthouse, I think need to be dealt with by the chief judge in regards to our trial judge. In regards to that, I've not given this. I think people need to understand, and there was definitely misstatements of law made by the defendant and some of his colleagues. But I would hope that individuals would, try to follow the law, and I think counsel should discuss with the defendant perhaps KSA 21-5905. And there are incidents concerning judges and prosecutors in regards to conduct. Very well. So I would, we will be adjourned. I would ask that the plaintiff proceed out, that there be an escort for the plaintiff. Again, that is standard procedure. Is there other issues that we need?
Just one issue, Judge. The petitioner did subpoena documents from the sheriff. Usually when you subpoena, both sides get those documents. I didn't get them. And I'd like just instruction from you to say, whatever she got from the sheriff under that subpoena, that I'm entitled to receive those same.
Judge, you've already ruled that those are not being handed out, and I would ask that they not be.
And we're referring to the videos that were played, is that correct?
Well, yes, she subpoenaed. She's a private citizen. She's got possession of them. Now, I think if she gets possession of them, I also should get, it's a subpoenaed records. I don't know if she's going to appeal this. I don't know what's going to happen, but I believe that I'm entitled to whatever documents she received under subpoena. I should also get those, and I haven't been provided those, and I'd like those.
The only copy of the flash drive is in the court's hands. I do not have a copy of my own.
All of the records that Axon and everything that the sheriff produced for you, is that what you're representing to the court is in that thumb drive?
The extra videos we didn't play.
That's what I'm asking. So she's got other videos that she chose not to. That's why you've got a omission in those exhibit numbers. It's still, she's acknowledging she got more videos than what she put on that thumb drive. I just like what she got from the sheriff as a private citizen, that I also get those.
There's two flash drives I have, and that's it.
Hold on. To what purpose?
Well, I think I'm entitled to it under a subpoena. So when you subpoena records, both sides get them, whoever subpoenas. So the other part of it is, there may be an appeal, I don't know, but I think I'm still entitled to that. Judge, private citizen here has possession of all those records. And it cannot be fair that she can subpoena the sheriff and keep what she wants and give out the other. That's all I'm saying. It can't be, if she's got them, it can't be, confidential. She's a private citizen.
The two videos that I have left, Judge, are on flash drives that the sheriff brought to the hearing. I didn't see any of them ahead of time. I didn't make any other copies. If those two flash drives actually belong to the sheriff, the only reason I have them is in case we needed them. They can be returned to the sheriff. I don't need them.
I'm going to order that they be kept in the court file as the exhibits. We don't have any large type, and I've got no problem with counsel viewing those. I'm not going to order that they be disseminated unless it's for, authorized in a another lawsuit or an appeal of some sort.
Or maybe a quorum request.
Well,
And see how they'd be private if he gave them to a private.
I'm not going to rule on court.
No, I understand that. I'm just talking out loud.
May I approach your Honor?
All right, well, both counsel would approach. Okay, this is the stack. These are Mr. What's this?
These are the videos that I want you.
Those are the copies.
Okay, so you got the original.
These are there were two sets of copies.
Yeah, I get it.
So I think, and if you guys want to look at them, make sure I got them all numbered correctly, but I'm returning those two cases that are F and G. And here's the.
This is theirs, those are.
Well, I appreciate that you.
I'm going to put those in with this bagging that's been provided. And so all of the thumb drives will be kept together. For the record, 8 and 9 were not admitted or viewed by the court. Again, I've got no problem with counsel viewing them, but I'm not allowing them to be disseminated. Absent another court order.
Thank you for taking the time.
All right. So we've got the defendants. Here's the plaintiffs.
I have to pack up my office, so I am escorted to my office and they leave the premises.
Very well. So, there's an escort for there, and hopefully that won't ever be necessary, but, so Mr. Baker?
Yes, sir.
If you would have you and, we're well past the hour for, the courthouse to be closed. Deputy? If everybody just go out the same door is all I'd ask, so that we, north door. This building is something different right here.